Welcome to the West Virginia Legislature on the West Virginia Channel. I'm Beth Voorhees. Here's a look inside the House of Delegates, getting ready for a choral performance there. Up for passage. Among the bills up for passage on third reading today, Senate Bill 10, creating the Unborn Child Protection from Dismemberment Abortion Act. House Bill 4279, relating to disposition of seized firearms by the Division of Natural Resources. House Bill 4317, limiting factors in parenting plans and clarifying the court's consideration of fraudulent reports of domestic violence and child abuse in imposing limits on a parenting plan in order to protect a child from harm. House Bill 4324, authorizing information sharing by Workforce West Virginia. House Bill 4346, relating to bear hunting and offenses and penalties. House Bill 4352, relating to the selling of certain state-owned healthcare facilities by the Secretary of the Department of Health and Human Resources, requiring the Secretary to contract a consultant to submit a plan relating to the potential sale, renovation, or lease of such facilities to the Governor and to the Legislature by November 30th in regards to Hopemont Hospital, Jackie Withrow Hospital, John Manchin Senior Health Center, and Lakin Hospital. Also up for passage, House Bill 4505, allowing Powerball winners and other lottery winners to remain anonymous. And House Bill 4706, relating to county board regional meetings.
Yeah, and 4376.
The Senate hasn't activated their floor cameras yet. Up for debate and passage on third reading in the Senate today, Senate Bill 47, rewriting licensing requirements for the practice of medicine and surgery and podiatry to reformulate what constitutes the unauthorized practice of medicine. Senate Bill 287, creating the West Virginia Safer Workplaces Act, permitting employers to test employees and prospective employees for drugs and alcohol. Senate Bill 344, clarifying the composition and chairmanship of the Commission on Special Investigations. This commission conducts comprehensive and detailed investigations into the purchasing practices and procedures of the state. Also up for passage in the Senate, Senate Bill 399, establishing personal and corporate income tax credits for farmers donating edible agricultural products, relating to the creation of the Farm to Food Bank tax credit. Senate Bill 596, permitting natural gas companies enter upon real property in certain instances. Senate Bill 618, allowing Economic Development Authority to make loans to certain whitewater outfitters. Senate Bill 700, authorizing the Berkeley County Council own and operate a drug treatment or drug rehabilitation facility in Martinsburg. And House Bill 2852, relating to legalizing and regulating the sale and use of fireworks and dedicating certain fees to Veterans Facilities Support Fund, the Fire Protection Fund, and the State Road Fund. Those are some of the bills up for debate and passage on third reading in the Senate today.
One.
The House will be in order. All those not having privileges to the floor will please vacate the chamber. Members and guests will please rise. In lieu of prayer today, the Princeton Senior High School Madrigal Singers will perform Gloria. Thank you very much. That was tremendous. Members and guests will please remain standing as we are led in the Pledge of Allegiance by gentleman from 53rd, Elgin Smith.
Thank you, Mr. Speaker. If our members and guests would accompany me in reciting the pledge to our country. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Once again, we want to thank our honored guests for their performance today. We would ask Members may be seated. Reading of the journal.
Journal of the House of Delegates, Charleston, Saturday, February 27th, 2016.
Gentleman from the 52nd, Delegate Schaefer.
Mr. Speaker, I ask unanimous consent that the further reading of the journal be dispensed with and that it be approved as having been read.
Gentleman from 52nd, ask unanimous consent that further reading of the journal be dispensed with and it be approved as having been read. Is there objection? Chair hears none. Journal will be approved as having been read. Introduction of guests. The gentleman from the 17th, Delegate Rohrbach.
Mr. Speaker, in the gallery to my left, I'd like to introduce one of our Cabell County Republican women, Janina Michael. If she'd stand up and be recognized, and the House make her welcome.
Lady from the 18th, Delegate Sabonia.
Thank you, Mr. Speaker. In the South Gallery, if she would stand, I'd like for the House to welcome a Cabell County future law student who is shadowing me today. Her name is Kaden Gould. Thank you.
Gentleman from the 48th, Delegate Hamrick.
Thank you, Mr. Speaker. In the gallery up here, my mom is joining us today, and my uncle, Bob Davison, is also here. If the House would please make them welcome.
Gentleman from the 45th, Delegate Hamilton.
Thank you, Mr. Speaker. Today, paging from Buchanan Upshur Middle School, we have Abigail Loudon and Emma Loudon, and they are accompanied by their parents, Sabrina and Andrew Loudon. If they would please stand and the House make them welcome.
Gentleman from the 1st, Delegate McGeehan.
Thank you, Mr. Speaker. In the North Gallery, we have one of our current Hancock County Commissioners from the 1st District, Mr. Jeff Davis, and a former member of this body. So, on behalf of Delegates DeTeslo and myself, will the House please make him welcome? Stand up, Jeff.
Lady from the 51st, Delegate Fritsch.
Thank you, Mr. Speaker. Joining us today in the West Gallery, I believe, are some students, some Psalm students from St. Francis de Sales in Morgantown. They're escorted by Miss Nora Sheets, and the Psalm students are, if you could stand and be made welcome by the House, Sophia Garcia, Matt Bowling, Nick Ogershock, Grant Wilson, Juanita Garcia, Barrett Johnson, and Reynolds Wilson. Will the House please make them feel welcome?
Gentleman from the 53rd, Delegate Smith.
Thank you, Mr. Speaker. I have several announcements or introductions. On behalf of Delegate Schaefer and myself, we have paging for us today from Aurora Elementary, Jacob and Savannah Hauser, and they're accompanied by their mother and Father Joe and Stephanie Hauser, if they would stand. Also from Aurora, we have Isabel Cordero, and she's accompanied by Debbie and Dave Hibbs, and her sister Gisela. We also have Avery Adams from the Aurora School. She is accompanied by her mother, Elizabeth Adams, and her grandmother, Jeanette Adams. And also from the Aurora School, we have Natalie Stemple, and she is accompanied by her mother, Tina Stemple. And also in the gallery, we have Buck Jennings, who a good friend of mine who is running for my seat in the House of Delegates next year, and Dave Price, our county commissioner, and Buck's grandson, Blake. If they would all stand and members make them welcome.
Lady from the 46th, Delegate Smith.
Thank you, Mr. Speaker. Here today for Catholic Schools Day are sixth graders from St. Patrick's School in Weston. Pages, will you please stand when I call your name? First of all, in the back are two honorary doorkeepers. Will they step forward? Kristen Simmons and Eli Sprouse. Also in front, Brandon Queen, Peyton Amon, Emma Post, Sydney Amon, Kirsten Amon, Kristen Simmons, Kristen Detterman, Alex Romero, Jonna Clem, Christian Mullins, Jack Paul, Brianna Franklin. They are accompanied, and will these people please stand, by their teacher, Sherry Jackson, Principal Maureen Gilden, and by parents, Agnes Queen, President of the Lewis County Commission, Heather Mullins, Kenny and Amy Skinner, Nicole Amon, Wayne and Jennifer Amons, Jerome Post, Marissa Amon, Connie and Jim Sprouse, Allison Clem, Barb and Eric Paul, Laura Detterman, Spring Franklin, Shirley Schaefer. Will the House please make these people welcome and these angel pages welcome too?
Gentleman for the 19th, Doggett Hicks.
Thank you, Mr. Speaker. On behalf of the Wayne delegates, I would like to announce that we have a special page with us today. Her name is Madison Picklesheimer. Madison is a 5th grade student at Buffalo Elementary in Wayne County, and she's escorted by her mother, Jody, and her father, Danny. Would you please stand and House make them feel welcome?
Lady from 36, Doggett Guthrie.
Thank you, Mr. Speaker. And the South Gallery, if they would stand, I'd like to welcome today and have you welcome also the women who represent West Virginia Free, the organization that tries to protect a woman's right to reproductive care in the safest possible way. So would the House please make them welcome?
John from the 4th, Doggett Farrow.
Thank you, Mr. Speaker. With us today, from the Youth and Government Seminar from Marshall County, we have several people, and if they would stand when I call their names, we have Wesley Eskridge, Colton Coher, Zane Clutter, Ethan Pasquale, Abby Aston, Jordan Dotson, Justice Robinson, Mackenzie Hall, Emily Anderson, Americus Cooper, Creed Kidney, Julian Spielvogel, and they are accompanied by their teachers, Mike Eskridge, Geraldine Eskridge, Dan Gatz, and one of my former students, Jeff Stevens. Please make them welcome.
Further introductions. Gentleman from 35th, Doggett Nelson.
Oh, don't want to hear me talk today. Thank you, Mr. Speaker. Today we have with us Molly Ransdale, who is the director from the NCSL and our state liaison here for West Virginia. She was here this morning talking to staff and members, but they provide a wonderful service to all of us as well as our staff. But please join me in welcoming her to West Virginia. Thank you.
Further introductions. Gentleman from the 58th, Doug Coles.
Thank you, Mr. Speaker. I ask unanimous consent to briefly address the House.
Gentleman from the 58th, ask unanimous consent to briefly address the House. Is there objection? Chair hears none. Gentleman from the 58th.
Thank you, Mr. Speaker. Ladies and gentlemen, just an update on the action of the Rules Committee and the calendar. The Rules Committee met before session, and we've moved over from the House calendar to the special calendar on third reading, committee substitute for House Bill 4377. So 4377 is on the special calendar. Thank you, Mr. Speaker.
Reports of standing committees. Reports of select committees. Messages from the executive. Messages from the Senate.
The Clerk of the Senate announces the passage by the Senate of Committee Substitute for Senate Bill 116, increasing number of limited video lottery terminals allowed at retail location.
Message be received and the bill be referred to the Committee on the Judiciary, then to Finance.
The Senate has passed Committee Substitute for Senate Bill 411, creating Second Chance for Employment Act.
Message be received, the bill be referred to the Committee on Industry and Labor, and then to Judiciary.
The Senate has passed Committee Substitute for Senate Bill 421, terminating behavioral health severance and business privilege tax.
Message be received. Gentleman for the 58th.
Thank you, Mr. Speaker. Committee substitute for Senate Bill 421 is substantially similar to House Bill 4486, which is on the special calendar second reading. Therefore, Mr. Speaker, I ask unanimous consent that the committee reference be dispensed with, the bill be taken up for immediate consideration and read a first time.
The gentleman for 58th asks unanimous consent that committee substitute for Senate Bill 421 be taken up for immediate consideration and read a first time. Is there objection? Chair hears none. Clerk, please read the bill first time.
Committee Substitute for Senate Bill 421.
Bill be advanced.
The Senate has passed Senate Bill 455, allowing person to be both limited video lottery operator and retailer.
Message be received. The bill be referred to the Committee on the Judiciary and then to Finance.
The Senate has passed Senate Bill 461, updating West Virginia Workforce Investment Act to the West Virginia Workforce Innovation and Opportunity Act.
Message be received. The bill be referred to the Committee on Government Organization.
The Senate has passed Committee Substitute for Senate Bill 468, allowing lender charge and receive interest on rescindable loan during recession period.
Message be received. The bill be referred to the Committee on Banking and Insurance and then the Judiciary.
The Senate has passed Senate Bill Committee Substitute for Senate Bill 542, admissibility of certain evidence in civil action on use or non-use of safety belt.
Message be received. The bill be referred to the Committee on the Judiciary.
The Senate has passed Senate Bill 578, protecting utility workers from crimes against person.
Message be received. The bill be referred to the Committee on the Judiciary.
The Senate has passed Committee Substitute for Senate Bill 595, relating to retirement credit for members of West Virginia National Guard.
Message be received. The bill be referred to the Committee on Finance.
The Senate has passed Committee Substitute for Senate Bill 619, 2016 Regulatory Reform Act.
Message be received. The bill be referred to the Committee on the Judiciary.
The Senate has passed Senate Bill 627, permitting physician to decline prescribing controlled substance.
Message be received. The bill be referred to the Committee, Select Committee on Substance Abuse and Prevention and the Committee on the Judiciary.
The Senate has passed Committee Substitute for Senate Bill 634, creating William R. Laird IV Second Chance Driver's License Act.
Message be received and the bill be referred to the Committee on Roads and Transportation and then the Judiciary. Resolutions.
House Concurrent Resolution 95 by Delegate Moffett, Staff Sergeant Arthur N. McGowan Memorial Bridge.
Resolution be referred to the Committee on Roads and Transportation and then to Rules. Gentleman for the 58th.
Thank you, Mr. Speaker. I ask unanimous consent that further reading of resolutions introduced be dispensed with, and that each resolution be formally introduced and referred to the appropriate committee as listed on the Chamber Automation System.
Gentleman for the 58th asks unanimous consent that further reading of resolutions introduced be dispensed with, that each resolution be considered formally introduced and referred to the appropriate committees as indicated on the Chamber Automation System. Is there objection? Chair hears none. Each resolution will be so introduced and referred. Petitions. Motions.
Delegate Kelly moves to discharge House Bill 4280, permitting persons who are 21 years of age or older to operate or be a passenger on a motorcycle without a helmet from the Committee on Roads and Transportation.
Gentleman from the 58th.
Thank you, Mr. Speaker. I move the motion be tabled.
The gentleman from 58 moves the motion. Roll call has been demanded. Is demand sustained? Put your hands up, please. Demand is sustained. The question for the House is the motion by the gentleman from 58 that the motion be tabled. All those in favor will vote aye. Those opposed will vote no. The clerk prepare the machine. Has each member voted? If so, the clerk will close the machine and ascertain the result. On that question, 50 ayes, 48 nays, 2 members absent not voting. Majority of members present having voted in the affirmative, I declare the motion tabled. Bills introduced. Unfinished business. Bills on third reading.
Committee Substitute for Senate Bill 10, creating Unborn Child Protection from Dismemberment Abortion Act.
To the members, this bill was advanced to third with amendments pending. Are there amendments?
Delegates Guthrie and Pushkin move to amend the bill. This is HFA Guthrie et al. 2-27.
The lady from 36, Delegate Guthrie, asks unanimous consent to explain the amendment in lieu of having read. Is there objection? Chair hears none. Before the House please be in order. Okay. Lady from 36.
Thank you, Mr. Speaker. Ladies and gentlemen, this is a fairly straightforward amendment, and all it does is restore some compassion and tolerance to the draconian bill that we have before us that is violating the way doctors practice medicine in their OBGYN practices to include rape and incest. Rape and incest. Rape and incest. Thank you, Mr. Speaker.
Other members desiring to speak to the adoption of the amendment. Gentleman from 38, Delegate Lang.
Thank you, Mr. Speaker. I would urge rejection of the lady's amendment. I certainly understand the intent that she's trying to get at, and think that it is currently covered under subsection D, paragraph 1. It specifically allows for abortion by any other method for any reason, including rape and incest. And if you read that in paramaterial with the medical condition that is within the reasonable medical judgment of a medical professional, so as to create or avoid death or serious or substantial irreversible physical impairment, I would suggest that the concern that the lady has already been covered within the language of the bill. For those reasons, I would ask for rejection of the lady's amendment.
Lady from 51st, Delegate Fleischhauer.
Thank you, Mr. Speaker. Will the gentleman yield?
Gentleman yield.
Do you not
Gentleman
recall
yields.
that the council in judiciary said that this was intended to bar medical termination of pregnancy in cases of incest and rape? That's what he said that sentence means.
Well, I think as I just explained, first of all, there are two. If a woman has been raped or is the victim of rape or incest, she and her doctor always may avail themselves of the exclusionary language under sub D or section D, sub 1. And then if it gets to the point where for some reason they determine that a dismemberment abortion is necessary to protect the life health of the mother, then I believe that language, because of the reasonable medical exception.
Well, that is not a reasonable medical exception if you read that more carefully. And it doesn't say anything in the bill about health of the mother. And it says you have to be...
is recognized to ask questions.
You're right, Mr. Speaker. If you read that more, I think you believe that those two sections can be read together. But wouldn't you concede that the medical emergency exception says it has to threaten one of your life's bodily function, like walking? And sometimes in the case of a rape or incest of a 13 or 14-year-old girl, the pregnancy is proceeding without medical complications.
Well, I think that if the members would read on page 2, lines 27 through 34, it certainly contemplates in the reasonable medical judgment, and then you can look at the definition of that up above, as to necessitate an abortion of a pregnancy to avert her death or to avert serious risk of substantial irreversible physical impairment of major bodily function, which is what you've just described, then this particular procedure is still available to a victim. I would suggest to the lady, of course I'm no OBGYN, but I would suggest to the lady that if a 13-year-old has been raped or molested and is the victim, that there probably are going to be substantial impairments to her bodily functions. And so that would fall squarely within the language on page 2.
Well, I understand that, but that's not what our council said. Mr. Speaker, at the appropriate time, I'd like to speak to the bill, or to this amendment.
Lady may proceed.
Thank you, Mr. Speaker. I support the lady's amendment. It's hard for me to understand how we would force a 13-year-old to have a baby when she's been raped by a family member. I read the front page of the Washington Post today, had a picture of a little girl who was raped by a UN peacekeeper, and she was nursing her baby, and she said, "When I'm alone with my baby, I see the rapist, and sometimes I'd like to kill my baby." Now that's obviously not a good response, but she's obviously not a grown-up. And I think that the lady from Kanawha is right, that we ought to have compassion for little girls that find themselves in this situation, and I don't think it fits within the definition of medical emergency, and that's what our council told us. So for that reason, I urge adoption of the lady's amendment, and I ask for the yeas and the nays.
Are there other members desiring to speak to the adoption of the amendment? Recognize the lady from 36 close debate. Lady from the 49th, Doggett Summers.
Thank you, Mr. Speaker, and I understand the delegate from the 51st concerns. This bill allows a person that's been raped or experienced incest to still have the D&E procedure. We are just asking in this bill that the baby be killed first instead of ripped limb by limb. So I think that the option is still available. I urge rejection.
Lady from 36 wish to close debate. If not, the question for the House is the adoption of the amendment. Roll call has been demanded. Is the demand sustained? Demand is sustained. Those in favor of the lady's amendment will vote aye. Those opposed will vote no. The clerk prepare the machine. Has each member voted? If so, the clerk will close the machine and ascertain the result. On that question, 16 ayes, 82 nays, 2 members absent not voting. Less than the majority of members present having voted the affirmative, I declare the amendment rejected. Are there further amendments? The question for the House is the passage of the bill being engrossed and advanced to third reading. The question for the House is the passage of the bill. The gentleman from 38, Doggett Lane, to explain the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, Senate Bill 10 seeks to prohibit the practice of dismemberment abortion. The term dismemberment abortion means with the purpose of causing the death of an unborn child, to purposefully dismember a living unborn child and then extract him or her one piece at a time from the uterus by use of clamps, grasping forceps, tongs, scissors, or similar instruments that through the convergence of 2 rigid levers slice, crush, or grasp a portion of the unborn child's body to cut or rip it off. A physician or other licensed medical practitioner may perform this type of abortion if he or she determines, based upon his or her reasonable medical judgment, that it is necessary to avert the death or avert serious risk of substantial or irreversible physical impairment of a major bodily function, not including psychological or emotional conditions. Physician or other licensed medical practitioner who performs a dismemberment abortion is subject to disciplinary action by the respective licensure board. A person who performs a dismemberment abortion who is not a medical professional is subject to the penalty for unlawful practice of medicine, which is guilty of a felony, and upon conviction thereof shall be fined not more than $10,000 or imprisoned in a state correctional facility for not less than 1 year. Mr. Speaker, I urge passage of the bill.
The clerk will read the bill a third time.
Committee substitute for Senate Bill 10.
Are there other members desiring to speak to the passage of the bill? Lady from 46, Doggett Smith.
Thank you, Mr. Speaker. I speak in favor of this bill. I wish to read to you Justice Thomas in Stenberg versus Carhart, a 2000 opinion of the U.S. Supreme Court. In the almost 30 years since Roe v. Wade, this court has never described the various methods of aborting a second and third trimester fetus. The most widely used method of abortion during this stage of pregnancy is so gruesome that it can be traumatic even for the physicians and medical staff who perform it. I will begin with a discussion of the methods of abortion available to women late in their pregnancies before addressing the statutory and constitutional questions involved. The primary form of abortion used at or after 16 weeks is known as dilation and evacuation, or D&E. When performed during that stage of pregnancy, the D&E procedures requires the physician to dilate the woman's cervix and then extract the fetus from her uterus with forceps. This little model of a fetal baby is 12 weeks, much smaller than we're talking about an abortion at 16 weeks. This is Peggy speaking, not Justice Thomas. It has a head, hands, fingers, arms, legs, all of its body functions are working. A baby grows much faster after this, so we're talking about a baby that is much larger than this. And again, Justice Thomas. The doctor grabs a fetal extremity, such as an arm or a leg, with forceps and pulls it through the cervix, tearing the fetal body parts from the fetal body by means of extraction. In other words, the physician will grab the fetal parts and basically tear off pieces of the fetus and pull them out. You grasp the fetal parts and you don't know what they are. And you just try to pull it down. Simply, that's all there is to it. The fetus will die from blood loss, either because the physician has separated the umbilical cord prior to beginning the procedure, or because the fetus loses blood as its limbs are removed. When all the fetus's limbs have been removed and only the head is left in utero, the physician will then collapse the skull and pull it through the cervical canal. At the end of the procedure, the physician is left, in the respondent's words, with a tray full of pieces. It used to be this, with a beating heart. All we have left is a heart that is not beating, all the parts in little pieces. I urge you to vote for this bill.
John for the fifth, Doug Pethel.
Thank you very much, Mr. Speaker. I know that this is a very emotional day and an emotional subject for all of us in this chamber. But you know, naturally, none of us know how long we're going to be here. And if this is the last opportunity that I have to speak against a bill like this, I'm certainly not going to pass on it. And I know that the people that named me a champion for choice would not want me to sit here today and not say anything. You know, as I said, the remarks I'm going to make, they are very personal. And you know, Mr. Speaker, I appreciate you giving us the latitude to speak on issues in this chamber and include our personal remarks. And you know, I've been here 24 years, and I can honestly tell you this year I've heard more members call for points of order than all the other years combined. And I agreed with some of those, and I disagreed with some of them, you know, on both sides of the aisle. So I certainly hope that that won't happen today. You know, I'm sure that most of you in this chamber don't know that for 21 years, I voted 100% pro-life. 100%. And I voted for the Women's Right to Know Act. I voted for the Unborn Victims of Violence Act. I voted for the Ultrasound Option Requirement Act. But you know, after 21 years, basically what some of my constituents said to me was that I either hadn't done enough or I needed to do more. And I knew they had a right to say that because this is America where we have free speech. But I also had a right not to appreciate it because I knew that I had done everything possible for the pro-life movement. Everything. And you know, my father always told me, he said, when you get up to speak or when you're talking, you should always measure the words and think about what's going to come out of your mouth. Because when those words are hateful and hurtful, you can never take them back. And I know that he would want me to take the high road today, and that's what, you know, I will do. I will take the high road. But you know, after 21 years, I could see which way the wind was blowing across this country with bills similar to today and similar to House Bill 4588 in 2014 and 2568 last year, which I voted against, which Governor Tomlin vetoed, and then last year the veto was overridden. So after 21 years, I used to listen to a newscaster who gave commentaries. He was very conservative, and he was a Republican, Paul Harvey. And I'm sure most of you in here, especially if you're a little bit older than me or just a little bit younger, you probably listened to him also. You know, and he would give a commentary about a subject, and then at the end, he would say the rest of the story. And then he'd come back and he'd give the rest of the story. And after 21 years, I was ready to hear the rest of the story. And I contacted a lady that I was asked to contact and was told I could get the rest of the story. And I finally got enough courage to call her. I know she was very surprised to hear from me. Very surprised. And when I met with her, we had a very frank conversation about issues, many about women's reproductive health that, you know, I didn't feel real comfortable talking about, but you know, she made me feel very comfortable in discussing those. And I told her that I didn't know if I could ever help her, because I knew what would happen when I did. You know, but it was not what she said to me that impressed me. That did impress me, but what even impressed me more was what she didn't say to me. She never said, well, you've never voted with me for 21 years at that time, and why should I trust you now? You know, what a classy lady. So I did hear the rest of the story, and I knew then I could make my own decision about bills. And I take full responsibility for my votes. I'm the person that presses either the green or the red button. No one else. And yes, that meeting and subsequent conversations did lead me to the most drastic change on a position in my legislative career. But let's talk about, this bill. First of all, let's talk about who's against this bill. The leadership of the West Virginia section of the American Congress of Obstetricians and Gynecologists. Let me repeat that. The West Virginia section of the American Congress of Obstetricians and Gynecologists, it says strongly urge opposition to Senate Bill 10. And that organization represents more than 225 obstetricians and gynecologists in West Virginia. And it is the leading organization of OBGYNs in the nation and also the state of West Virginia. And it says, I'm not going to read all this to you, but it says Senate Bill 10 seeks to ban the predominant approach to termination of pregnancy after 13 weeks gestation, commonly referred to as dilation and evacuation. Compared to alternative procedures, D&E has been shown to result in the fewer complications. And it goes on, it talks about science, that they believe that this approach is definitely the best. And let's talk about who else is against this bill. I'm good friends with the senator who represents the 7th senatorial district from Boone, and he's a doctor. When I talked with him about this bill, and I asked him if I could use some of his comments, and he said, "Oh, yes, you can, definitely." And he told me, he said, this was the first time in my 10-year career that I voted against a pro-life bill. And he said, you don't know how difficult that was. And I told him, yes, I did know how difficult it was because I had been there, just like him. But he said this bill interferes strongly with the doctor-patient relationship and does away with the safest procedure in the second trimester. He went on to say second trimesters abortions are extremely rare and usually only happen when the fetus is dead or severely malformed. And he said that this bill clouds the OB/GYN doctor's ability to make a good, clear decision, even to the point of losing their medical license. And I know that I've read some papers here, about the constitutionality of this bill. Some people feel it is constitutional and some people don't. But this bill was actually blocked in Kansas and Oklahoma, a near identical bill. I'm not going to say it was exactly a near identical bill. And on January 22nd, 2016, the Kansas Court of Appeals split evenly 7-7, an outcome by law that confirms a lower court decision. And this bill could be reviewed by the Kansas Supreme Court. You know, so I don't know what the rush is to go out there to be like the third or fourth state. I think maybe this bill or a similar bill was possibly also passed in Nebraska to possibly face, you know, major litigation and major cost. You know, I really believe that this bill let me get exactly what I want to say here. I don't want to misquote. But I really believe that the ultimate goal of this legislation is to take away women's health services one by one until no safe legal options are available to any woman who makes a decision to end her pregnancy. And there's many other things I could say about this bill, but I'm not going to do that today. You know, and I thought about all those comments over 21 years, and I never could figure out why I was getting those comments when I voted 100% pro-life. But you know, everything has a purpose in life. And I finally figured out if I hadn't have received those comments, I never would have sought out that lady to listen to the rest of the story. You know, and let me say that that lady's not an abortionist. She gave birth to twins this past summer. So I'm proud to stand with the ladies today that are against this bill and the men that support them. And I urge a no vote on this bill. Thank you.
John from 67th, Douglas Kenner.
Thank you, Mr. Speaker. It's kind of hard to come after the gentleman from the 5th who said more than what most of us possibly could today, and from deep within the heart. I think we need to really understand what this bill is actually about. Doctors base their decisions on the best method of treatment based on each individual patient. It is not the place of the legislature to interfere with the doctor-patient relationship. This law would deny access for women to a standard of care that is safe. As the gentleman, the chair of health acknowledged in judiciary, this is a reasonably safe procedure. Those were his exact words. It is reasonably safe. It denies
the ability to fall within what is the standard of care as developed by doctors, even when it is the best option for women. This law is focused on pushing political agendas instead of ensuring that doctors are able to provide the best individual care and expertise for women. This bill is designed to deny access to a safe and common procedure in order to make it harder for women to seek abortion care. This procedure is used in about 95% of the cases today that this bill seeks to address. There is no reasonable alternative to this that is available today. It just doesn't exist. When we questioned the alternatives to this in judiciary, we learned that one of the procedures that's being recommended isn't even being taught to med students. It is not something that OBGYNs have in their repertoire today. So what happens when you don't have a reasonable alternative to this? That means you're going to deny access to a woman's most personal decision, which she should be making with her doctor and her family, not her legislature. Every pregnant woman faces unique circumstances, challenges, potential complications. Reproductive health care providers must be able to provide their patients with the best and highest quality medical care based on their medical judgment and their patients' needs, not political agendas. This is not about medicine. This is about trying to stop a decision. This is trying to prevent access to medical care. Let's be frank, the goal of this bill and the many restrictions that have been proposed in this legislature is to eliminate access to abortion by making it too hard, too difficult for people to afford. You know, many women are going to have to travel, particularly from here in the center part of the state. They're going to have to travel out of state in order to receive the kind of quality care that they seek. It's going to be difficult, and it's going to be illegal. We shouldn't be criminalizing medicine. This is the second bill in a few days where we're creating crimes for doctors. Let's create an atmosphere of safety where the legal and personal decisions of women in consultation with their doctors and their families are protected. I urge a no vote.
Lady from 31st, Doug Arbon.
Thank you, Mr. Speaker. We've discussed many issues on this floor this session, some very emotionally charged. But nothing is more important than our basic human rights. Very basic. The right to life. The right to have the chance at living. As I look around this body today, I notice that all of us here were born. We were all given the opportunity to live. Why should we have the right to decide that a baby, a live baby, shouldn't have the same opportunities that we have been given? The right to be born, to live and have a future. However, last year we passed a law allowing an abortion for any reason, and I repeat, for any reason, up to 20 weeks. I was for that passage of that bill because we didn't have any laws on the books pertaining to limits on abortion. How sad. But now we do. This bill, however, pertains to dismemberment of an unborn living baby. Again, an unborn living baby, limb by limb. This is absolutely barbaric. in a society where we treasure life. According to testimony in our committee, there are other methods of terminating a pregnancy. If the mother's life is in danger, the physician is allowed to do whatever necessary to save the mother's life. There is no question about that in this bill. But, Mr. Speaker, we are talking about a live, unborn baby being aborted by a mother who doesn't want it. Imagine the trauma on the baby, and imagine the trauma the mother will feel from that day on, knowing that she killed her own baby in such a barbaric fashion. Talk about emotional and mental trauma. These women, if they have a heart, will suffer for the rest of their lives. And we, as a society, will have to care for their emotional and mental distress. Mr. Speaker, we should do everything to protect life, especially the precious lives of our unborn babies. I urge a strong passage of this legislation. Thank you.
Lady from 36, Delegate Guthrie.
Thank you, Mr. Speaker. I, too, want to stand up for the majority of women in the state of West Virginia and the overwhelming majority of women across this country who think bills like this go too far. Go too far. Like our education system, all they want is for legislators to stop reaching their hands into their examining rooms and dictating what they can and can't do with their doctor. Each and every year, we get further and further away from allowing women to have safe, affordable, and rare reproductive health care. Now we've brought the doctors into it, and we're dictating to doctors how they are to practice medicine without knowing what the circumstances are of that pregnancy. You know, like the gentleman from the 5th, I hate these bills. I hate that we have to come here each and every year and have someone tell women what kind of health care they are allowed to have, what kind of health care they're not allowed to have. Because it is political. Whether you like it or not, 45 years ago, or longer, the United States Supreme Court ruled that a woman has the right to medical privacy. It was called Roe v. Wade. And so we have become incubators at the state level, incubators, to test out how we can become intolerant, uncompassionate, so that we can throw up more cases, say, look, the West Virginia state legislature said that this is okay. So let's go ahead and rehear Roe v. Wade. Well, the court, the high court, is getting ready to do that. And so I stand in agreement with the gentleman from the 5th. What is the rush? Why can't we leave this alone for 1 year? You know, like all of you, I'm a Christian too. And because of my Christian beliefs, I think that we ought to be showing compassion. And I also am intelligent enough to know that we can't prevent every child or every fetus from an untimely death. We can't prevent rape or incest that compromises women beyond belief and then re-victimizes all of those women as we tell them, that's a horrible thing that happened to you, but no, you're not allowed to terminate that pregnancy. That's barbaric. You know, a couple of years ago, I was hobbling around here on a cane because I needed a new hip. My doctor said to me, here's the procedure. First we go in and we rip and tear and cut through all of the muscle. And then we dismember your hip. And it was my choice. That's absolutely correct. It is my choice. And I would suggest to you that the United States Supreme Court over 45 years ago gave women the right to make that same choice in matters of reproduction. I think the thing that is so troubling to me about this bill is that it is designed to shock and awe. If you make it sound hideous enough, if you make it sound as gross as possible, then somehow everyone will be cowed into submission to vote for something that jeopardizes the medical practices of many of our OBGYNs. As you've heard from people who are a lot smarter than me, this really criminalizes doctors. You know, I never thought I would see the day, but this really takes the cake. I believe that this particular legislative session will go down in history as being the one session that is most intolerant, that lacks the most compassion on social issues. It is beyond measure what we are about to do to make it even less safe for women in a time when we are trying to avoid abortion by giving them the medical care that they need. I don't expect to win on this one. I have never won on any of these. But what I can tell you is that all of us in here, or all of you who are going to vote for this bill, you are in the minority. Because women want you to leave them alone. Stop picking at this. And they're watching. You know, the key word here is to make it sound sensational. We had a floor speech, or a floor activity down here the other day on something that most of us are very proud of. The bill that would allow people to donate their organs. It was one of the first bills I ever worked on whenever I got here. And I thought, what a great idea. You just put it on your license that you want to be an organ donator. And yet, over the summer, Planned Parenthood, another life-saving organization, was accused of harvesting baby parts. Now, The guy that made those charges is under indictment because all of it was a bunch of garbage. But it just depends on which side of this issue you land. Do you want to go down in history as being known as someone who can't even see the other side of the coin? The other side of the circumstances that may have driven a woman to need a termination. It's not any of your business. And yet you're making it your business. I have rejoiced with each and every one of you who have stood on this floor and talked about how they made a choice to go through with a risky pregnancy, despite what their doctors said. And you know what? That is a wonderful thing. I'm glad that happens. But for those women who don't have the economic means, who have a compromised health condition, you are taking away that right for them to make their own choice. You don't have to agree with it, but they deserve more respect than shaming them and making them feel as though they've done something wrong because they are not equipped to carry that baby to term. And so, when we should be dealing with fixing and funding PEIA and roads, here we are again, Mr. Speaker, becoming the most socially intolerant state legislature in the country.
Gentleman from the 20th, Doug Markham.
Thank you, Mr. Speaker. I'm going to read three things I want the body to consider when you vote on this bill. According to Jeremiah 1:5, before I formed you in the womb, I knew you. Before you were born, I set you apart. Then we go to Galatians 1:15. Even before I was born, God had chosen me to be his. And then we go to Psalms. For you created my inmost being. You knit me together in my mother's womb. Your eyes saw my unformed body. All the days ordained for me were written in your book before one of them came to be. For those three reasons, Mr. Speaker, I will be voting for this bill and encourage the body to do the same.
Lady from the 50th, Doug Longstreth.
Thank you, Mr. Speaker. I don't usually stand up and talk about this type of issue because it bothers me a great deal, and I hope I don't cry throughout what I'm talking about. I've always, as my colleague beside me, have always voted mainly pro-life on a lot of issues here because I thought they just tweaked something that didn't really harm a woman's right to choose. I come from a background that's very mixed and diverse on this issue, and I just felt like I had to stand up to say something and point out something that I don't think you've all looked at here today. Now, we've talked about many freedoms, many constitutional freedoms. Well, this is a constitutional freedom of a woman. There's not many women who's going to stand up for this in this chamber because it's ugly. This bill is ugly. I said this in the committee, that we put out things that became a very personal thing between a doctor and a patient. It made me sick, and it made everybody else sick too. But let's stop there, because the point is, pro-life, you want to call yourselves pro-life, everybody's pro-life. There isn't anybody here who wants to kill anyone. But the thing that you're not saying, that I've read through this bill over and over, is that you're saying, let's kill it first. What do you mean, let's kill it first, before you do the procedure? If you believe in life, why are you even considering killing it first? You're still wanting to kill the baby, if that's what you're talking about. This is a procedure, a standard of care. This is a constitutional right now that we have crossed a line. 20 weeks last year, I voted for that because I'm not sure if they felt pain. And if you believe that they feel pain now, why are we killing it first? Now, you're still crossing the line as far as I'm concerned with a patient and a doctor. But if you're pro-life, why don't you stand on what you really say you stand on and put the bill out here and say you want to eliminate abortion completely, and let's vote on it. Let the United States Congress vote on that. But don't tweak this and say that you want to save a life when you tell everyone in the committee and everyone on this floor, let's kill it first, because that's what you're doing. I will be voting against this bill, Mr. Speaker. Thank you.
Jump for the 30-second delegate fast.
Thank you, Mr. Speaker. You know, we have a couple of judges back in Fayette County, and one of them says repeatedly in the context of abuse and neglect cases that the government, especially DHHR, has a duty to protect children. And why is that? Because children cannot speak for themselves. And we right now are representatives of the government, and we have a duty to speak for those who cannot speak for themselves. We are talking about unborn children, living unborn children who cannot speak for themselves. We are talking about living unborn children who have fingers, who have arms, who have legs, who has a head that can be grasped with instruments. That's who we are speaking about. In Judiciary Committee, we had a guest attorney that spoke to us in the context of a legal expert, and this attorney was from the American Civil Liberties Union and was speaking extensively about the due process rights of adults, due process rights of a pregnant woman. And the question was asked, are there any due process rights for a living unborn child? And the answer given was, I can't think of any. And I think, Mr. Speaker, that is the dichotomy that we are facing here today. Are we speaking about persons or are we not? For in the West Virginia Constitution, Article 3, Section 10, it says that no person shall be deprived of life, liberty, or property without due process of law and the judgment of his peers. And if we are speaking of persons here, then those persons who cannot speak for themselves have that right to life and liberty. And we cannot just turn our back on those persons and say that they can legally, without repercussion, legally and physically be torn apart limb by limb. Our laws, statutes outside of our Constitution state that an unborn child, obviously still within the mother, if the mother is killed, murdered, there are to be 2 counts of murder there, one for the mother, one for the unborn child. The same applies for voluntary manslaughter. The same applies for attempting to kill by means of poison. So, Mr. Speaker, I believe that we do have a duty to speak for those who cannot speak for themselves. And I believe that is exactly what we are doing. We are a humane society. We are a civil society. We must prevent, as an act of government, barbaric procedures on unborn children
who cannot speak for themselves. And certainly, Mr. Speaker, I urge a yes vote on this bill. Thank you.
Gentleman from 37th, Delegate Pushkin.
Thank you, Mr. Speaker. The Chairman of Health and Human Resources, please yield.
Gentleman yield. Gentleman yields.
Yes, sir. Thanks. Thank you for yielding. I'm sorry to have you get up today, but you know more. You know more about this subject than I do. Basically, what the bill says that I hate talking about this as much as anybody. That poison would have to be injected into the fetus before the D&E, before the procedure was made. Under this bill, there would have to be poison injected.
It doesn't say you have to do that. It's saying that if you were to perform the D&E on a live fetus, that you would probably need to terminate it first before you do the D&E. So it doesn't preclude you from doing the D&E. Now, there are medical alternatives to doing a termination also. Doesn't mean you have to inject a feticide or something.
But this is the most commonly used method for a second trimester abortion.
Yes, it is.
And so, under this bill, it'd be safe to say that in the unfortunate event where someone would have this choice for themselves during their pregnancy, and this was the doctor felt was the safest method. In order to perform that method, they would have to inject poison.
Probably, yes.
And what kind of poison did they use?
Well, there's several things you can do. You can either, for injecting poisons, you're talking about digoxin is one thing, 1 milligram of digoxin. The other thing would be potassium chloride.
What would happen if they missed with the potassium chloride?
Well, it's sort of like doing an amniocentesis. You probably wouldn't miss, but if you inject it into the uterus itself, that could be something that could get into the maternal bloodstream, and that could be a factor. But I would imagine someone that is careful enough to be able to do a D&E, because it does take a fair amount of skill to do that, would be careful enough not to inject something into the maternal bloodstream.
Is this something that is commonly taught, that method is taught now?
It's not commonly taught, but it's possible. I mean, I would be able to do it if I wanted to.
It's not commonly taught, but you said it could be a factor. Could that factor be the death of the patient?
Well, the D&E itself could be the death of the patient.
But if they missed with the poison, could that result in the patient?
The possibility if it was a high enough dosage.
And then the baby dies also, right?
Well, yes, that
so
would
you have
happen too.
The mother and
if
the child
mom dies,
both
baby
die.
dies. Yes.
All right. Well, thank you. I'm sorry I made you have to get up, but you're the doctor. I'm not. At the appropriate time, I'd like to briefly speak to the bill.
Gentleman may proceed.
This is an extremely difficult decision for me today, not nearly as difficult as the decision is when a woman is faced with this decision. I don't know what goes into it, whether it's because it was a rape or someone was a victim of incest, or there's medical complications. I know that that's provided for in the bill, but it's not really clear, and it creates a bit of doubt in the doctor whether or not they should use this method or that method or lose their license. And what I'm trying to say is I'm very uncomfortable making this decision for other people. And I know we make a lot of decisions for other people, but we're making decisions inside their doctor's office for them. I'm going to come down on the side of trusting the women and their doctors to make the right decision for themselves on the unfortunate event that they even would consider that decision. Because like everybody else in here, I'm also pro-life. Everybody in here wants to see every baby carried to term and be born healthy to two healthy parents and be raised in a healthy household. But that's just not the case all the time. So yeah, it's going to be it's a tough decision that I'm going to vote against this because of what I just heard. There could be mistakes made and it could result in the death of the patient, death of the mother and the baby. And I have a feeling though that there's going to be, there'll be more votes in the affirmative, and the bill is going to pass. And I just hope that if we are all truly pro-life, And we're all truly pro-children. I just hope after this vote we can work together on doing some things to improve public education and maybe juvenile justice reform, maybe helping their parents get better jobs so they can provide for their kids, maybe funding their insurance, their health insurance, so they can go to the doctor themselves. So, but it is a tough decision. I'm going to have to vote no and trust women and their doctors to make these decisions for themselves. Thank you.
John from the 10th Delegate Azinger.
Thank you, Mr. Speaker. Last week I quoted a gentleman named Ron Johnson, a theologian from Indiana, who said, "Our founding fathers called the right to life self-evident truths. This means you don't reason to them, you reason from them. You begin with life as a starting point and view all public considerations from life." Jefferson in the Declaration of Independence did that very thing. He said, "We hold these truths to be self-evident that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life." Life. Interestingly, God addressed the life issue as a first thing also. At the end of Genesis chapter 3, Adam and Eve were ejected from the Garden of Eden. And the first verse in chapter 4 records the first thing that Adam and Eve did after they were ejected from the Garden of Eden. They got frisky. It says Adam knew his wife, and she conceived. She conceived. That's called the law of first mention in Scripture. The first mention of conception, of life, is life occurring at conception. You'll find that pattern after that first verse, verse in Genesis 4:1, repeated throughout Scripture, that so-and-so came together and they conceived and then they bear a child. Conception. That's God's standard of where life begins. We can set a standard wherever we want, in a capricious manner, in a relative manner, in our decision of where we want to decide and say where life begins. But I'd have to ask you, if you set that standard after conception, on what basis, on what authority are you setting that standard? Because God makes it clear in Scripture that He sets life, the standard of life, beginning at conception. Anything after that we do with that life in that womb, we better be very, very, very careful. Conception, a first thing. You argue from it, you don't argue to it. I said in Judiciary, when this was before the committee, that when a nation drifts from God, this is the kind of arguments you can expect to have. Is it okay to tear apart a helpless, defenseless baby in the womb, limb from limb? Justice Kennedy, Supreme Court Justice, said of this procedure, friction causes the fetus to tear apart. For example, a leg might be ripped off the fetus as it is pulled through the cervix and out of the woman. Kennedy again in Steinberg v. Carhart said, the fetus in many cases dies just as a human adult or child would. It bleeds to death as it is torn limb from limb. That is man setting a standard that God did not give us, setting a standard of what we can do with life after conception. We think because God is merciful that God is indifferent. Or as R.G. Lee said, that perhaps He's blind, that He cannot see. Perhaps He's deaf, that He cannot hear. Perhaps He's paralyzed, that He cannot move. But He is none of the above. God bless those that made this bill happen. May their numbers increase, Mr. Speaker. I urge its passage.
Gentleman from 52nd, Delegate Schaefer.
Thank you, Mr. Speaker. You know, the things just keep getting harder, don't they? You know, I've talked to a lot of legislatures this session, and they said this has really been a tough one. And you know, I was told before I come down that politics makes strange bedfellows. And as you sit back and as you're against someone today or against this bill, the very next bill your best buddy's on. But you know, I've heard a lot of talk here today about pro-life. I've heard everybody talk about being pro-life. And as I spoke on this bill in judiciary, I just wanted to bring up one thing. If you get down to the bottom of the bill, it clearly says, this section does not prevent an abortion by any other method for any reason, including rape and incest. I said in judiciary when I spoke on this that if I had my way, I would outlaw abortion 100%. But I guess we're going to leave that decision up to the U.S. Supreme Court to make constitutional law, like they do in every other thing. But I do want to read a couple things. West Virginia Law 61-230 talks about when a lady is murdered and she's pregnant. And in section C, it says, for purposes of enforcing the provisions of section 1, 4, and 7 of this article, subsections A and subsections C, section 9 of said article, sections 10 and 10B of said article, and subsections A, section 28 of said article, a pregnant woman and the embryo or fetus she is carrying in the womb constitute separate and distinct victims. Now, if you go right above that, it talks a little bit about embryo and fetus. And it says embryo means the developing human in its early stages. And it lists two different periods. And it talks about the embryonic period. Commences at fertilization. I think if we looked that up in the dictionary, I'd say that's when the baby was conceived. It's when two people have sexual relations and a human being is formed. And what this bill is about, as we've heard our assistant chair in judiciary say, it's about the ripping off of a leg, of an arm, of a head, of a living being. Now, he has said that if they kill the baby ahead of time, that they can do this. You know, this bill does not outlaw abortion. In judiciary, we had one of our delegates that's a physician talk to us, and he talked to us about other methods of abortion. This bill does not affect those other methods at all. All it does is try to protect that little fetus that's in the womb while it's alive from being ripped and torn apart. I also want to direct you to the 8th Amendment of the Constitution. We've talked about constitutional freedom of women. The 8th Amendment gives this right to criminals. Excessive bail shall not be required, nor excessive fines imposed. That one there doesn't apply, but it's the last part of that. Nor cruel and unusual punishment inflicted. I want you to think about a living being that is breathing and living off its mother, and you're going to go up in there and you're going to rip its legs off and let that little baby bleed to death, do you think that's cruel and inhuman treatment and punishment towards a human being? If you do, please vote green on this bill. Thank you, Mr. Speaker.
Lady from the 51st, Doggett Fleshire.
Thank you, Mr. Speaker. Just like cases and constitutional provisions, there are competing versions of things in the Bible. For example, Genesis chapter 2, verse 7. Then the Lord God formed a man of dust from the ground and breathed life into his nostrils, the breath of life, and man became a living being. A living being. Now, we had a public hearing on this bill, and there were persons who testified from several different religious traditions, and we have different religious traditions within Christianity regarding when life begins and when it would be permissible to terminate a pregnancy. Not everyone believes the same on this issue. And let's be clear, we are not talking about a viable fetus. We've already outlawed abortion after 20 weeks, and there has been no instance of a fetus that was able to breathe, that was able to live, that's under 20 weeks old. Another scripture that I think might be helpful, scriptural verse that might be helpful in this instance, is judge not, lest ye be judged. Judge not, lest ye be judged, which is from Matthew chapter 7, verse 1. We don't know all the facts. If a woman and her family and her physician are considering terminating a pregnancy. Many families in this second trimester desperately want to have children. But they know that if they're forced to continue the pregnancy, the child will die within the first few days. For example, if the fetus has no brain, no heart, or multiple anomalies that would virtually assure that it could not survive. Yet we are going to override the judgment of a woman and her family and her doctor who says that a D&E procedure is her safest option. That's what this bill would do. So I'm going to be voting no for 3 reasons. 1, in my opinion, this bill is unconstitutional. It violates women's liberty and privacy rights because this is a very, very private decision about whether to have children or not. Most people really want to have children. And most people, it's a blessing to have children. But we should not be barging in to the doctor's office and mandating that decision. So my second reason is I think that we need to have some compassion for families during that second trimester who are going to be having to make difficult decisions. And thirdly, and lastly, we shouldn't be punishing physicians for exercising their best medical judgment. That is what the American College of Obstetricians and Gynecologists have said, is this is the safest procedure for women in the second trimester. So I will be voting no on this bill.
Lady from the 18th, August Sabonia.
Thank you, Mr. Speaker. There's not much more I can say on this bill. A lot of it has already been said on both sides, but I would like to thank you, Mr. Speaker, for escorting the pages out of this chamber. This has been it's been stated that this is a horrible bill. Well, Mr. Speaker, this is a horrible practice. It's a horrible procedure. This deals with live babies in the womb, and they are dismembered while they are alive. It's been stated that this does not end abortion. Roe versus Wade still exists. It doesn't criminalize doctors. The criminal and civil penalties were removed. The high courts have determined, as in partial birth abortion, another procedure that was upheld by the court, that the state may use its regulatory power to ban certain procedures. And no court has determined, in the couple of states that have passed a similar bill and legislation, no court has determined that it is unconstitutional at this time. We've heard this is about reproductive health. It's a political agenda. We've heard that it's a political agenda. Mr. Speaker, I'm glad to be political if it means that we're going to end a practice that does this to a human live baby. I don't believe this is politics. I believe that it's humanity, it's compassion. I'd like to remind the body, we've heard that this is not somebody that said this, I'm not sure, I think it was the gentle lady from Kanawha County said that this is not the legislature's business. But I'd like to remind you that Chapter 19, Article 2E was adopted by this legislative body, and it's called the Humane Slaughter Act of 1982. And it puts forth humanity, compassion in the slaughter of livestock. Yet we're debating whether we should be compassionate in the slaughter of a live baby. Inmates on death row. There's compassion and humanity in death row for lethal injections. Each state that employs lethal injection for the death penalty must have a compassionate, detailed protocol in place before they put a death row criminal to death. Mr. Speaker, I'm going to stand on the side of humanity and compassion today. I'm going to vote whether a future court will turn this over as unconstitutional. I'm going to stand today and say that a live baby deserves humanity and compassion. I urge a green vote on this. Thank you, Mr. Speaker.
The lady from the 32nd, Delegate Kessinger.
Thank you, Mr. Speaker. Safe, legal, and rare. We've heard it over and over since 1973. We've heard it in this room today, that abortion should be safe, legal, and rare. Well, out of those three words, the only thing I can think abortion is legal. It's not rare, with more than 55 million unborn children being aborted since 1973, and it's not safe. The CDC says that in 2009, the CDC said that more than 400 women have died as a result of a D&E abortion. The CDC also says that more than 40% of women who receive a D&E abortion have serious complications. Everything from lacerations of the cervix or uterus to infections to death. Death in the case in Chicago in 2009, where a young woman, 24 years old, Tanya Reeves, died just hours, 12 hours after having a D&E abortion procedure done. She bled to death because her uterus was perforated, because a D&E is a blind procedure. In 2002, a 25-year-old woman named Diana Lopez in a Los Angeles Planned Parenthood lost her life after her cervix was punctured and bled to death in a hospital 5 hours later. We can sit here and say that this bill is going to put women's lives at risk, and we do that every single time any type of restriction or regulation is tried to be placed on abortion procedures. In 2003, when President Bush signed the partial birth abortion ban, after being vetoed twice by the former President Clinton, people said this is going to hurt women. This is going to take women's rights away. This is going to leave women without adequate health care, and women are going to die because they can't have a partial birth abortion. Not one time Not one time since 2003 has a woman died because she couldn't receive a partial birth abortion. Last year, we passed a 20-week pain-capable Unborn Child Protection Act. And we heard these same conversations. This is going to take women's health away. This is going to put women at risk. And not one time since last year have we heard that a woman's life has been lost because she could not receive an abortion after 20 weeks. My friend from the 36 compared a fetus to her hip replacement. The last time I checked, your hip doesn't have a heartbeat. It doesn't have fingernails. It doesn't have fingerprints. It doesn't have eyes. It doesn't have a beating heart. We are not talking about just another limb on our bodies. We're talking about a completely separate individual that has a right to life and should be protected, and that's why it's our business. It's been asked, it's been said that it's none of our business to get involved in women's health. Well, let me tell you, a fetus it's not just another part of a woman's body. It's a completely separate entity, and if you believe life is inherently valuable, then you believe that. I'm not going to sit here and say that any of my friends in this room, whether you vote for or against this bill, are pro-abortion. I don't think anybody but abortionists are pro-abortion. We all value life in all of its stages. And I'm asking you today to look at the humanity, not only of the fetus who's being ripped apart limb by limb, but even the risks that these procedures present to women. You know, I don't want to be too vulgar, but I do want to read something from a former abortionist who has since laid down his abortion tools. And it says, "The toughest part of a D&E abortion is extracting the baby's head. The head of a baby that age is about the size of a large plum and is now free floating inside the uterine cavity. You can be pretty sure you have a hold of it if the sofa clamp is spread apart about as far as your fingers will allow. You will know you have it right when you crush down on the clamp and see the white gelatinous material coming through the cervix. That was the baby's brains. You can then extract the skull pieces. Many times a little face will come out and stare back at you. Congratulations, you have just successfully performed a second trimester suction D&E abortion. You just affirmed her right to choose in less than 15 minutes. 15 minutes, that's all it takes to rip a baby apart, a baby with a heartbeat, a baby with fingerprints, a baby with its own completely separate own set of DNA. And so I'm asking you, Mr. Speaker, and members of this body, to think very hard about the decision that we're making. And I would urge a green vote on this bill.
Gentleman from 53rd, Douglas Smith.
Thank you, Mr. Speaker. I feel it's sad that our society has got to the point that we have to even pass a bill like this, that we've lost our heart and soul for mankind. I honestly believe if this was an animal bill, if we was talking dogs or cats, this bill would pass 100% unanimously out of this body. I truly believe that. I truly believe that. This is simple for all of us. This vote is simple for everyone in here. If this does not bother your conscience, if this does not bother your conscience at all, dismembering a baby, vote against it. If you have no conscience on this, if this does not bother your conscience, vote against it. But if you have a conscience, if you have 1 ounce of conscience on something like this, if this truly bothers you, then you're going to vote for this bill. It's just as simple as that. And I can tell you, Mr. Speaker, my conscience will not let me vote against this. Thank you.
Gentleman from 27th, Douglas Ellington.
Thank you, Mr. Speaker. Full disclosure, I testified to Judiciary Committee the other day, and the gentleman from the 67th asked me if I belonged to West Virginia ACOG. I do belong to ACOG itself. Some of my dues do go to West Virginia ACOG. I've never formally applied to them, but I assume that I am probably a member, or at least on the rolls. So I misstated that previously, saying that I wasn't, but I may be. So getting that out of the way. I have, over the weekend, while each of you were diligently going over all the other bills, while I was taking care of my practice delivering a few babies, I took the time to read over the ACOG practice bulletin. I was able to log on to the site and look at all the different reviews. And from ACOG practice bulletin 135, this is the most recent one, it mentions, though, that these guidelines, this is quote, "These guidelines should not be construed as dictating an exclusive course of treatment or procedure," unquote. I wanted to give you a little bit of facts first, just so the members here have some background. They've heard different numbers, but I wanted to state some of the things that came right out of that committee opinion. About 4% of abortions occur from 16 weeks or later. That's what's in the second trimester. So you're only talking about 4%. After 21 weeks, 1.3%. Mortality rate, meaning mother dying, is 0.6 out of 100,000 abortions. Childbirth, 14 times greater than what it would be for abortion, just to put it in perspective. Now, abortions that are performed less than 8 weeks, the mortality rate is 0.1 per 100,000, but over 21, or at 21 or over 21 weeks, 8.9 over 100,000. So there's a relationship between how many weeks of gestation to what the mortality rate is. So the further you get, the higher the rate. Most of these terminations that are done in the second trimester have a higher rate. Now, in 1973, when they mentioned the Supreme Court decision in Roe versus Wade, the same committee report quotes, "By the late 1970s, researchers had demonstrated the safety of D&E and concluded that it was safer than the medical abortion techniques used at that time." This is in the late 1970s. They also mentioned afterwards, under methods that, quote, "both surgical and medical methods of pregnancy termination can be used in the second trimester," unquote. And also, quote, "limited evidence suggests that the vast majority, 95%, as quoted by the gentleman from the 67th, of second trimester abortions in the U.S. are performed by D&E. However, terminations by medical abortions may be underreported." As the lady from the 51st had mentioned, that a fetus that may have no head or no heart, or no brain or no heart, most of the cases of medical abortions are performed to keep the fetus intact so as to determine what anomalies or genetic malpresentations were there. So there are reasons why these are done that way. Now, again, it does take a certain part of skill to do a D&E, and many places do not train their providers in how to do that. About 30% of residencies don't have opt-outs for abortion procedures, and about half the residency programs don't even train their residents in how to do a D&E. So it does take a certain level of skill. And as some other people have mentioned, there are significant risks to those procedures. Now, ACOG and West Virginia ACOG, along with the AMA, don't like any interference with the physician-patient relationship. And I, for one, don't particularly like it either, but I realize there are guidelines we have to go by. Main concerns regarding abortion are access to care, facilities that are available, people that are trained to perform the procedures, transportation to and from these centers, cost, insurance, just to name a few. I will submit to you that the physician-patient relationship with someone obtaining an abortion, they're usually meeting that person for the first time, so it's usually not a long-standing relationship. That doesn't negate the physician-patient relationship, but again, it's not something that's usually been long-standing. Now, government interference in medicine, particularly to my practice, Perinatal Partnership and ACOG are already pushing that we can't do elective deliveries before 39 weeks. And CMS regulates that we have to have certain codes, diagnosis codes, in order to do that. That takes a lot of the decision-making out of my hands when I'm trying to determine the general scope of what's happening with my patient. I live by that. I have to go by it. That's part of the rules. But don't doubt for a minute that if I felt I had to intervene, I wouldn't do so. And I suspect that many providers that may do abortions for their patients wouldn't hesitate to do the same and suffer the consequences. Tubal ligations. Medicaid patients, the federal government dictates that we have to wait 30 days, have a consent on the form that they signed 30 days before we could do a tubal ligation. They require that. That's because of the person's right to their privacy as far as their reproductive abilities. However, if I'm doing a C-section on someone and they wanted a tubal ligation and I didn't have those forms signed by the government, I couldn't do it. Even if it's against my best judgment, I'm subjecting that person to another procedure, something that I didn't plan on doing. Cloning, researchers, we have moral boundaries as far as what we're allowed to do from research. Euthanasia, how many patients that I've had to deal with in oncology, cancer patients. I mean, I've been faced with that. You're not allowed to do that. We set those boundaries. So my thought is there are things that we are setting. For this particular procedure, all this is saying is that if you have a live fetus, you're not going to dismember it. Now, this was brought up also about the term dismemberment. It's not a medical term. In the same bulletin, they describe it as disarticulation, for those of you that want to be specific. In any case, all this is saying is that you have to either terminate the fetus before you perform the abortion, or you use another technique. And the same bulletin reports the different techniques on how you can terminate the fetus. So this bill does not prevent someone from doing that. Certainly someone that is going to terminate the fetus is not going to be against injecting potassium chloride or digoxin into the fetus. So I don't see that this is a boundary. It does give the medical exception as far as emergency, that you can still do that. I don't have a problem with it. I know some of my colleagues do, but as I mentioned in the judiciary testimony, they didn't poll me. And I'm sure they didn't poll many of the other members of ACOG in West Virginia. Thank you, Mr. Speaker.
Further members desiring to speak for, I recognize the gentleman from 38th, Duggan Lane, to close debate. Gentleman from 38th.
Thank you, Mr. Speaker. Ladies and gentlemen, I just want to touch on a couple of things about exactly what the bill does, what it doesn't do, and then sort of provide a lay of the land as best as I can with regard to the state of the law and some court cases. First of all, I heard a couple of things mentioned in debate. One of them was that it criminalizes doctors. The bill before us does not criminalize doctors whatsoever. There is no criminal penalty in the bill for doctors who perform a dismemberment abortion. They may be subject to licensure action because they're determined by the language of the bill to be practicing outside the scope of their practice. However, as we just heard from the Chair of Health, there are numerous other areas where the government has defined what the scope of practice is for not just OBGYNs, but other medical professionals, and in fact, other professionals altogether. And I would just on that point, point the members to a United States Supreme Court case, Washington versus Glucksberg, which says that the government has an interest in regulating the profession of medicine. The government has an interest in regulating the profession of medicine. And so from the United States Supreme Court, they have certainly recognized that we have, as legislators and policymakers, have the ability to set the scope of practice for the practice of medicine. Another item that I heard mentioned was that women are not going to be allowed to have an abortion if this bill passes. And that's just simply not the case. If you read the plain language of the bill outlaws or prohibits one particular type of abortion, one particular type of procedure for abortion. And I would suggest to you that it is much like a recent Supreme Court case, Gonzalez v. Carhart, which is a 2007 case that upheld the partial birth abortion ban. In that case, the court determined that this one particular procedure, the legislature or the Congress at that level had the authority to prohibit that particular type of procedure. And in the bill before us, the language seeks to do the same thing, and that is prohibit one particular type of procedure. Now, one of the requirements under the Carhart case was that there are alternatives to the procedure that was banned under the statute in that case, the statute in this case. I think we all heard, if we were paying attention, the Chair of Health just described the alternatives that are available, even if this bill is passed and becomes law. There are a number of alternatives that are available to provide a woman the opportunity, if she so chooses in consultation with her doctor, or if medical necessity requires, that pregnancy be terminated. And so while we have some information from particular groups or particular doctors who are opposed to it and claim that there's not a medical necessity, that there are no other procedures, we also have conflicting testimony and conflicting evidence and conflicting argument presented to us, both at the public hearing that was held, in the Health Committee, in the Judiciary Committee, in documents provided to those committees, and by our friend from the 27th, who is, as I might remind the members, an expert and is practicing in the field. And so when it comes to conflicting medical testimony as to whether something is necessary, whether it is available, whether or not there are alternative procedures, what does the court say in that regard? And I would point the members to the Kansas v. Hendricks case, which is, again, a United States Supreme Court case. And part of the holding in that case found that the law survives where medical uncertainty exists. And so in that situation, and in Gonzales, you had exactly the situation that we've been presented with here today, which is medical experts. Some said it was a good idea, that it was available, that it wasn't available, and then there were others on the other side. So you had medical experts on both sides presenting their arguments, presenting their facts. And so when that happens, the court has said that the law will survive constitutional challenge where medical uncertainty exists and the legislature acts. I would also just point out, with respect to the practice of this procedure, we've heard that ACOG and some of the other groups have opposed it, and that the procedure is not taught, it's not available, and people don't know. I have, as part of the information that was submitted during the public hearing and to the Judiciary Committee when we took this up, a letter from the professor and vice chair of the Department of Obstetrics and Gynecology at WVU here in Charleston. And as you may or may not know, Charleston's medical school has a division here in Charleston where students can take their residencies in the local hospitals. And so this person is the professor and vice chair of that OB/GYN department here through WVU here in Charleston. I won't read the whole letter, but I will point out two sentences I think that are important to our contemplation today of the bill. And he says, "Never in my 30 years of medical care has an obstetrician gynecologist and over 25 years of maternal fetal medicine has it been necessary to dismember a living baby." He goes on in the letter to say, "Virtually everyone abandoned these dangerous surgical procedures precisely because of the risks to the mother with regard to laceration, damage to internal female organs by fetal bone, shards, instruments, and significant risk of perforation of the uterus." And he also talks about the availability of medications that are relied upon to terminate the pregnancy prior to dismembering the fetus and extracting the fetus. And so I believe that based on the information that we've been provided from the medical community, there's clearly alternatives available to this procedure. Based on what we know from the Supreme Court, we clearly are able to enact policy and legislate when there are alternatives, and we have the authority to regulate and define the scope of practice for the medical community. Now, I heard someone early on talk about 2 other states that had adopted this or similar language to this, and if I wrote it down, I tried to quote it exactly. But in that discussion, in those comments, the member said that a 7-7 split confirmed a lower court decision that it was unconstitutional. And most of us who are lawyers in the room know that that is not what a 7-7 split of an appeals court does. That's not the legal effect of that. But for those who are not lawyers, a 7-7 split or any even split on an appeals court does not confirm the holding of the lower court. It simply does not have that effect. The effect of a 7-7 split or any split, even split, on an appeals court is to allow the lower ruling to stand. It allows it to stand. So that split, that even split, has no effect in the law. It provides no precedential value. And if you think about it, we've heard recently with the death of Justice Scalia that the Supreme Court now is at what some people believe is a 4-4 split. And there's been a discussion about what happens in the next year or however long it takes if there's no Supreme Court justice appointed and all of the cases that are currently before the court come out as 4-4 splits. And if you ask any lawyer, any legal expert, they will tell you that every one of those 4-4 splits has no legally binding effect on the law. It's basically a stay, it's a hold. This is where we are until we get another justice, until we can deal with this issue again later on. So the law may be different depending on where the split occurred, what circuit it came from. And I would point out that the even split stays that were referenced and that I've just explained are not in effect and should have no bearing for a second reason. First of all, they don't create law, they don't confirm the lower court ruling, but secondly, because those are not federal court rulings. Those were state courts that determined that. And so, to my knowledge and in our research, there's been no federal court that has ruled upon whether or not this is unconstitutional. No federal court has determined that this is unconstitutional. Now, I think some of the things that are important to understand is what is required for a bill that deals with abortion to be constitutional. And the reason that I say that is because one of the other comments that I heard was that the language in here says that it prohibits dismemberment abortion for the purpose of killing the baby, killing the fetus. And someone lamented the fact that all we had to do was kill the baby first, and then you could dismember the baby. And the question was raised, well, why, if we're pro-life, if somebody is pro-life, why would you not just run that bill out? And why is it okay to kill it first? Why kill it first? And the answer to that is that it is unconstitutional otherwise. Because clearly, women have a right to an abortion, and it's just a matter of where the state may exercise its authority. And so if the bill comes out that says there is no abortion, abortion is outlawed totally, then I think everybody would agree that that would be unconstitutional. And so the answer to why kill it first is because there must be an opportunity for a woman who is needs her life or health protected, or who is in a medical emergency, to have that alternative. And those are provided in this bill. And I would just point out to the members that Justice Kennedy, who is sometimes thought to be the swing vote on issues such as this, said in a case, if truly necessary, and this is upholding partial birth abortion ban, if truly necessary, In some serious circumstances, a prior injection to kill the fetus allows a doctor to perform the procedure. And so again, if we think about in the context of what has already been upheld, partial birth abortion ban, a particular procedure where there are remaining alternatives, compared that to what the language is before us, a prohibition against a particular procedure. There are alternatives that are still available to doctors and women. The life health of the mother is protected in the language of the bill. And the medical emergency exists, and the only thing that this bill does is to outlaw a particular procedure that is for the purpose of killing the unborn child, for the purpose of killing that child, that it is dismembered. Now, ladies and gentlemen, I've tried to run through as best I could most of the arguments that I heard that were either based on the language, inaccurate reading of the language before us, or based on what I consider to be inaccurate expositions on what the case law is. I will not stand here and presume to tell you what policy you in your heart should adopt. I won't do that, because I don't think it's right for me to do that on such an important issue, such a personal issue. But I would hope that after hearing the arguments or the explanations that I've provided to you, I would hope that you would be free from the constraints of trying to figure out what the bill does and whether or not it is constitutional or not. And so that those two items have been removed, and what's left is for you in your heart to determine whether or not this is a proper policy that you believe ought to be adopted by the state of West Virginia. Don't vote no because you think it's unconstitutional. Don't vote no because you think that somebody's not going to have an abortion if they absolutely need one for medical reasons. Don't vote no because you think it prohibits every type of abortion available, because we've talked about those. None of those are valid reasons. If you truly believe in your heart as a policy matter that you should vote no, then do that. I won't tell you otherwise. I won't ask you to do otherwise. But if you truly believe that the state of West Virginia has a proper role in protecting these children in their mother's belly, I would ask you to vote yes. Thank you, Mr. Speaker.
Question before the House is the passage of the bill. Those in favor will vote aye. Those opposed will vote no. Clerk, prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, 86 ayes, 13 nays, 1 member absent not voting. Majority of members present having voted the affirmative, I declare the bill passed. Clerk, please report the title.
Committee substitute for Senate Bill 10.
Are there amendments to the title?
Delegate Ellington moves to amend the title.
Question for the House is the adoption of the title amendment. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. Declare the title amendment adopted. Clerk, please communicate the action of the House to the Senate. Further bills.
Committee substitute for House Bill 2826, requiring the Commissioner of the Division of Highways to approve points of access to and from state highways to real property used or to be used for commercial, industrial, or mercantile purposes.
Question for the House is the passage of the bill. Gentleman from the 27th, Delegate Schott, to explain the bill.
Thank you, Mr. Speaker. In 2014, 21-year-old Sarah Knott stopped at a convenience store to buy something to eat. As she was trying to depart from the convenience store, her line of sight was obscured by vehicles that were parked along the roadway. She eased out onto the road and was smashed into in her lane of traffic. As a result, she died from injuries that occurred in that accident. This bill, House Bill 2826, seeks to minimize the chance of that ever happening again. It designates a method of notifying the public where parking is prohibited on driveway entrances or access points for business, industrial, or mercantile establishments. Specifically, the bill addresses the following areas. For points of access which exist on or before July 1 of this year, in business or industrial mercantile establishments where the driveway entrance is more than 50 feet wide and is along a road with a speed limit of more than 45 miles an hour. For those points, the Commissioner of the Division of Highways shall place no parking signs at the end of the driveway's entrance or clearly mark the area at issue with the words "no parking" and hash marks to notify the public that parking is forbidden. But only if the Commissioner deems it appropriate due to heavy traffic or other circumstances created by vehicles parked on the state right-of-way. For these same type of points of access that are approved after July 1 of this year, the owners are responsible for including no parking signs, markings, curbs, and paint necessary to comply with the appropriate safety requirements, and done with the approval of the Commissioner. Mr. Speaker, I urge passage.
Are there other members desiring to speak to the passage of the bill? Gentleman from the 14th, Doggett Butler.
Thank you, Mr. Speaker. I'd like to thank the members of the Judiciary Committee for their hard work on this bill to continue to narrow it so that we're not doing this in instances where it's not necessary. But as the chairman said, this was a young lady who was trying to get to college that morning. Her view was blocked by a couple of large utility trucks. She was trying to pull out onto a 55-mile-an-hour highway where oftentimes people are going 70 miles an hour. So what this legislation does is, in instances where the speed limit is above 45 and where a dangerous situation exists, it gives the Commissioner of Highways discretion here. It says that no parking signs will be put up and or the no parking lines will be painted on the road. And I had placed a picture on your desk earlier. It shows you it's a pretty simple matter to do this. And also there's a statement from the Mason County Sheriff that says that it's difficult for the law enforcement officers to know where these parking and no parking situations exist without being properly marked. So for all those reasons, and so we don't have continued instances of this in our districts, I would ask that you vote yes on this. Thank you.
Gentleman for the 56th, Doggett Howe.
Thank you, Mr. Speaker. Rule 49, my business location meets these descriptions.
To the gentleman, to the extent that you would be affected by this, would be as a member of a class, and therefore the gentleman would be directed to vote. Further members desiring to speak to the passage of the bill? If not, the question for the House is the passage of the bill. Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has each member voted? If so, the clerk will close the machine, ascertain the result. On that question, 97 ayes, 0 nays, 3 members absent, not voting. Majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
Committee substitute for House Bill 2826.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. Clerk, please communicate the action of the House to the Senate and request concurrence therein. Further bills.
Committee substitute for House Bill 4279 relating to disposition of seized firearms.
Request for the House is the passage of the bill. Gentleman from the 27th, Delegate Schott, to explain the bill.
Thank you, Mr. Speaker. Another DNR bill. This one deals with firearms impounded or seized by the DNR. Under current law, the DNR comes into possession of firearms. Its officers are empowered to impound property of an accused used in committing an offense. If the accused is either not acquitted or fails to pay any fines or penalties, the law directs that the property be sold at public auction. Also, when a person is convicted of a second violation, the property seized at the time of the arrest is declared forfeited to the state and may be sold. And finally, for various reasons, gun owners may not even seek to recover the seized property. Under this bill, any firearms that the DNR is empowered to and intends to dispose of must be handled pursuant to the unclaimed stolen property held by law enforcement agency statute, which is codified at section 36-8A-1 and the following provisions. The unclaimed property statute contains a specific section relating to the disposition of firearms in state custody. The statute permits the treasurer to dispose of firearms consistent with federal law. After determining whether the firearm needs to be returned, such as whether it was lost or stolen from an innocent owner, the treasurer can either trade the firearms with firearms collectors, dealers, importers, or manufacturers, which is authorized under federal law, or sell them at public auction to these classes of individuals only. So all this bill does is require that the DNR dispose of firearms through the treasurer's unclaimed property procedures. DNR can apply to the treasurer for the proceeds of that sale. Mr. Speaker, I urge passage.
Are there other members desiring to speak to the passage of the bill? The gentleman from the first dialogue begin.
Thank you, Mr. Speaker. Will the chair please yield for a question?
Gentleman yield. Gentleman yields.
Yes.
So it's my understanding that when someone is arrested under this code, their property, the accused property, is seized and impounded?
Yes, that's the process that's been in law for quite some time, yes.
Okay. So no conviction of a crime is required. The property is seized automatically?
It is impounded before the determination of guilt, yes.
So with the presumption of innocence, does this not kind of violate that American tradition?
No.
Well, it doesn't?
It does not.
Innocent
No.
until proven guilty?
There is still a presumption of innocence of the crime, but the tool that's being used in the crime is often impounded by authority.
Right, but
You have somebody robbing a bank, you don't give them back their gun.
but the individual's still innocent until proven guilty, so
Of the
you're taking
crime.
his property, correct?
It's
With no conviction, right?
you take the tools that was used to commit the crime and impound them until the crime is determined. That's common practice. You don't give a drug dealer the drugs back after you catch it.
But does this not flip the presumption of innocence on its tail?
The drug dealer is presumed innocent as well. But
We're
you
not
take the
talking
drug-
about drug dealers.
This
We're
is
talking
this
about
is
the
consistent-
DNR.
This is consistent with the way we handle crimes. That's all I can tell you.
Okay, thank you.
Gentleman from the 51st, Dr. Tyler.
Will the chair yield, please?
Gentleman, continue to yield. Gentleman yields.
Just two questions. First question, does the treasurer oversee the process?
The treasurer
The treasurer's
oversees.
office?
The treasurer oversees the sale of the weapons once they're turned over to the treasurer.
Okay, so if they're
But
not
they're not turned over until the person is convicted of the crime and fails to pay the fine or absconds and doesn't pay what they're required to pay. But they're impounded until after that occurs.
Okay, so in the past, before this, if this bill should be adopted into law, I guess it would be sold off by the police department or the county or the state or something like that?
I think what the bill does is try to clarify who should be selling the property. In the past, I believe it was done. I think the purpose was to clarify and make this consistent with other instances in which weapons are seized and turned over to the treasurer.
Thank you very much. Thank you, Mr. Speaker.
Gentleman from the 63rd, Dr. Fulton.
Gentlemen, continue to yield.
Gentleman, continue to yield. Gentleman yields.
Yes.
On page 1, line 8, section B there, it says, if the accused is acquitted, the property seized shall be returned. So basically, if they're found guilty, they'll get the property back, shouldn't they?
If they're found guilty,
No, acquitted, not found guilty.
if they're acquitted, they get the property back. Yes.
So they would have to, if they're convicted, obviously they wouldn't, but if they are not, they get their property back. Is that the way I read that?
I'm sorry, I could barely hear you. Could you repeat
That on page 1, that whole paragraph basically deals with allowing them to get their property back as long as they're not found guilty, which is acquitted, an acquittal.
If they're acquitted, they get their property back. Yes.
All right, thank you.
Further members desiring to speak to the passage of the bill. Not question for the House is gentleman from 35th, Dr. Byrd.
Thank you, Mr. Speaker. Rule 49, my wife works for the Treasurer's Unclaimed Property Division.
To the extent So gentlemen, to the extent that this affects the funds that would be, or the disposition of this property by the treasurer's office, I don't believe that she would have a direct pecuniary interest or any particular interest to her personally, and therefore I don't believe you have a direct pecuniary interest in this bill. To the extent you would, it would be as a member of a class of more than 4 people, I would think, that would be there, employed there. So, gentleman will be directed to vote. Gentleman from the 7th, Delegate Ireland.
Thank you, Mr. Speaker. Permission to speak to the bill.
Gentleman may proceed.
Thank you, Mr. Speaker. Ladies and gentlemen, most of you know that life member of the NRA and own a number of guns and believe in the Second Amendment just about as much as anybody in this room. But I also know when I go to Colorado, which I have done a few times elk hunting, that if I'm not in compliance with the law in Colorado, I'm going to end up forfeiting my firearm, my sleeping bag, my pickup truck, whatever else I've got out there, and I'm going to get back to West Virginia just about as, I guess, on my thumb. Because Colorado is going to impound everything that I have that has to do with illegally taking an elk or a mule deer or an antelope or whatever. So I believe what we're doing here is exactly what we need to be doing with respect to promoting legally taking of our wildlife and not promoting illegally taking of our wildlife. If I'm caught spotlighting a deer, then I probably should be forfeiting my spotlight and my .30-30 rifle or whatever else. Now, if it turns out that I was really out there checking on my cattle, or maybe trying to take a coyote out of my calves, then I get all that back. And we actually amended the bill in judiciary to say that the DNR had to provide reasonable care for my firearms or my pickup truck or my spotlight while it was in their possession. So I think we're really doing exactly what we need to be doing with this bill. And our Second Amendment rights, I don't think, are being absconded. So I urge a green vote.
Further members desiring to speak to the passage of the bill before I recognize the gentleman from the 27th. Close debate. Gentleman from the 27th.
Thank you, Mr. Speaker. Let me just clarify, if I can, if you look at the bill and what we've done, there's very little change to the bill. So if you don't like the idea of impoundment and you vote against this bill thinking you're going to change that, you're not. All this bill really simply does is clarify who's supposed to sell these weapons once they're forfeited. And keep in mind there's a difference between impoundment and forfeiture. And we've added language to make sure if you impound something, you have to exercise reasonable care to protect the condition of it. That wasn't in the bill. You vote against this, you remove, and this bill goes down, you remove that reasonable care requirement that we take care of people's property when it's impounded. The only other thing this bill does is just clarify who can sell these weapons once they're forfeited. And so I think there's very little change, but it makes sense to have a standardized procedure that we follow anytime there's forfeited weapons, and that's to place it with the treasurer where they have a process to handle that. So therefore, I urge passage.
House, please be easy a moment.
You're watching the West Virginia Legislature on the West Virginia Channel. Today we bring you today's House floor session live. We are recording the Senate floor session, and we'll bring you that once the House has settled all of its bills on third reading. Right now the House is discussing House Bill 4279 relating to the disposition of seized firearms by the Division of Natural Resources. Also before the House, coming up, many bills on third reading. Also coming up, House Bill 4317, limiting factors in parenting plans, clarifying the court's consideration of fraudulent reports of domestic violence and child abuse in imposing limits on a parenting plan. Also coming up before the House, House Bill 4352, relating to selling of certain state-owned health care facilities by the Secretary of the Department of Health and Human Resources, requiring that the Secretary contract a consultant to submit a plan relating to the potential sale, renovation, or lease of facilities in regards to Hopemont Hospital, Jackie Withrow Hospital, John Manchin Senior Health Center, and Lakin Hospital. Also among the bills coming up before the House, House Bill 4463, permitting the practice of telemedicine. House Bill 4505, allowing Powerball winners to remain anonymous. And House Bill 4706, relating to county board regional meetings.
The House will be in order. So the gentleman from the 35th has provided some additional clarification pursuant to his request under Rule 49 to be excused from voting. And as I understand the facts, the gentleman's wife would be paid from the unclaimed property fund. And initially, it was our belief that it would be as a member of a class. But in light of additional information the gentleman has provided that his wife is paid directly from this fund, that division is, and we're unclear of the number of members, then we are unable to make a determination that it would be as a member of a class. And because it would perhaps have a direct pecuniary interest on her and indirectly you, or perhaps directly you, then the ruling of the chair would be that the gentleman, because we're not able to make a determination that it would be as a member of a class, the gentleman may in fact have a direct personal or pecuniary interest and therefore should be directed not to vote on this particular bill. Further members desiring to speak to the passage of the bill, the gentleman from the 27th has already closed up. Sorry. Therefore, the question before the House is the passage of the bill. Those in favor will vote aye. Those opposed will vote no. Clerk, prepare the machine. Has each member voted? If so, the clerk will close the machine and ascertain the result. That question, 94 ayes, 3 nays, 2 members absent, not voting, 1 member excused. The majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
Committee substitute for House Bill 4279.
Are there amendments to the title? No. Not the title is read by the clerk will be and remain the title of the bill. Clerk, please communicate the action of the House to the Senate. Request concurrence therein. Further bills.
Committee substitute for House Bill 4317, limiting factors in parenting plans.
Question for the House is the passage of the bill. Gentleman from the 15th, Doggett Foster, to explain the bill.
Thank you, Mr. Speaker. House Bill 4317 relates to limiting factors in parenting plans. It seeks to address parents who make fraudulent reports of domestic violence and child abuse. Currently, West Virginia Code 489209 requires a court to impose limits on parenting plans that has repeatedly made false reports of domestic violence or child abuse. The committee substitute for House Bill 4317 amends the code section referenced above by requiring court to impose limits on parenting plan that has made 1 or more fraudulent reports of domestic violence or child abuse. I urge passage.
Are there other members desiring to speak to the passage of the bill? Not the question for the House is the passage of the bill. Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has each member voted? If so, the clerk will close the machine and ascertain the result. On that question, 89 ayes, 7 nays, 4 members absent not voting. Majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
Committee substitute for House Bill 4317.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. Clerk, please communicate the action of the House to the Senate and request concurrence therein. Further bills.
House Bill 4324, authorizing information sharing by Workforce West Virginia.
Question for the House is the passage of the bill. Gentleman from the 27th delegate shot to explain the bill.
Thank you, Mr. Speaker. House Bill 4324 is a bill that was requested by Governor Tomlin. The bill simply updates existing law to make it consistent with the change in the law at the federal level. By way of background, this section of the code enables Workforce West Virginia to communicate information to certain entities, such as the United States Department of Health and Human Resources, the Division of Labor, and other such agencies. Workforce West Virginia receives certain information quarterly from employers within this state via reports they are required to submit. The statute also permits Workforce West Virginia to share information with agencies responsible for employment and training, including those charged with administration of what was formerly known as the Workforce Investment Act, which is now simply revised by this bill to reflect the new name of that federal statute, the Workforce Innovation and Opportunity Act. This act was passed by a wide bipartisan majority of the United States Congress. One of the main goals of the Workforce Innovation and Opportunity Act is to ensure that employment and training services provided by a state's core programs are coordinated and complementary so that job seekers acquire skills and credentials that meet employers' needs. It strategically coordinates core federal and state programs related to employment and training services, education and literacy, vocational rehabilitation, and more. This amendment is required to comply with the Workforce Innovation and Opportunity Act so that the state may continue receiving federal workforce training funds from the U.S. Department of Labor. Mr. Speaker, I urge passage.
Are there other members desiring to speak to the passage of the bill? Not the question for the House is the passage of the bill. Those in favor will vote aye. Those opposed will vote no. The clerk prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, 98 ayes, 0 nays, 2 members absent not voting. Majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
House Bill 4324.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. Clerk, please communicate the action of the House to the Senate and request concurrence therein. Gentleman from the 22nd, Delegate Eldridge.
Thank you, Mr. Speaker. If I'd have been in the chamber and in my seat, I would have voted in the affirmative on roll call 254.
Without Jackson, gentleman's preference, had he been present, will be reflected in the journal. Gentleman from the 22nd, Delegate Moffitt.
I was also out of the chamber with my fellow delegate from the 22nd and had the same affirmative vote.
Without Jackson, gentleman's preference, had he been present, will be reflected in the journal. Further bills.
House Bill 4346, relating to bear hunting and offenses and penalties.
Request for the House is the passage of the bill. Gentleman from the 27th, Delegate Schott, to explain the bill.
Thank you, Mr. Speaker, and thankfully this is the last DNR bill. It addresses bear hunting, and that's B-E-A-R rather than B-A-R-E. The bill makes various changes. Some highlights include treating the training of dogs on bears as hunting for purposes of making the hunting laws applicable, prohibiting the baiting of bears, and enlarging the examples of what includes bait to include sugars, scent attractants, and other edible enticements. It updates depredation permit procedures when the DNR can relocate or permit hunting of a bear causing property damage. It also revises provisions related to payment of bear damage, which are claims for damage to real and personal property. It includes limiting the payments to the amount of the deductibles if that property is insured. And finally, and surprisingly, it actually decreases the criminal penalties and jail time for violation of bear hunting laws. These laws were put into effect when bears were scarce and the population has greatly increased over the years. Thus, the DNR felt it was time to lower these penalties. Mr. Speaker, I urge passage.
Are there other members desiring to speak to the passage of the bill? Not the question for the House is the passage of the bill. Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, 94 ayes, 3 nays, 3 members absent not voting. Majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
House Bill 4346.
Are there amendments to the title?
Delegate Schott moves to amend the title.
Question for the House is the adoption of the title amendment. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. Declare the title amendment adopted. Gentleman from the 58th.
Thank you, Mr. Speaker. I move the bill be made effective from passage.
The gentleman from the 58th moves the bill be made effective from passage. All those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? Gentleman from the 10th here. If so, the clerk will close the machine and ascertain the result. On that question, 98 ayes, 0 nays, 2 members absent not voting, 2/3 of the members elected having voted in the affirmative, I declare the bill effective from passage. Clerk, please communicate the action of the House to the Senate and request concurrence therein. Further bills.
Committee substitute for House Bill 4352.
Question for the House is the passage of the bill. Gentleman from the 35th, Delegate Nelson, to explain the bill.
Thank you, Mr. Speaker. In the way of some background, the state currently owns 2 hospitals and 4 nursing homes. And this particular bill has really, I guess, been through the ringer, if you will. It came through the Health Committee. It went through a public hearing, went through the Finance Committee, and has changed in its form a number of times. What it does is it will authorize the Secretary of the DHHR to engage a consultant to prepare a plan for the sale or renovation or leasing of the state's 4 owned nursing homes. The plan is to include timetables. The plan is to include minimizing the effects or any effects on state employees in these homes. It's meant to look at strategies to minimize the effects of the patients or the residents in these homes, the most critical of this whole. And then it's meant to look at the strategies to reduce the cost or potential increased revenues of operating our nursing homes. The report is to be completed by November 30th of this year and reported to the governor as well as the Joint Committee on Government and Finance. Final action of anything that's proposed in this plan must come back to this body. Now, in the way of some information about these 4 homes, the average age is 96 years of these facilities. The youngest one's 79, the oldest is 116 years. These 4 facilities contain 152 beds. 452 beds. Only 273 of them are filled right now, 60%. It ranges from the low of 43% in one of these homes to a high of 78%. Just 4 years ago, the occupancy was at 70%. So in 4 years, our occupancy in these 4 state-owned facilities has dropped 10%. And I did say that the average age of these homes is 96 years old. They do employ 525 state employees. It costs approximately $31 million to operate these 4 homes. Revenues are only $24 million. Annually, the state loses our taxpayers lose in excess of $7 million. Where are these 4 homes located? Lakin, Mason County. Mansion, that's Fairmont or Marion County. Withrose down in Beckley, and Hopemont is in Terra Alta, Preston County. This bill does not affect the 2 hospitals that we own. In 2011, there was a study, another study, that was done looking at the need for repair of these facilities. Again, 2011, 5 years ago, identified nearly $54 million of repairs for these homes. In fiscal year 13, a PERD report was done. Finance Committee saw copies of this. And again, it pointed out in particular that the Jackie Withrow home down in Beckley spends in excess of $2 million more than the other homes just to operate on an annual basis. That also happens to be the one home that's occupied at less than 50%. I think this is a prudent way of looking at some state-owned properties and where we need to go going forward. And again, it is a plan to look at the potential sale, renovation, or leasing and come back to this body with a recommendation of where we need to go. Mr. Speaker, I urge passage.
Are there other members desiring to speak to the passage of the bill? Lady from the 46th, Doggett Smith.
Thank you, Mr. Speaker. I'd like to speak in opposition to the bill. I really hate this bill. I hate everything about it. It's better than it was, but it scares me to death. Because what's going to happen, we're going to study the sale of these hospitals. What's going to happen to the land and the buildings and the patients? All 443 of them at these 4 hospitals. We don't know. We're going to study it. I've never really seen a bill that said study something. We usually have study resolutions. Is the state going to continue to supervise these 443 patients? We don't know that. I do know this. There is another state hospital in my district, and I can tell you our patients, and I'm sure these others, are well taken care of. They're taken care of like family members. I've represented many of them. I've been at that state hospital all my life. Are they going to continue to be well taken care of? And is the state going to supervise how well they're taken care of? You can't imagine how disruptive it was to my county when the state moved a state hospital. We moved it from downtown Weston to, I don't know, a mile or 2 away. There were so many employees there, hundreds, and they all went over town to eat lunch and to buy things. And the restaurants where they ate every day closed down. And the stores where they shopped closed down, and now Weston's a ghost town because we moved a state hospital. It's just a couple of miles away, but too far to walk downtown. It was devastating to our community. It was extremely disruptive. Another thing that I'm really afraid of, someone who I really fear, is the consultant. I spent my career as a professor. I've said that before, and I was a consultant in many cases. I was an expert witness in a lot of cases. I know the power of a consultant. I know how easy it is to defer to the consultant on on a hard decision and just defer to the decision of the consultant. Oh, I fear this consultant and her power to make recommendations about our communities. I also am not crazy about the idea. I bet we hire somebody from Atlanta or New York. Because what? We don't have smart enough people here in West Virginia to be consultants and make these difficult decisions. I wanted to talk to the secretary about that, but she didn't manage to come to the public hearing or most of the committee meetings about this bill. I've had some experience with this kind of stuff in another state. Experience when they privatized state employees. Now this bill calls for studying what will happen to them. But I know what happened to the other employees I'm referring to, the state employees who lost their state jobs. They lost their state retirement. They lost their state insurance. They got paid the amount of state retirement they had in the system, and it wasn't enough. My best friend was one of these employees. She lost her state job. I asked her about a year ago, Kim, when are you going to retire? She said, I can't. I'm not a state employee anymore. I can't ever retire, Peggy. She had a heart attack about 2 months later. She doesn't have state retirement, and she doesn't have state insurance, and she's in a terrible shape. There's 770 state employees at those hospitals we're talking about, and there are 1,549 at all of our state hospitals. We don't have a problem with them. Those patients are well taken care of. The state's going to have to pay for their care anyway. I urge you, please think about what I'm telling you. This bill is a study, and it'll turn into something more, and it'll turn into something none of us like. There's no need for this bill, and it should fail today. Please vote red.
The gentleman from 53rd, Douglas Smith.
Thank you, Mr. Speaker. Will the chairman yield?
Gentleman yields.
Thank you. You said there was we lose $8 million a year on these facilities. Is that correct? Or $7 million? What was
Yeah, over the last 4 years, it's averaged $7 million.
Is that over 4 years or just
No,
a year?
each year. Each year it's average. It's been a little bit higher. It's been a little bit lower.
So all 4 hospitals are losing money?
Currently, yes.
How much each one, do you know? I know there's 4 of them. I'm just curious. Hopemont is in my...
Hopemont in fiscal year 15 lost almost $2 million.
Okay, so each one of them's losing about $2 million a year. And is it because of, I'm assuming, probably lack of patients, the facilities with lack of patients, because that's where they make their money from, correct?
That's part of it. I mean, Hopemont, for instance, 73% occupancy.
You know why that is?
Down from 96% 4 years ago.
You know why that is? Because they got a freeze on admittance because they can't get help. They can't hire staff to staff it, so they've had to reduce their admittance because they can't acquire staff because basically they don't make any money is what the problem is. And from what I believe, if you check into it, that's the problem with all 4 hospitals is the staffing because like I said, they have a limit of 60 patients in hospital or in Hopemont right now because they just don't have the staffing for anymore. So that is, it's kind of unfair to them to the hospitals to say that they're losing money when it's not really their fault. It's because as a body we're not paying our medical staff or facilities enough money to. But I wanted to know if all 4 of them was. Because I was under the understanding that it was just one of them that was really losing money. So, all right, thank you. Permission to speak for the bill.
Gentleman may proceed.
Like with the gentlelady from the 46th, Hopemont State Hospital was in my district. It's the largest employer in the Tarrata area where I'm from, and to say it's near and dear to my heart would be an understatement because my stepdad was a TB patient there years ago, and my mother was a nurse's aide, and that's where they met. And then got married, and then my mother worked there, and then my stepdad started working there, and then he went and got his nursing degree while he was working there and became an LPN. And this is the first job I had when I graduated from high school. I went to work at Hopemont State Hospital, so it is it has a lot of history, and it's very important to our area because, like I said, it's the largest employer in my area or my former area. But so I'm going to have to vote against this. I understand where we're coming from. It's an old building, but this building here is probably older than most of the hospitals, and look at it. It's this one was taken care of, and that's what a majority of the problem is. We don't take care of our facilities. At one time, Hopemont was a state hospital. The TB state TB clinic. It was a prison. It had a state farm that raised all the vegetables and had a dairy with and pasteurized milk for the prisons in the state. And I've seen it over the years just continually dwindle and dwindle and dwindle because we just don't put any money into it. So, you know, it breaks my heart that's come to this. I understand the financial part of it, but most of it's our own fault because we failed to take care of our employees and the buildings. You know, this year we have, the last couple of years, a budget deficit, but there was many years when we had a surplus that we could have been taking care of these facilities, and we failed to do so. So now the hard-working people at these facilities is going to have to pay the ultimate price at the end, I'm afraid. So for these reasons, I'm going to vote to reject this bill.
The gentleman from 13th, Delegate Cadle.
Thank you, Mr. Speaker. Would the chairman yield?
Gentleman yield. Gentleman yields.
Mason County happens to be in my district, the Lakin facility, and I'm sitting here thinking, I thought they built that Lakin facility. I know there were some buildings on the property that were built in a 28, 30 period, but I was thinking that the hospital, it's a ground floor, one level. They built that in the 70s, I do believe, because the big buildings wouldn't meet code and it was going to cost so much to change them over. But it's a ground level facility, and I don't think it's that old. What kind of information do you have?
I have information that it's 79 years old, and to the extent that they've had an addition or something, maybe that's what the gentleman's referring to, but the main building itself is 79 years old.
There might be a part of it 79 years old, but you know, where they keep the patients, because I've been in it, and it's not that old. What's their percentage of people in there?
Lakin in the fiscal year 2015 was 78% occupied, down from 84% just 4 years ago, and it lost $1.8 million.
All right. Well, thank you, Mr. Permission to speak to the bill.
Gentleman may proceed.
Thank you. Lakin, like I say, Lakin's in my facility or in my district, and you know, I know those people personally that work there. They make $16,000, $18,000. They're scared to death they're going to lose their job. We don't have anything in Mason County. We just lost the power plant. You know, I can't vote for this. I'll tell you exactly, in my opinion, the problem with the bill. It does not address management. We have a management problem, not a problem with anything else. The state does a horrible job at managing everything it does. I think we ought to look at some management, and you know, all those people in the Lakin facility are very handicapped, and I know that the nurses and stuff take good care of them, and they're all very happy. When you go there, they all seem to be very happy, and I would sure hate to see them lose their home. Thank you, Mr. Speaker.
Lady from the 50th, Delegate Longstreth.
Thank you, Mr. Speaker. I know we've talked about this bill, and to the chairman, I appreciate you taking off the agenda for one day and trying to make some changes. But I am going to speak against this bill for several reasons. These hospitals and nursing homes are not a huge factor in our debt. They do need some help, but we have always protected our state employees and our state hospitals. We had a PERS report that only really talked about one hospital that was in critical need. The other three had really nothing against them. And in my area, we have the John Manchin Clinic, and it does a wonderful job. It employs not only people in our community, it serves various other things that they do. We have a nursing home, We also have an outpatient clinic, and that outpatient clinic does serve hundreds of people in the whole, not only Marion County, in the other counties around us. They come there because they cannot afford to go anywhere else. They do provide an excellent service for those people. The other reason is not only a nursing home, not only an outpatient clinic, it also serves people with Meals on Wheels, and into our senior centers, they provide the food on a daily basis. So that's quite an activity for a particular, what you want to call a nursing home, hospital. They do many other entities. My concern also with this is, what do we do with those patients? These patients can't afford to go to private nursing homes because that's why they're there. It's based on their needs. What do we do about the loss of employment and loss of jobs? What do those people do? And did we really talk about what do they do for retirement? They said that we were going to try to be very careful what we do with our employees if it does close, but we haven't talked about, do they get retirement? What kind of benefits? Will they or will they not get those? We're going to pay $200,000 for someone to come in and look at these hospitals. Maybe we should use that $200,000 and put it into the renovations of some of these hospitals. So for those reasons that I'm concerned about the patients, not only the patients, but the employees that we do have, and the function that I know that John Manchin Clinic does, I will vote against this bill. Thank you, Mr. Speaker.
The lady from 43rd, Delegate Campbell.
Thank you, Mr. Speaker. Would the distinguished chairman yield for a question?
Gentleman yields.
Thank you. The 4 facilities that we're talking about, these are nursing homes?
That's correct. There's not a hospital in this, in these.
Are these duly certified nursing homes?
Duly certified, maybe.
That means that they can bill Medicare for skilled services, or they can bill Medicaid for intermediate care.
I can't answer that.
My question is related to, I saw the printout of how many days were billed as skilled services for the facilities around the state compared to these 4 facilities, which they billed 0 to the federal government for skilled services. If they are licensed to provide skilled services, that's usually how nursing homes sort of are able to survive, by being able to provide a skilled level of care. So that's why I was interested in knowing if they were skilled. So you don't know if they were duly certified where they could bill Medicare dollars.
I'd look to your experience.
Okay. Mr. Speaker, at the appropriate time, I'd like to speak to the bill.
Lady, may proceed.
Thank you. I have very great concern about this bill. One question is, I just asked if they were a duly certified facility. If you go around the state and see what has happened in nursing homes in the last 10 years, providing short stay treatment, skilled services for IVs, wound care, physical therapy, fractured hips, things like that. That's what duly certified skilled facilities do. And if these facilities actually have that capability of doing that, and they haven't been doing that, then that's something that I think we need to look into. If they had that ability, probably the patients where they've lost their census has been going to a facility that will actually do that, where they can utilize their Medicare benefit. So I have concerns about that. And once again, as it was mentioned, we talked about the number of beds. And I know sometimes we can disconnect ourselves when we call people beds. These are individuals. These are people like you and I, our moms, our dads, our aunts, our uncles. These are the disabled. These are our senior citizens. And the people who care for them are the working people of West Virginia. And I think we really need to take great caution in knowing, did we do our due diligence and trying to do everything we can to save these facilities? And if they are duly certified, I think we need to significantly look into allowing those individuals to use their Medicare benefits and be able to go to those facilities for short-term stay. Mr. Speaker, I will have to vote against this legislation. Thank you.
John from 52nd, Delegate Schaefer.
Thank you, Mr. Speaker. I stand up in opposition to this bill. Hopemont Hospital has been a part of Preston County for over 100 years. This past summer, the delegate from the 53rd and our state senators and I met with the administrators and employees at Hopemont Hospital. The chairman talked about the 60% capacity of the hospitals being used. The administrators and the employees begged us for help. They needed help because they needed more employees. They were running at almost a 30% reduction in force because they could not find people to become employed because of the amount that the state paid. The amount that they were paid and to be drug tested. The beginning wages at Hopemont Hospital are just about what a person can get on public assistance in West Virginia and never have to be drug tested. So it's like the administrators and the employees said, why do people come to work, make the same amount they can make on public assistance, and have to be drug tested? You know, these places were set up for failure. As the lady from the 50th said, we're going to spend $200,000 on a consultant. And he has to have that report to the governor in 9 months. Seems like an awful lot of money to be spent in 9 months. I know the other hospitals to the other counties are just as important as what Hopemont is to Preston County. It's the backbone of Terre-Haute. Several people got their start in Preston County working as teenagers and young adults at Hopemont. I would ask that we bind together, just as the delegate said from the 32nd the other day when we talked about the EPA standards and fighting against them wanting to shut down our wood burners and pellet stoves. I think it's time we take a stand, and we take a stand and say, no, we're not going to close down these hospitals. We're not going to put our senior citizens and people that need help out in the cold. Let's take a stand by pushing the red button and rejecting this bill. Thank you.
John from 29th, Doug Moy.
Thank you, Mr. Speaker. Does our chairman yield for a question?
Gentleman yield. Gentleman yields.
I apologize, but I should have asked this in committee. Does this bill, will the study provide for an economic impact study for the areas affected by the closures, if that should happen?
Not specifically, no. As you can read in the bill, there are minimum standards that deal with the employees, the patients, and the facilities. A minimum standard, as well as the management.
All right, thank you, sir. Mr. Speaker, I'd like to speak to the bill.
Gentleman may proceed.
Thank you, ladies and gentlemen. I happen to know that some of the residents in Jackie Withrow Hospital have been there a long time and have family members in there. They've come to call that facility home. And the staff there have come to call the residents there their family. Southern West Virginia has lost far too many jobs already, and I cannot support legislation that will cost Raleigh County any more jobs. Thank you.
John from the 50th, Doug Manchin.
Continue to yield.
Gentleman yield. Gentleman yields.
I note in reading at the bottom of page 2 that the hiring of the consultant as described in subsection A of this section is not subject to the purchasing requirements of Article 3, etc. Can you explain to me why a $200,000 contract is not subject to our normal purchasing requirements?
Okay. I think one of the main reasons that specific language was not included was because of the time frame of having this report back to us and the need to answer all of the critical concerns that have been voiced here today. We cannot continue to let these 4 facilities go unanswered.
Well, is there anything in the statute that requires them to study and report back on what it would take or why we're not having full utilization of the facilities?
That is something that I would expect to come out of this report and plan.
But I don't see it specifically set forth like all the other things that we've talked about already.
Oh, again, we set out, or the bill sets out minimum standards. Feedback from, and number 4, feedback from relevant internal and external stakeholders. So that is quite broad across many spectrums.
Permission to speak to the bill when it's appropriate.
Gentleman may proceed.
I want to point out to the members that what is also created in this bill now, okay, not when we get to the end and once we've got a report. What's created now is a healthcare facilities transition fund. I suggest to you that the decision's already been made and that this is just a matter of a self-fulfilling prophecy and a study, and therefore I'm voting no.
Gentleman from 56, Delegate Howe.
Thank you, Mr. Speaker. Will the Finance Chair yield?
Gentleman yields.
Reading this bill, if I'm reading correctly, it doesn't say we're closing these hospitals. It's looking at selling, leasing, or renovating. Is that correct?
That's correct.
If we were to sell these hospitals, I'm assuming whoever would purchase these would want to continue to run them to make a profit.
Well, again, this body would have to legislate or take action on whatever may be recommended in the plan. Anything. Expending extra dollars for renovation, entering into leases, or a possibility of sale. But this body would have to act again.
Okay. If they were sold to a private entity, does the private sector usually not pay more to their employees in the healthcare industry than what the state does?
You know, I can't answer that directly, but I think that the opportunity to earn more and be outside of maybe certain restrictions of state payroll, yes, that opportunity would be there.
So if the state was to sell these, the employees that work in these hospitals could actually get a pay raise?
That is a great opportunity that would be available, yes.
Thank you.
Further members desiring to speak to the passage of the bill before I recognize the gentleman from the 35th. Delegate Caputo. Gentleman from the 50th.
Thank you very much, Mr. Speaker. I certainly rise in opposition to this bill, and I want to first talk about some comments about the possible sale of these facilities and the employees remaining there and working there and making more money. I think that is just absolutely false. I think it's absolutely impossible, and I think it's misleading. I think if these were sold, what would be sold would be the beds of these facilities. And these beds could be located anywhere in the state of West Virginia. So please, however you vote, don't think for 1 second that if we allow the sale of one of these facilities, that it would be undoubtedly remain in your district and some private entity would take it over and give all these people wonderful jobs with wonderful benefits. Because that just ain't happening. I'll tell you that right now. You know, I also want to echo some of the comments of the gentle lady from Lewis. I've been here a day or two, and most studies come via a resolution. I don't know that I can recall one coming via legislation. Maybe it has. I just can't recall it. But one thing I do know, it says the secretary shall contract with the consultant. And there's no doubt about it, usually the person who's ordering the study and paying for the study usually gets the results they want. I'm not sure why we want to single out these facilities, but I'm very concerned about those 452 beds. I'm very concerned about the people who are in them. I'm very concerned about the employees who take care of them every day. Something smells bad about this legislation. There's no question in my mind about it. I think someone's mind is made up, and I think that they want these places closed. And I think they need a study to back up what their wishes are. Now, I can't speak for every one of these facilities because I only have one of these facilities in my district. And Delegate Longstreth talked briefly about what they do. They take care of people that can't take care of themselves. They take care of people who has no family. They take care of the poorest of the poor. This is home for those people in Marion County. This is home. They administer primary care to people who can't get care otherwise. And they prepare tens of thousands of meals on wheels at a cost of $2 a meal. $2 a meal. That feeds our seniors in Marion County on a daily basis that otherwise might not be able to get a nourishing meal. That's what my facility does. And I find it extremely troublesome, and unless I'm missing something, I'm looking at the 5 sponsors of this bill, and not one of them represents a district where these facilities lie. I find that troubling. I find that very troubling. I would think that the delegates who represent these districts would know best what these facilities do, and we would look to them for guidance. I can't speak to the one in Mason or the one in Preston, but I can speak to the one in Marion. And I think we should heed to that advice. And I can't remember who said it, but someone talked about the economic ramification of if these facilities close. Are we going to look at that? Are we going to talk about what it does to that district? No. No, the answer is no. If the decision is made to close it, there's no discussion about the economic impact of that district. Oh, those beds will be filled. Those beds will be filled, but they won't be filled in the districts where they are right now. You can take that to the bank. They'll be spread out all over West Virginia, and I dread to think where those folks in Marion County and Preston County and Mason County will wind up. I dread to think that. I think we need to vote no on this bill. No disrespect to the Finance Committee or the Health Committee or the sponsors of this piece of legislation, but I think we need to scrap this bill. And we need to have some good discussion with the delegates that live in these districts and represent these districts and decide what's best for the people. Not the bottom line, but for the people. Those folks who can't take care of themselves, those folks who can't afford to feed themselves, and those folks who have nowhere else to go. Please vote no.
Chairman from the 27th, Delegate Ellington.
Thank you, Mr. Speaker. The intent of this bill originally was to look at selling possible state nursing homes to see what would be better for that, and we had the public hearing for that. 3 of the facilities out of the 4 were doing better than the 4th one. After the public hearing, the concern was we have the patient, I mean, we did have this concern ahead of time, but concern for the patients, their families, the employees, that all of these are people that depend on those centers. However, I think most people would agree that the state running certain things may not be the best way to do that. All of these facilities are aging in certain degrees. The maintenance of those are costing a lot more. The concern was, is this something that's very efficient? The purpose after the public hearing was to move this to a study so that the Secretary may investigate this and look at the best ways to take care of the patients, the employees, and to see if all 4 or just 1 out of the 4 facilities need to be modified. They were also looking at either selling it, renovating it, leasing it, looking at the different options, and taking into account each of the concerns for the patients too. Now, Mr. Speaker, if we're having a big issue on looking at these issues here, where, in my opinion, one of the facilities really probably needs to be addressed, we're going to have a very tough issue with the rest of this session, because we're not going to be able to deal with our problems in this state if we can't make some of the hard choices. It is a hard choice, but I think the sponsors looked at this as something that we have to start with. It was a very obvious concern on our part from the state running these facilities. Thank you, Mr. Speaker.
Gentleman from 35th, Doug Nelson, to close debate.
Thank you, Mr. Speaker. I mean, gosh, it just really troubles me. All we hear is fear. Fear. If one thing that this does, it puts in front of others, let's look at these and let's care about the patients and the employees. And for once, it'll get something done within a time frame. But no, I hear fear. Fear. Daggone it, let's get off our tails and do something that's right. We cannot continue to kick the tire down the road. This doesn't say that things will be sold. It says that's a possibility. It says it's a possibility we could renovate. This doesn't address any hospitals. This is for nursing homes. Each of these areas also have private nursing homes in their areas. And in particular, in Marion County, there's at least 4 that have occupancy levels all exceeding 80%. And I believe a couple of them are at 100%. What I can see and what is the intent, this bill provides minimum standards that a consultant will report back to. And to address the gentleman from the 53rd, it will deal with management and the lack of any oversight that we have had. It will discuss the age of these facilities and the potential needs. We heard 4 years ago, at that time, that it would take at least $54 million. You know, we've got one hell of a budget situation right now. Now's not the time to continue to kick it down the road, but this study, it's going to cause some action and realize and give us the answers that this body would then have to act on. How much will it take us to, one, redo these facilities, to really care about our patients? The patients are first, the elderly. There are a lot of employees here, but that's one of the things in the study. Let's look at the whole impact on our employees. You know, these facilities, as it's been brought to my attention, were initially built for other purposes. They weren't built to house our elderly. They weren't built to house our elderly. The gentlelady mentioned about various billing practices. I would fully expect that this study would come out and recommend if there's billing discrepancies or ways we can improve that, it will be addressed. Many times, again, we have heard that issues a report, a study, and points out things. I think that this is taking the step of really pushing us forward and taking an action. And again, for the benefit of our elderly, in providing the best service to those that need it, Mr. Speaker, I believe that, or I know that this is the best way that we can move forward with this, and I urge complete passage and a green vote from everyone. Thank you.
The question for the House is the passage of the bill. Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? So the clerk will close the machine and ascertain the result. On that question, 53 ayes, 45 nays, 2 members absent, not voting. Majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
Committee substitute for House Bill 4352.
Are there amendments to the title? No. Not titles read by the clerk will be and remain the title of the bill. For what purpose the gentleman from the 32nd Delegate Perry seek recognition?
Unanimous consent to turn to the second order of business for a purpose of introduction.
Without objection, gentleman may proceed.
In the North Gallery, it's my distinct pleasure today to introduce the Executive Director of the West Virginia Secondary Schools Activities Commission, and the Assistant Executive Director, Mr. Bernie Dolan, Mr. Ray Landry. If they'd stand in the House, please make them welcome.
Further introductions. Gentleman from the 13th, Delegate Cato.
Thank you, Mr. Speaker. My vote didn't register. I hit the red button. Huh? Did? They said it didn't. I don't know.
So, gentlemen, you were in your seat and did push the button. And, okay. Your gentleman's vote will be recorded in the negative. Whether if it may already be, but if it is not, it'll be recorded in the negative. It was the gentleman's vote was not recorded, and therefore it will be. Gentleman wishes to record it in the negative. Is that correct? Gentleman's vote will be recorded. Gentleman for the 51st, Dr. Chaba.
Thank you, Mr. Speaker. If I were in my seat on the vote on House Bill 4346, I would have voted in the affirmative.
Without objection, gentleman's preference, had he been present, will be reflected in the journal.
Mr. Speaker, also on the amendment on SB 10, I would have voted in the negative.
Without objection, gentleman's preference, had he been present, will be reflected. Gentleman from the 58th, Delegate Coles.
Thank you, Mr. Speaker. Subject to announcements, I move the House stand in recess for 30 minutes.
Other announcements. Gentleman from the 13th, Delegate King.
Mr. Speaker, I hate to stand up again, but you know, I live a dangerous life, always have, like challenges. And I've got some raw milk down there in my office. I got 2 gallons of it, and anybody that wants to taste raw milk is welcome to come down and get some. And if I run out, I'll bring more next week. Thank you.
Further announcements. Not the gentleman from 37, Delegate Pushkin. Not the question for the House is the House. The gentleman's motions that the House stand in recess for 30 minutes. All those in favor will say aye. Those opposed, no. Spirit of it, the ayes do have it. House stands in recess for 30 minutes.
You're watching the West Virginia Legislature on the West Virginia channel. While the House takes about a 30-minute recess, it still has about 5 bills to go on third reading. The Senate is also in recess right now, but we will bring you today's Senate floor session as we recorded it earlier today.
The Senate will come to order. All those not having privileges of the floor, please vacate the chamber. Those in the gallery and those on the floor will please rise as we are led in prayer by Pastor Ladina Teets of Brookside Church of the Brethren in Aurora, West Virginia. Please remain standing after the prayer as the Mountaineer Challenge Academy Honor Guard leads us in reciting the Pledge of Allegiance. Pastor?
Let us quiet our hearts and minds as we go before the Lord. Heavenly Father, we thank you for this great state of West Virginia. We thank you that we have men and women willing to serve. Dear Lord, we ask you to give them the courage and the boldness and the wisdom that they need to move this great state forward and to do as the people have elected them to do. Dear Lord, we thank you for your Son, in whose name we pray. Amen.
Thank you, Pastor. And again, please remain standing for the presentation of colors.
Join me in honoring our flag as we recite the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Be seated. Reading of the journal.
West Virginia Legislature, Senate Journal, February 28, 2016. The Senate met at 5 p.m.
The Senator from Raleigh requests unanimous consent that further reading of the journal be dispensed with. The journal be approved. Is there objection? Chair hears none. Further reading of the journal is dispensed with. The journal is approved. Introduction of guests. On behalf of the Senate, it's my pleasure to welcome our honorary pages for the day. Please stand and be recognized as your name is called. As guest of the Senator from Upshur, Trevin Kreitz. As guest of the junior senator from the 17th, Jesse Riley. As guest of the senator from Preston, Noah Gonzalez, William Broshert, and Torrance Adkins. As guest of the senator from Greenbrier, Cole Basile and Caleb Gano. And as guest of the senator from Boone, Hannah Walden, Michaela Toppins, Emily Cadd, Joshua Adkins, and Isaac Lucas. Let's give our pages a round of applause. The senator from Jackson. Are there further introductions? Senator from Greenbrier.
Thank you, Mr. President. On behalf of the Senator Fayette and myself, we're happy to have with us today accompanying Cole Basile, our page, his father, Frank Basile. They're from Peterstown. He's in the South Gallery. If he'll please stand, the Senate make him welcome. And also on behalf of Caleb Cano, his parents, Bobby and Delinda Cano, who are possibly seated in the South Gallery too. I'm not sure. If they'll stand, the Senate make them welcome, please. Well, they're in it.
Senator from Wayne.
Thank you, Mr. President. On behalf of the Senator from Cabell and myself, we have two people here today. One is accompanied by Corey Dennison. The Spencer Hanna, a student at Marshall University, and Phoenix Huron, a student at St. Joseph High School. Would they stand?
Senator from Boone.
Thank you, Mr. President. On behalf of the Senator from Logan, we're very pleased to have in the South Gallery the chaperones of the pages from Hamlin pre-K through 8. Fred Curry, Jill and Greg Lucas, and Michelle Toppins. If they would stand, and the Senate make them welcome.
Further introductions. The Senator from Upshur.
Thank you, Mr. President. On behalf of myself and the Senator from Nicholas, I'd like to welcome the parents of our page, Trevin Kreitz, Eric and Jennifer Kreitz, and they're up in the North Gallery. If they would stand and the Senate would please make them welcome.
The junior senator from the 17th.
Thank you, Mr. President. On behalf of the senior senator from the 17th, we have the father of one of our pages, Mike Riley. He's sitting in the North Gallery. If you wouldn't mind standing, Mike, and let the Senate make you welcome.
Senator from Cabell.
Thank you, Mr. President. On behalf of my senior senator from Wayne, it is my pleasure to recognize two dedicated public servants from here in Kanawha County. That would be Jeannie Chandler and Mary Beth Abbott. Would you stand and make the Senate let you feel welcome?
Further introductions. Senator from Preston.
Thank you, Mr. President. I have several introductions this morning. Seated in the North Gallery, we have students and chaperones from Preston High School. I know that we had the FFA and political science students earlier. They might be waiting in the back for the presentation of the resolution, but the ProStart students who are dressed in black and served us the delicious buckwheat breakfast this morning are back there. On behalf of the Senator from Taylor and myself, we'd like to make them welcome. Please stand and be recognized, and the Senate make them welcome. Also, Mr. President, seated in the North Gallery, we had some visitors last night from the Andrea family from Crown Point, Indiana. They were traveling with Janie Lou White, the Senior Center Director from Preston County, and came into the chamber. We had a nice long conversation with their homeschooled children. And we'd like to recognize them and welcome to the great state of West Virginia. Would you please stand and be recognized, and the Senate make them welcome. Also, Mr. President, seated in the North Gallery are Robbie Baylor from the Preston County EDA and a couple members of the Preston County Farm Bureau. Philip Gregg, I see right there. If they'll stand up, and we'll make them welcome. We have a lot of people from Preston County today. Now, this one I would like to say is on behalf of the Senator from Taylor and myself, but it's actually on behalf of everyone in this chamber. And as you noticed, we had the presentation of colors this morning from the Mountaineer Challenge Academy. We have several pages from that institution today. But seated in the North Gallery is the admissions recruiting coordinator for the Mountaineer Challenge Academy. And the reason I say that it has to do with the entire state is because they have students from all over the state. They have a wonderful, successful program up there, and we wish them all the best. And will Diana Trickett please stand and be recognized, and the Senate make her welcome.
Further introductions. Communications from the House.
The Clerk of the House announced the passage by that body of engrossed committee substitute for House Bill 2110 relating generally to the tax treatment of manufacturing entities.
Message to be received, bill be referred to the Committee on Finance.
Engrossed committee substitute for House Bill 2205 creating the crime of prohibited sexual contact by a psychotherapist.
Message to be received, bill be referred to Committee on Judiciary.
Engrossed committee substitute for House Bill 2801 permitting county commissions and municipalities to designate areas of special interest which will not affect the use of property in those areas.
Message to be received, bill be referred to the Committee on Government Organization.
Engrossed House Bill 2960 permitting county boards of education to develop emergency preparedness drills in schools.
Message to be received, bill be referred to the Committee on Education.
Engrossed committee substitute for House Bill 4237 supporting and strengthening Families Act.
Message to be received, bill be referred to Committee on Judiciary.
Engrossed House Bill 4299 increasing the amount volunteer fire companies or paid fire departments may charge for reimbursement.
Message to be received, bill be referred to Committee on Government Organization and the Committee on Finance.
Engrossed House Bill 4315 relating to air ambulance fees for emergency treatment or air transportation.
Message to be received, bill be referred to Committee on Banking and Insurance, then the Committee on Finance.
Engrossed House Bill 4321 relating to tax credits for apprenticeship training and construction trades.
Message to be received, bill be referred to Committee on Finance.
Engrossed committee substitute for House Bill 4330 relating to make unlawful to take a fish, water animal, or other aquatic organism from state waters to stock a commercial pond or lake.
Message to be received, bill be referred to Committee on Natural Resources, then the Committee on Judiciary.
Engrossed House Bill 4334 clarifying the requirements for a license to practice as an advanced practice registered nurse and expanding prescriptive authority.
Message to be received, bill be referred to the Committee on Health and Human Resources, then the Committee on Government Organization.
Engrossed committee substitute for House Bill 4339 relating to wildlife resources.
Message to be received, bill be referred to the Committee on Natural Resources, then the Committee on the Judiciary.
Engrossed committee substitute for House Bill 4380 adding the spouse of an indigent person as a possible individual who may be liable for the funeral service expenses.
Message to be received, bill be referred to Committee on Health and Human Resources, then the Committee on Finance.
Engrossed House Bill 4411 relating to penalty for illegally taking native brook trout.
Message will be received, bill be referred to Committee on Natural Resources, then the Committee on Judiciary.
Engrossed House Bill 4461 relating to School Building Authority School Major Improvement Fund eligibility.
Message be received, bill be referred to the Committee on Education and the Committee on Finance.
Engrossed committee substitute for House Bill 4554, allowing an increase of gross weight limitations in certain roads in Greenbrier County.
Message will be received, bill be referred to the Committee on Transportation and Infrastructure.
Engrossed committee substitute for House Bill 4587, relating to violations associated with absent voters' ballots.
Message will be received, bill be referred to the Committee on Judiciary.
Engrossed committee substitute for House Bill 4607, adding violations of law upon which a public servant's retirement plan may be forfeited.
Message will be received, bill be referred to the Committee on Pensions and the Committee on Judiciary.
Engrossed House Bill 4658, relating to the Board of Funeral Service Examiners.
Message will be received, bill be referred to the Committee on Government Organization.
Engrossed House Bill 4725, relating to providing the procedures for the filling of vacancies in the offices of Justices of the Supreme Court of Appeals, Circuit Judge, Family Court Judge, or Magistrate, and making certain clarifications.
Message to be received, bill be referred to the Committee on Judiciary.
Engrossed House Bill 4727, relating to state plan amendments.
Message to be received, bill be referred to the Committee on Health and Human Resources.
Engrossed House Bill 4730, relating to computer science courses of instruction.
Message be received, bill be referred to the Committee on Education.
Engrossed House Bill 4731, relating to requiring comprehensive drug awareness and prevention program in all public schools.
Message be received, bill be referred to Committee on Education.
Engrossed House Bill 4732, relating to performance metrics for the West Virginia Division of Highways.
Message be received, bill be referred to the Committee on Transportation and Infrastructure, then the Committee on Government Organization.
Engrossed House Bill 4733, relating to requiring the Commissioner of Highways to develop a statewide communications plan known as the Comprehensive Public Involvement Plan.
Message be received, bill be referred to the Committee on Transportation and Infrastructure, then the Committee on Government Organization. Communications from the Executive.
There are none.
Reports from standing committees.
Your Committee on Finance has had under consideration Senate Bill 555, providing for a 5-cent tax increase on sale of fuel when cost is less than $2 per gallon, and reports back a committee substitute for same, with the recommendation that the committee substitute do pass. Respectfully submitted, Mike Hall, Chair.
Report will be received. Senior Senator from the 4th.
Mr. President, I request unanimous consent that the committee report be taken up for immediate consideration, that the bill be read a first time.
Is there objection? Chair hears none. Clerk will read the bill the first time.
Committee substitute for Senate Bill 555, providing for a 5-cent tax increase on sale of fuel when cost is less than $2 per gallon. First reading of the bill.
Bill be advanced. Reports from select committees.
There are none.
Resolutions.
Senate Resolution 54 by Senators Seipolt, Williams, Unger, Kessler, Prezioso, and Stallings, designating February 29, 2016 as Preston County Day.
Senator from Preston.
Thank you, Mr. President. I ask unanimous consent to take the resolution up for immediate consideration. The committee references be dispensed with, and it will be put upon its adoption.
Senator from Preston requests unanimous consent the resolution be taken up for immediate consideration. Committee reference be dispensed with. The resolution be put upon its adoption. Is there objection? Chair hears none. Clerk will read the resolution.
Senate Resolution 54, designating February 29, 2016 as Preston County Day.
Questions on adoption of the resolutions or discussion? Senator from Preston.
Thank you, Mr. President. Preston County is home to over 1,200 small businesses and 1,000 working farms. And we find it fitting to recognize Preston County for its history, culture, economy, natural beauty, and future developments in the state of West Virginia. But let me touch just a little bit on a personal note. We know that many counties in the past few years have been delivered a blow in economic opportunities, and they're hurting. Their people are hurting. My story is that I began my surveying career in Preston County in 1986, and at that time, the company I worked for had as clients 22 different mines. Almost all of them were deep mines, and there were surface mines also. And I worked in every one of those different mines. Today, Preston County has 0 mines. Over the past 20 years, we have lost an enormous amount of employment, but our people are resilient. They realize that maybe Preston County coal wasn't the future, and they've moved into other areas. We've grown in tourism. We've grown in also agriculture and agritourism. We've grown in recreation, we've grown in the arts, and we've grown in culture. And we invite the members of West Virginia and the rest of the country to come and visit our great county and take in some of these features and opportunities. Mr. President, I urge adoption of this resolution.
Is there further discussion? If not, the question for the Senate is the adoption of the resolution. All those in favor will say aye. Those opposed, no. The ayes have declared the resolution adopted. Senator from Jackson.
Thank you, Mr. President. I move the Senate stand in brief recess for the purpose of presenting the resolution.
Senator from Jackson moves Senate stand in brief recess for purpose of presenting the resolution. All those in favor say aye. Those opposed, no. The ayes have it. I declare the motion adopted. The Senate will stand in brief recess to present the resolution.
You're watching the West Virginia Legislature on the West Virginia Channel. Today, this is the Senate floor session recorded earlier today. Among the bills on third reading in the Senate today, Senate Bill 47, rewriting licensing requirements for the practice of medicine and surgery and podiatry. Senate Bill 287, creating the West Virginia Safer Workplaces Act. Senate Bill 344, clarifying the composition and chairmanship of the Commission on Special Investigations. Senate Bill 399, establishing personal and corporate income tax credits for farmers donating edible agricultural products relating to the creation of the Farm to Food Bank tax credit. Senate Bill 596, permitting natural gas companies enter upon real property in certain instances. Senate Bill 618, allowing the Economic Development Authority to make loans to certain whitewater outfitters. Senate Bill 700, authorizing Berkeley County Council own or operate a drug treatment or drug rehabilitation facility in Martinsburg. And House Bill 2852, relating to legalizing and regulating the sale and use of fireworks, dedicating certain fees to Veterans Facilities Support Fund, the Fire Protection Fund, and the State Road Fund. Those are among the bills on third reading before the Senate this morning.
Ladies and gentlemen of the Senate, can I have your attention, please? Ladies and gentlemen of the Senate, those of us in the gallery, we have a special treat today before we gavel back in. Princeton High School, which is from Mercer County, the Princeton High School Madrigal Singers are here, and they're gonna share a couple of selections with us. I was actually a madrigal when I was back in the Bluefield High School days. I'm not sure it was because I could carry a tune, but I did have a bass voice. So we're tickled to death to have you guys here. I understand that there's been a lot of awards, including most recently the 2016 West Virginia Music Educators Honor Choir. But we're tickled to death to have you here. And after they offer up one or two selections for us, I'd ask the members of the Senate to come back down and we'll have a picture and give them a certificate of recognition. Please, Princeton High School Madrigals. Would members of the Senate come down for a picture presentation? Senate will come to order. Motions. Petitions.
I have a petition presented by Senator Kessler from Dustin Till containing numerous signatures opposing House Bill 4012, the West Virginia Religious Freedom Act, Restoration Act.
Petition will be referred to the Committee on Judiciary. Unfinished business.
The senator from Jefferson moves that the Senate reconsider the vote by which it adopted the amendment offered by the senior senator from the 8th to Senate Bill 435.
The question is on the adoption of the motion offered by the senator from Jefferson that the Senate reconsider the vote which it adopted the amendment offered by the senior senator from the 8th to Senate Bill 435. Is there discussion? Senator from Jefferson.
Thank you, Mr. President. I urge adoption of the motion to reconsider.
Is there further discussion? Senior senator from the 8th.
Thank you, Mr. President. I'd like to stand in opposition to the motion to reconsider the amendment. I tell you, we put the amendment in to try to help small businesses throughout the state of West Virginia. There's a group up at Snowshoe that wants to sell West Virginia wine to the people that frequent the resort. And I tell you, I don't know why we would not allow something like that to happen, why we wouldn't allow West Virginia goods to be sold, to be taken off the premise by people visiting the facility, and to go back to their states and share some of West Virginia's pride with those individuals outside of our state. It only promotes the goods that we supply here in West Virginia. It's a small business friendly amendment, and I urge rejection of the motion because I think we did the right thing. And I'm a co-sponsor on the bill, and I think it fits perfectly into the piece of legislation as well, dealing with wineries. We need to move West Virginia forward in any way we can, and this will bring additional monies, additional tax dollars to the state of West Virginia. It's not raising taxes. It's simply just lifting our foot off the throats of small businesses in West Virginia that are trying to compete, trying to succeed, and trying to survive. I urge rejection of the motion. Thank you, Mr. President.
Senator from Marshall.
Thank you, Mr. President. Will the senator from the...
Will the senior senator from the 8th yield? Senator yields.
You know, obviously, I don't know a lot about this. Wasn't on. I assume it happened on the floor in finance. I'm not sure.
Happened on the floor.
Okay.
Yeah.
But in any event,
everyone on the floor voted
this facility is over in Pocahontas County.
It is. That's correct.
And Pocahontas County, as I understand it, is a dry county.
It is a blue county. That is correct.
So it only permits the sale of alcohol, wine, and other things in.
Only wine.
Only wine, and some locations, I think, over maybe at Snowshoe or...
At Snowshoe Resort. If somebody has any location at Snowshoe Resort, that's correct.
All right, and that was granted to them, a privilege to do that by the county commission, I'm assuming?
I'm sorry?
The county commission granted them that exemption?
We're granting the exemption in the amendment,
all right,
Senator.
So they have not granted an exemption?
Not that I'm aware of.
And what we would be doing would be usurping the power of the county commission to grant variances to their non-alcohol sales ordinances on Sunday over there.
That's correct. Not on Sunday, sir, just in general.
In general?
No, yeah, they would not be allowed to sell on Sunday.
Under your amendment, they would or they would not?
You have to excuse me. I'd have to look. Under my amendment, they'd be able to sell the bottles of wine now. They would be able to do it on Sundays, but just until, they wouldn't be able to sell until after 1 p.m. on Sundays.
So what we're doing, as I read your amendment, it is limited and confined to a resort area, meaning an area encompassing one or more resort hotels and attachments to the resort hotels and the traditional immediate grounds of such resort hotels. So we're basically giving a narrow exemption to one facility and one location.
Just like we've done in Greenbrier County, yes, sir.
So this would be creating monopoly within that county for the sale of wine only for that one facility.
For that resort area, yes, sir.
Would it be available to any other area?
No, sir.
So it's limited to one county, one group. Who's requested this amendment? Is it a particular business owner?
I understand that Snowshoe has been favorable to the amendment, and then business owners have come to me.
Well, who owns the business? Somebody's going to benefit from that by getting in a monopoly to sell wine at one location that nobody else in the county has.
I just understand that the resort area has been favorable towards the amendment.
Are they the ones who requested the amendment, or the business owner who's getting the monopoly?
I don't remember who sent the email asking me to do it. I could look. But I don't remember who did ask for it.
We're creating special interest legislation that benefits one individual, one company, create one monopoly in one area. I think we'd like to know who we're bending over backwards to grant a favor to.
I understand that.
And I don't have any problem selling wine on Sunday in the whole of Pocahontas County. But that isn't what we're doing here. We're granting one person a monopoly to have the benefit of that without the approval of the county commission, who's otherwise granted the
To speak to that,
exemption.
I would say that if anybody else wants to offer to any other store inside a Snowshoe Resort, they would be allowed to as well.
Under what?
If anybody else at Snowshoe Resort would like to sell this product as well, they could.
They would have to be somebody who's within the resort hotel itself or attachments to it. So
that's correct.
It isn't like it's open to the free market for anyone to go in and force themselves into that location. They would have to.
I don't know the amount of occupancy in that location.
Okay.
I don't get to frequent Snowshoe.
So have you found out who we're benefiting by this? The name of the business, company, individual, somebody's getting
The amendment came from Parween, is who sent the amendment to me.
Who, I'm sorry?
Her name's Parween.
All right. And so we're giving Parween a monopoly statutorily.
I don't know if it's her store. You alluded that it may be earlier today, but I don't know if it's just her store. I don't know if she owns a store.
That's all I have, Mr. President.
Thank you.
I would urge the adoption of the motion to reconsider. I think it's something that we need a little more discussion on, certainly, before we start granting monopolies to one individuals within this state. So I think it's legitimate for public discussion.
Senator from Greenbrier.
Thank you, Mr. President. I also would speak to reconsider this amendment. This bill that this amendment attached to, and I do apologize to the body, I missed this on Saturday when it took place. I did not hear it go through. It went through very quickly, and I just did not hear it, and I do apologize for that. I'm a sponsor of this piece of legislation, this attached. This piece of legislation that attached, that we'll be voting on later today, is a great piece of legislation. And I'm not going to drag the Senator from Montague into this, but he had worked on this last summer and this year. I was also a sponsor on that, allowing farm wineries to use their facilities for some other products. It's particularly directly related to farm wineries, which is an industry we're trying to grow and improve and make a great economic tool for West Virginia. What happened to this amendment, there's an old saying in my part of the country that pigs get fat and hogs get slaughtered. And what we've done is created instead of a fat pig here, which is what this bill would have been, a nice fat pig, we've created a hog to be slaughtered, because not only have we taken what was a nice piece of legislation to do something very positive, but instead we've added another segment into it. Now let me tell you, there's a couple problems. First of all, the problem for me when I read this was we give authority to do this to one shop in one resort district in one place. We usurp county authority, usurp municipality authority, we usurp home rule that we talk so much about. That's one problem that I see with this. The other problem that I have with this is that we are setting this bill up to be vetoed. And this is too important a bill to be vetoed. We're setting up to be vetoed because we're dealing with two separate objects in this piece of legislation. But more importantly than that, this amendment is in the wrong code section. I talked to the ABC this morning. It's in the wrong code section. In the code section that it's in, it basically circumvents the West Virginia Code, but it also is in a code section that the Alcohol Beverage Commission has nothing to deal with and nothing to do. We've suddenly taken a farm winery section and put this in that section when this would have been done with the Alcoholic Beverage Control Division. So I can't say that it's not germane. It is out here, but it is double what we've done. It's a problem. It creates a problem for a bill, and I can almost guarantee that when this goes through, the governor will veto this because it is wrong. It's written wrongly. The amendment was well-intentioned, but it's in the wrong place at the wrong time. So I would urge that we reconsider this amendment.
Senator from Wayne.
Would the senior senator from the 8th yield?
Will Senator yield? Senator?
Yeah, I yield.
Senator, one thing I was confused about when you were talking about this is that you said it was very similar or identical, I think you may have said, I'm not really sure, to Greenbrier County. Now, did Greenbrier County have a referendum to vote that in?
I was referring to, he said that essentially we are only doing this for one resort area, and that's all we're focusing on, implying that we only are doing this for one resort, and we haven't done that before. My implication was that we have done stuff for singled out areas in the past.
But
it wasn't referencing to the alcohol perspective. It was we have picked and choose resorts to help in the past. That's what my motion. I mean,
and the difference, if you would let me ask the question, and you didn't answer it, the difference is Greenbrier County actually passed a referendum after this was done, and the legislation was contingent upon that. Correct?
I would trust the senator. I don't know.
Thank you.
Thank you.
Further discussion? If not, the question is on the adoption of the motion offered by the senator from Jefferson that the Senate reconsider the vote by which it adopted the amendment offered by the senior senator from the 8th to Senate Bill 435. All those in favor will say aye. Those opposed say no. The ayes appear to have it. The ayes do have it. I declare the motion adopted. The question now before the Senate is the adoption of the amendment offered by the senior senator from the 8th to Senate Bill 435. Is there discussion? Senator from Marshall.
Thank you, Mr. President. Just briefly, again, I would urge rejection of the amendment. I think the bill is well-intentioned. You've heard the explanation of the senator from Greenbrier that has written it may lead to the ultimate veto of a very good piece of legislation. And again, there's not been consideration in committee or discussion of the particularly troublesome potential for creating a monopoly in a dry county for the liquor sales or wine sales in that particular resort area. It appears to be very confined and self-serving to only a particular business or entity without full discussion or potential inclusion of everybody in the county. And I'm concerned about usurping the county commission's rights to regulate such activity of the people that live over in Pocahontas County. So for that reason, Mr. President, I would urge the rejection of the amendment and move forward with what's otherwise a good bill.
Further discussion, the senator from Taylor.
Order, Mr. Chairman. Based on the comments of the senator from Greenbrier with regard to it being a double object in the bill and also being in the wrong code section, I request a ruling of the chair if the amendment is germane.
Senate will be at ease.
The Senate is considering Senate Bill 435. This allows farm wineries to enter alternating wine proprietorship agreements with farm owners. Apparently what happened is that the bill was amended to allow a shop owner at Snowshoe Mountain Resort to sell West Virginia wines. So that's the consideration. They are reconsidering that amendment. The amendment was put in, I don't know when, but it was amended on the floor, and they are now reconsidering this amendment regarding selling West Virginia wines at a shop at Snowshoe Resort. This is a recording of this morning's Senate floor session. The Senate is now back into session and taking up bills on second reading. The House is also almost back in session. It recessed until 3 o'clock this afternoon to finish up their bills on third reading. But we think it's important to show you today's Senate floor session from this morning. And now the Senate President and all the other senators are discussing whether or not the amendment allowing the shop owner at Snowshoe to sell West Virginia wines is even germane to the bill. That means, does it pertain, does it belong in this piece of legislation? And we're waiting for the Senate President to decide if the amendment regarding
Senate will be
wine
in order.
sales is germane.
Regards your point of order, your point's not well taken. The chair believes the amendment to be germane. The senior senator from the 8th.
Thank you, Mr. President. I ask unanimous consent to withdraw the amendment.
Is there objection? Chair hears none, so ordered.
And with that, the Senator's amendment is completely withdrawn and no longer needs to be considered. Senate Bill 435 is up for action on the Senate floor today.
Are there further amendments to the bill?
No, sir.
If not, the bill be engrossed and advanced to third reading.
Senate Concurrent Resolution 51, requesting interim study of structure of regional education service agencies.
Resolution be referred to Committee on Education and the Committee on Rules.
Senate Concurrent Resolution 52, requesting study of feasibility of home modification tax credit to make homes more accessible for older adults and disabled.
Resolution be referred to the Committee on Finance and the Committee on Rules.
Senate Concurrent Resolution 53, naming the Harry C. Buck Markley Jr. Memorial Bridge.
Resolution be referred to Committee on Transportation and Infrastructure. Bills on third reading.
Engrossed committee substitute for Senate Bill 47, rewriting licensing requirements for practice of medicine and surgery and podiatry. Third reading of the bill.
Questions on passage of the bill. Senior Senator from the 15th.
Thank you, Mr. President. Senate Bill 47 rewrites the licensing requirements to practice medicine. Most of the changes just update the section for readability and organization. The bill includes preclusions against practicing medicine without a license. There is a list of exemptions, all which are currently in the code, with the exemption of allowing a physician from another state to provide medical service to a college or university, affiliated or sponsored sports team. The exceptions to practice medicine without a license are limited to a 30-day period, and there are procedures set forth for notice and an order to revoke the privilege. The bill establishes criminal penalties for unauthorized practice and sets out the procedures for when a complaint is made and reporting the information to the appropriate licensing board or state or federal law enforcement or the prosecuting attorney. I urge passage, Mr. President.
Questions on passage of the bill. Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voted. More than a majority of those present voting having voted in the affirmative declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 287, creating West Virginia Safer Workplaces Act. Third reading of the bill.
Questions on passage of the bill. Senator from Ohio.
Thank you, Mr. President. This act would permit employers to voluntarily institute drug and alcohol testing programs in the workplace. The bill makes legislative findings about drug issues in our state and the potential impact on safe workplaces. The Senator from Marshall's amendment makes clear the privacy rights are not impacted, but the interest in safe workplaces for public employees and employers are also important. The act only applies to employers not already subject to a drug or alcohol testing statute, including but not limited to the mining industry and public improvement projects. The bill makes it lawful for employers to test employees for drugs and alcohol as a condition of continued employment or hiring, provided they adhere to conditions in the article. Samples are to be collected in a manner to ensure proper identification and uncontaminated samples. Tests are to be conducted either during work time or immediately before or after work time. Testing is compensable time, and an employer is to provide transportation or pay for reasonable transportation if tests conducted at a location other than normal work sites. Positive tests, which are going to form the basis of an adverse employment action, must be confirmed at certified labs. Employees who wish to challenge a positive test have the right to request a split sample. Employers must issue a written policy to avail themselves of the Act and distribute that policy to all employees or make available to prospective employees. Employers must provide information on an employee assistance council programs offered. Employers are permitted to take disciplinary action within the confines of their written policy issued pursuant to this Act after a confirmed positive test or refusal to submit a sample pursuant to the Act. Sensitive employees may be transferred to non-sensitive positions or subject to any other discipline under a written policy if a confirmed positive test is received. Employers are not liable for certain claims if they follow the provisions of the Act. Those protections are not available unless the employer complies with the Act. All communications related to drug or alcohol test results are confidential and may not be used in any proceeding except to a proceeding related to any action taken by an employer under the Act. An employee who tests positive can forfeit unemployment or workers' compensation benefits if the employer so advises its employees of that possibility. The Act specifically defers to the drug testing provision of West Virginia Code 23-4-2 as the sole mechanism to provide intoxication under the chapter. I urge passage.
Questions on passage of the bill? Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted the affirmative declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 303, providing for a 5-day resident fishing license. Third reading of the bill.
Questions on passage of the bill. Senior Senator from the 15th.
Thank you, Mr. President. Senate Bill 303 creates a 5-day resident fishing license, which is designated a Class L license. The license is valid for 5 consecutive days and entitles the licensee to fish for all legal fish except for trout. The trout stamp can be bought for an additional $10 to allow a Class L license holder to fish for the trout. The cost of the license is $8. I urge passage, Mr. President.
Questions on passage of the bill. Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 344, clarifying composition and chairmanship of Commission on Special Investigations. Third reading of the bill.
Question on passage of the bill. Senator from Morgan.
Thank you, Mr. President. The committee substitute for Senate Bill 344 amends the article that governs our Legislative Commission on Special Investigations. It's Chapter 4, Article 5. And this bill amends sections 1 through 6 of that article and adds a couple new sections. 2 new sections be designated sections 7 and 8. Under current law, the Commission on Special Investigations is composed of 5 members from each house. And the bill specifies specifies that this commission will always include as members the President of the Senate and the Speaker of the House of Delegates, and then other members, 4 members to be appointed by the Speaker, 4 to be appointed by the President, and it says no more than 2 of whom shall be appointed from the same political party. The bill requires that action required by the Commission requires a vote of a quorum as opposed to the current requirement, which is majority. Current law allows the Commission to employ staff generally. The bill will say that the Commission as staff is to include an executive, a director and a deputy director and senior investigators. The bill also requires all persons with information to cooperate with the commission and defines that term, and it provides for some new penalties. The bill defines new penalties, new offenses for impersonation of a member of the Commission on Special Investigations, and the committee substitute also, I think we have a additional penalty for making false statements. When a person makes false statements to a member, an investigator of the Commission on Special Investigations, the law defines that now as a felony, punishable by not less than 1 or more than 5 years, and a fine of not less than $1,000 or more than $5,000, or both. Finally, the committee substitute contains a provision which allows, upon the retirement of one of the commission's investigators, for him or her to be awarded his service revolver upon a retirement when for someone who's had at least 20 years of service for the commission. Be happy to try to answer questions, otherwise urge passage of the bill.
Questions on passage of the bill? Is there discussion? Senator from Jefferson.
Would the chairman yield?
Senator yields. Senator yields.
Mr. Chairman, this is just by written request of the Committee on Special Investigations of any agency. This is just, I'll repeat that. This is done by a simple written request from the Committee on Special Investigations to virtually any agency or branch of government.
You mean the investigative power, the cooperation?
Well, if they're asking for documents per se.
There is subpoena power. They have subpoena power. Thank you. Council's clarified that for me. The commission has subpoena power now. This adds a provision that allows them simply to make a written request of a state agency.
Right. Without subpoena.
Correct. So the language here is on page 4, line 49, provided that the commissioner is not required to issue a subpoena as provided for in section 3 of this article when requesting disclosure of any information or the production of any documents.
My concern is accountability, and this is on written requests with no subpoena required. Does any other police enforcement, state police have that power?
I don't believe the state police do have that power.
I
don't believe the state police have independent subpoena power.
They do not.
No,
so not only do they not, they can't request records by written request. They don't even have subpoena power.
That's correct, although the way it works in a lot of criminal cases and criminal investigations is that a state police investigation in which prosecutor's office is aware of or involved, the prosecuting attorney's office will utilize the grand jury.
Okay, so that clearly that's another layer. You have to involve the prosecutor and possibly even the grand jury. Is the prosecutor involved in this process that we're passing today?
Sometimes yes, sometimes no. In other words, and I know a little bit about it because I have served for a long time on the Commission on Special Investigations. Sometimes their investigations do work in coordination with county prosecuting attorneys' offices and sometimes the United States Attorney's offices.
Would the Federal Bureau of Investigations be able to get documents on written request, or do they have to get a subpoena?
The senator from Jefferson County, and it's not hard to get where you are now, but you are beyond my scope of knowledge. Let me see if our committee counsel knows the answer to that question. The answer is, I guess, and I probably could have got this part of the question myself. An agency, any police agency, can make a written request for documents. If the senator's question is, what authority does the FBI have to go beyond that if somebody's not compliant? Well, I don't know the answer, and I don't think we know the answer here.
Well, I'm of course talking about that in the context of taking what we have now, that this Committee on Special Investigations, which, again, I've never been on it. I've only heard rumors of what they do, and that's fine. And I'm sure it's all very important public business. But we're going away from the subpoena, which they still have the authority to do, and making it simple written requests. I've got to my final point, Mr. Chairman. What about agencies that are charged with keeping certain information confidential? That charge, we will use the Secretary of State's office, for instance. They are charged to hold confidential certain records in their possession, as many of our agencies would.
The bill addresses that specifically, and it's on page 4. It's subdivision 4 of section 2A of the bill. No, excuse me, 2B4. And what the language is, it says, notwithstanding any provision of this code that imposes an obligation of confidentiality or secrecy other than the provisions of Rule 6E of the West Virginia Rules of Criminal Procedure, and Rule 6E relates generally to grand jury proceedings. For the purposes of this subdivision, the term cooperate includes the disclosure and production of any documents, reports, or other items in the possession of a state agency or a state political subdivision and its personnel upon the Commission's request to assist it in its investigation.
You've done an excellent job of explaining that. And again, I think this is an important move that I want to make sure that our confidential documents throughout agencies with that those confidentialities that have been placed on agencies is to protect the citizens of West Virginia and our businesses and so forth. I just wanted to make sure that you're amply satisfied that this bill does not pierce that.
Well, I think it does pierce it. I think what I just read to you does pierce it. But the Senator, I hope, can take some comfort in knowing that all of the proceedings of the Commission on Special Investigation are confidential and not subject to public disclosure and subject to sanction and punishment for anybody who discloses that information. That is addressed in Section 5 of the bill, some of which is existing language, but in current law, and this is not changed, says investigations conducted by the Commission and the materials placed in the files of the Commission as a result of any such investigation are exempt from public disclosure under the provisions of Chapter 29B of the Code. And then the new language in that section allows, upon a vote of the Commission, for the Commission to dispose of printed materials and files.
Thanks. Mr. Chairman, thank you. I wanted to talk about this because I think it is an important issue. We're moving quickly today, and I certainly didn't mean to waste a few minutes of floor time, but it's an important issue because you have an interplay of confidential documents here, and this bill will certainly change that. Thank you, Mr. Chairman.
Thank you.
Is there further discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 28 yeas, 6 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. The senator from Jackson.
Thank you, Mr. President. I move the bill be made effective for passage and request unanimous consent that the roll call used on passage be used to make it so effective.
Senator from Jackson moves the bill be made effective from passage. Requests unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none on this question. 28 yeas, 6 nays, 0 absent, not voting. More than two-thirds of those elected to the Senate having voted in the affirmative declare the bill effective from passage. Clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 384, requiring Bureau for Medical Services seek federal waiver for 30-day waiting period for tubal ligation. Third reading of the bill.
Questions on passage of the bill. Senator from Ohio.
Thank you, Mr. President. The title pretty much sums this one up, but the bill would instruct the Secretary of Department of Health and Human Resources to seek a waiver within the Medicaid program to allow for the performing of a tubal ligation without first having to seek 30-day pre-approval, which is under the current federal requirements. I urge passage.
Questions on passage of the bill. Is there discussion? The junior senator from the 17th.
Thank you, Mr. President. I just want to make the other members aware the reason that we're searching this out. There's been a long-standing issue with those on Medicaid trying to get a tubal ligation. Anybody else in the state of West Virginia, if you're private insurance, private pay, whatever, if you and your spouse or significant other decide when you're going in for a C-section that you can have that you decide you want your tubes tied, anybody can do that unless you're Medicaid. And part of ACA was to not discriminate against Medicaid. So they have to have decided 30 days in advance, and oftentimes they're just not thinking about it. So the patients want it, but they can't get it. So what that does is it requires you to come back in for a second procedure, second induction, more cost for a procedure, or an unwanted pregnancy from the individual who wanted their tubes tied in the first place. So just to make everyone aware of why we're doing this, it does require federal waiver, so hopefully we get this, but thank you.
Further discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the result on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 399, establishing personal and corporate income tax credits for farmers donating edible agricultural products. Third reading of the bill.
The question is on passage of the bill. Senator from Upshur.
Thank you, Mr. President. This bill creates a farm to food bank tax credit, and the purpose of the bill is to provide an incentive for fresh produce and food donations that would be thrown out or left unharvested due to costs. Food banks are often lacking in fresh and healthy produce, and the committee substitute would permit a farming taxpayer to donate agricultural products to West Virginia food banks equal to 10% of the value of the donated agricultural products, not to exceed $2,500 during a taxable year. The credit may be used to offset personal or corporate income taxes. Be happy to answer questions and urge adoption of the bill.
Questions on passage of the bill. Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative declare the bill passed. Clerk communicate the action of the Senate to the House.
Engrossed Senate Bill 435, allowing farm winery interalternating wine proprietorship agreements with farm owners. Third reading of the bill.
Questions on passage of the bill. Senior Senator from the 15th.
Thank you, Mr. President. Senate Bill 435 permits a license of farm wineries to enter into an alternating wine proprietorship agreement with farm owners located in West Virginia. The bill allows the farm winery to rent or lease wine production facilities, equipment, and space, including a separately bonded wine area at the existing licensed farm winery premises. Both parties to the alternating wine proprietorship agreement must be licensed farm wineries, organized as separate businesses, and both must meet federal and state license requirements for farm wineries. The wine cannot be commingled, must be stored separately, and is limited to 50,000 gallons or less per year. The bill permits co-ownership of wine production facilities. The wineries are limited to retail sales off-site, and the language is clarified for all farm wineries with regards to samples. Up to 3 samples, that's 1 fluid ounce, per patron. Provisions are made in the bill so that the farm wineries may conduct tastings and sell or provide samples of up to 3 samples, 1 fluid ounce each, per patron, and sell bottles for off-premises consumption to patrons at fairs and festivals. The bill also provides for rulemaking by the West Virginia Alcoholic Beverage Commission. I urge passage, Mr. President.
Questions on passage of the bill? Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea, those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted the affirmative, declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 594, requiring state auditor consider for payment claims submitted by electronically generated invoice. Third reading of the bill.
Questions on passage of the bill. The senior senator from the 15th.
Thank you, Mr. President. Senate Bill 594 adds a new section requiring the state auditor to consider an agency-generated electronic invoice as an original invoice. The invoice must contain the vendor name, address, invoice number, invoice date, amount, description of the item purchased and goods provided, purchase order number and contract number where applicable, and date of the service provided or goods received. The invoices may only be considered for payment if the agency has an established financial system which has been subjected to a financial audit by the legislative auditor or by an independent certified public accountant, duly licensed and in good standing. I urge passage, Mr. President.
Questions on passage of the bill? Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea, those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative, declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 596, permitting natural gas companies enter upon real property in certain instances. Third reading of the bill.
Question on passage of the bill, Senator from Morgan.
Thank you, Mr. President. The committee substitute for Senate Bill 596 does what the short title suggests. It addresses the circumstances in which a natural gas company would have a right of entry to come upon a person's property. It does this by creating a new section of the code in a new article of the code, but the bill is a single section of the code. It'd be embedded at Chapter 37, Article 16, Section 1. The committee substitute reflects a number of changes made by the committee in its careful consideration of this bill. But this relates generally, as we understood it and learned in the committee, to situations when companies are trying to site pipelines, trying to figure out what is going to be the optimum location for a pipeline. And so, as the members can imagine, this involves the balancing of, because there is eminent domain authority for natural gas pipelines under federal law, balancing property rights against the need for the companies that are going to construct pipelines to be able to find the best route for it. And so just briefly, I'll go through what the provisions of this bill allow. First of all, it relates to natural gas companies that are regulated under the Natural Gas Act of 1938. And it gives to them a right of entry upon real property for survey, study purposes in order to collect information. And there's a subsection B is a specific right of entry for survey activities. There are requirements that they have to meet, but if they meet the requirements, it relates to companies and their agents, employees, contractors, subcontractors, etc., may enter upon real property in certain limited circumstances without the permission of the owner. That's it's where the issue, the balancing issue in this legislation comes for the purpose of making inspection studies, tests, hand auger borings, hand excavations, appraisal surveys, collectively called studies. So The bill before us, the committee substitute, is different from the introduced bill in a couple of important respects. To trigger this now, a natural gas company can't just go wandering around and speculating. They have to have made an application and have been assigned a docket number under the Natural Gas Act at the time of notification for entry, so long as it is organized for those purposes and intends to use the studies to satisfy regulatory requirements, to prepare necessary applications for approval by a regulatory body, 3, respond to data requests or inquiries from a regulatory agency, 4, to aid in the selection or location of pipelines, proposed pipelines or other facilities. Now, the bill requires that before they can do this, they have to try to obtain permission from the owners and occupants. They have to, subsection C of the bill says they have to attempt to obtain permission to perform the studies by sending a request for permission to the owner. Law requires that the bill would require that be by certified mail, identifying the date or dates when the studies are proposed to occur, and it has to be at least 15 days in advance and not more than 60 days more in advance from when they want to enter the property. And these reflect changes made by the committee. It says the request for permission made to owners has to go to those that are whose ownership appears of record in the office of the clerk of the county commission where the property is located, and also person or persons to whom the sheriff is mailing the annual tax ticket. A new section subdivision was added which says if the identity of the occupants of the property are known to be different from the individuals mentioned in subdivision 1, the owners, and can be ascertained by due diligence, reasonable due diligence, then the request has to go to the occupants as well. So that's to try to address a situation where there's a tenant or someone living on a property who is other than the owner or the person that is getting the tax ticket. And it tells what the notice has to contain. Subsection E says then if those procedures are followed, then entry, even without permission, will not be deemed to be a trespass. It says that there are some limitations for the limitations. The statute specifically would not permit the people coming on to do tests to park or use motor vehicles on property, use chainsaws or other power equipment without the consent of the owner, and it requires specifically that a natural gas company on property for those purposes would be required to reimburse the owner for any actual damages resulting from the studies. I guess the explanation for this, as we learned about it in the committee, is that even though there's a power of eminent domain to build these pipelines under federal law, there's work and information that has to be done and collected before you get to that step to determine what property is going to be the route that you select for a pipeline. So, Mr. President, I'd be happy to try to answer questions as there may be from the body. Or otherwise urge passage of the bill.
Question on passing the bill. Is there discussion? Senator Marshall.
Thank you, Mr. President. Will the Senator from Morgan yield?
Certainly. Yields.
So as I understand this, these gas companies will have the right to come on your property of the owner whether or not they have any actual ownership of the gas. Is that correct?
That's true.
So they don't own the gas, they don't own the surface.
The trigger, as I mentioned, for the authority to go in is that it has to be a natural gas company regulated under the Act, and it has to have been a company that has made an application and been assigned a docket number under the Natural Gas Act. And I'm not knowledgeable about that process. I've never been involved in it, but as we learned, it's the process by which an application to build infrastructure like that is commenced.
So I understand it's a transmission line. It's not a gathering line to take it in, which does not, I understand, have eminent domain. But these folks already...
I think if it's subject to eminent domain, I think that's part of this. If it's not something that would be subject to, or that for a pipeline that would have an eminent domain power as an appurtenance of it, I don't think this is going to apply.
You're telling me this bill does not apply in the instance where there's eminent domain?
I'm telling you this. I believe this bill's going to apply. This bill does not limit any power of eminent domain. That's specifically in subsection H of the bill. So it says nothing in this section impairs right of any natural gas company, et cetera, obtained by eminent domain or an easement granted by the landowner or his predecessor in title, or any right-of-way agreement, lease, or other agreement bound between a natural gas company.
So if they have a written document with a landowner or their predecessor saying you have the right to do it, then they have the right to do it.
Right, and these processes would not be necessary in that circumstance, as I understand it.
But in the instance where there is a distribution or transmission line only, and it's subject to FERC, I think the Federal Energy Regulatory Commission, or just transmission lines, excuse me. If they're transmission lines that they're subject to FERC, they do, as I understand it, have eminent domain powers.
I believe that to be correct from what I learned, and I believe that these processes, that this bill will make, if adopted and passed, will make these processes available in those cases.
But only to those, is that correct? Or whether it's a FERC application for a transmission line or any line, gathering line, any type of line in the state?
Well, it has to be something that is commenced by an application and the assignment of a docket number under the Natural Gas Act. So, I don't mean to dodge your question, but I am not conversant enough to know the whole gamut of circumstances when that has to occur. In other words, if I don't know personally if there are sorts of lines that can be built that don't require that process in an application generating a docket number under the Natural Gas Act.
But in the event if we pass this bill, they'll have the right if they say we're the gas transmission company, Columbia Gas Transmission, and we want to build a line from point A here in Doddridge County to point B in Williamsburg, Virginia, and they've got applied for an application with the Federal Energy Regulatory Commission that they would have the ability to go do these pre-entry, no trespass surveys and other studies.
I believe the senator is exactly correct, that would be the effect of this bill.
And while I understand the intent of the bill, I'm concerned about perhaps the overbreadth of it. Although it encourages people to get the consent, it doesn't require consent. In fact, if you don't get the consent, you can do it anyway without any penalty, correct?
I agree with the senator on that legal principle.
Is there anywhere in this bill that restricts or this right of entry without permission and not calling it a trespass to residences? Because I know in many instances it's talked about they have the right to may enter upon any real property on line 11 of page 1 of the bill. And then later it talks about occupants. So if they decide this point A from Doddridge County down to point B down in Williamsburg, Virginia, the best location for that as drawn is a straight line, and it happens to go right through the smack dab through my living room. Well, they have the right under this bill, if they ask for consent and not granted, the right to knock on your door and say, I can come in without your permission and see just whether or not your living room's wide enough to run this pipeline through.
To the distinguished minority leader, I don't think so.
Well, is there a prohibition anywhere in there that would suggest or absolutely prohibit them from entering someone's residence? Because in many instances, I understand they will, they use eminent domain all the time under projects to take people's homes, to take people's residences, to take people's garages, to take people's farms or gardens or whatever they may want. But I don't see anywhere in the bill that would suggest that this could not be interpreted so broadly that they can go right through your middle of your house.
To the gentleman's point, the distinguished minority leader, the bill does not specifically address dwellings, but it would be my opinion that there would be no authority to enter someone's dwelling under this bill. For two reasons. One, that it's limited, it's a right of entry to real property for survey and study purposes. I mean, that is the fundamental purpose of the bill, and I can't imagine that that would ever require entry of a dwelling.
Well, unless, of course, that was the route of choice and your home happens to sit in the middle of it, then they would need to know continue through that line with the survey.
Well, I think they would be limited to being able to collect data from the topography of the ground around the dwelling. My guess is that if there were to be, if ultimately a decision were made that the optimum route for a gas line is through some area where there is a dwelling, it would require taking and raising of the dwelling and not actually running the pipeline through a dwelling.
But I just, in this day of drones and aerial photography and other things, I'm just wondering what's the necessity of actually having boots on the ground for folks to determine the point A to point B location?
It's a great question. It was actually the subject of some discussion in the Judiciary Committee, and the information we got from the testimony of people who came to the committee was that it is true. These companies can collect a lot of data from either satellites or from drones or from other sources, but there are apparently occasions when trying to find what's the optimum route for a pipeline, you actually have to go out on the ground and look at it. One of the things that was mentioned was, sometimes there'll be like a family cemetery on a farm. And it's not always possible to tell that from satellite imagery, that sort of thing. And so the companies, for lots of reasons, need to avoid those sorts of things that exist, and you can't really find out if they're there without actually getting out on the ground and walking around and looking at it.
I guess finally, will the castle doctrine apply to these folks that try to come on my property without permission, and we don't call it a trespass?
I do not believe that it would be lawful to shoot somebody. If that's the question, I do not believe it would be lawful to shoot someone exercising the authority granted if this law passes who comes onto property without permission. Now, inside the dwelling, I'm with you on that.
That's my next question.
Yeah.
They come in my dwelling, it's not a trespass, they're perfectly legal and entitled to enter. Will I have the benefit of the castle doctrine if they show up and say, I'm coming in whether you like it or not?
In my opinion, to the distinguished minority leader, this bill would not give or authorize anybody authority to enter someone's dwelling. And I can certainly tell you that, and I'll say it for the record here, we can append the remarks to some future journal, that I don't believe it was the intention of anyone in the Judiciary Committee in recommending this bill that such a thing would be permissible.
Thank you, sir.
Thank you.
Further discussion. Senator from Greenbrier.
Thank you, Mr. President. This bill is better than when it started, I will tell you that, but it's still, for those of us who live in the area that they're talking about, a pretty bad bill. This bill allows natural gas companies to enter on the real property of anyone in the state without permission of the owners. Now, it is saying that isn't trespassing, but I'm telling you, those of us who own farms and land, particularly in my region, if you come on our property without permission, that's trespassing. I don't care what the code says. The senator from Marshall asked the question about entering your house. They don't have to knock, according to this. If they've asked permission a couple times by letter and you don't respond, they can come on in, the way I understand this. Now, I understand the FERC rules. I understand the feds are going to do what they do. I understand that. But I'm telling you, this has problems for people where I live. Let me tell you the big problem that we're not even addressing today. Here's what we're doing with this bill. The judge, a circuit judge in Monroe County, issued an injunction to stop this happening. Now, that could have fought itself out in court, and it should fight itself out in the court, and I believe the Supreme Court may be looking at it at the moment. But instead of letting it fight itself out in court, instead of spending the money, those who have the money have decided it's better to come up here and simply make us give them what they want to circumvent what the court might do. And that's exactly what has taken place here. With this piece of legislation that we passed today, we're telling the court, we don't care what you rule on this. We don't care what the people want in this region. We're going to take your land because it's cheaper for us to come here and get a law passed than to let the court make the decision. That's wrong. I think we need to let the court run this thing through. But let me tell you another problem. I live in an area where people own their property rights, surface and mineral rights. We own these. I said this in judiciary. We own these rights and they are dear to us. I know I've been told by others, well, they're going to pay you well for this. Somebody said they may come through your farm. Don't you want to get the money from your farm when they come through? I don't want the money. And most of the people I talk to in my region, it's not about the money they get paid for this going through. It's about the fact for 5, 6, 7 generations, they have owned this property, they have fought for this property, they farm this property, they use this property, they love this property. It's their property. And I have a real problem when we can come here with those who can afford the best and say, you don't matter, we're going to take your property. You don't matter, we're going to trespass on your property. And I understand the good, I understand FERC, and I understand all of the federal issues with this, but I'm telling you, let's let the courts play this out. We do not need to pass this today. We can let this go and do it another time, and I'm not just wanting to kick the ball down the road. We need to do something about pipeline issues. It's a big issue. But in our region, we do not drill gas. We do not get rid of our minerals. We hold on to our land because we love our land. It's very important today that we send a message, this is important to us. This is important to those in that region. And there's some other issues that are going to come up, and I'm going to give you the same speech. I'm sorry. You're going to hear the same thing, but it's extremely important to the people in my area. You may not get emails on this, and I don't care what emails say one way or the other usually, because I get hundreds of them about something, and usually they're all the same and I don't read them. But I will tell you, I probably get 25 or 30 a day on this issue alone from people in my region who are extremely upset that we are taking this action, particularly when there's a court case waiting to decide this. So I would encourage you to defeat this legislation. Let's see what happens in the court. Thank you.
Further discussion. Senator from Harrison.
Thank you, Mr. President. I rise briefly to clarify any misconception. We, with all due respect to my chairman and judiciary, we worked hard to try to make this a better bill, but, you know, after I walked out of there, and for the reasons the Senator just stated, that you know, this was a court case where I think the judge would have been overturned, but it's not right to come to the legislature and ask us to bail people out of court decisions. This should have been played out in the Supreme Court. I think the judge would have been overturned and nobody would have come here with this bill, but I think we failed to consider some important aspects of being a property owner. I mean, we're allowing people to come on to others' properties without their consent, without their desire for that to occur. I mean, imagine being in your house. Imagine somebody walking on your property, having the run of your property without your permission. I mean, that's a huge step against property rights in this country, which we all believe and profess we hold dear. I think we could make this a better bill. The senator from Braxton pointed out to me that we didn't consider something that my friends across the aisle consider in every bill: liability of the property owner. Do I have to go and pick up all my traps, make sure there's not a hidden pit somewhere that somebody's going to follow into and get injured? We failed to consider that. I think we can make a better bill. I think if we'd had the time to look at this a little more thoroughly and understand it, and understood that the industry failed to follow through on their obligation to challenge that court decision, I think we could have maybe come up with a bill that would have worked, but I oppose this bill, and I urge everybody in the body to oppose this bill.
Further discussion? Senator from Marshall.
Thank you, Mr. President. I also rise in opposition to the bill for a couple of reasons. I wasn't familiar with the pending court case, but I think it's bad public policy for this body or any legislature to start picking the winners and losers of any pending litigation. Otherwise, every time there's a divorce case, people are going to be down here knocking on our door asking us to say, I want custody of the kids. It's bad public policy. We should not be passing legislation that picks winners and losers. We've heard that all the time. The market should pick the winners and losers. Well, in this instance, it looks like we're picking the winners and losers. And again, I'm troubled by the fact that I don't think that this bill is written narrowly enough that specifically precludes the entry into residence and permits on what would otherwise be an unlawful trespass onto someone's property, lawful only because they've got a hat, wearing a hat or a shirt that says oil and gas. And they do have remedies and they do have relief under this legislation, under the current state of the law without this bill, because they do have the rights of eminent domain. But you got to convince a court you have it, and then once you have that condemnation proceeding filed, normally the first thing you get once it's filed is a right of entry. A right of entry. So under legitimate cases where there is a legitimate public need, they do have the right for eminent domain for these type of transactions, these type of transmission lines, and there is an appropriate method. The only thing that usually becomes into dispute at that point, once it's a legitimate right of entry on their eminent domain, is how much. How much. So again, Mr. President, I think this bill is too broad, and we should not be giving anybody, just by virtue of them being an oil and gas company, the ability to enter on your land, to scope it out, check it out, see what it is, so that they can want to know what it is before they take it. There's a procedure in place for them to take it properly, and we shouldn't be moving that bar even further and that timeline even further away from the court process and without an appropriate remedy. So for that reason, I urge the rejection of it and stand for the property rights of the citizens of this state, wherever they may be. All 55 counties. All 55 counties. I can't remind us again that they are the people of the state, the voters of the state, the citizens of the state that sent us down here. I pray to God that we're not sent down here solely to represent Exxon Mobil and some transmission line. We should represent the people of the state who don't need or want this piece of legislation, Mr. President.
Senator from Braxton.
Thank you, Mr. President. I've thought about this a good little bit as we've sat here and talked and listened, and I've heard arguments on both sides, and to some extent I could probably argue either side of it. But here's the important thing that we need to remember. They do not need this. Now, we've all been out in real estate transactions and right-of-ways and this and that, and so let's look at it like this. We've got Farm A, B, C, and this pipeline's going to go through the middle of all of them. Now, these surveyors wants to come out and try to pick the best route for the pipeline. But if you'll read this bill, it's not about driving vehicles or anything. It's about carrying their equipment. It specifically talks about no chainsaws, no vehicles and all. So look, if you go to Farm A and you say, I want to come on your property, and for whatever reason they say you can't, well, then you can come back onto Farm B and get access. I mean, we're not talking about the pipeline right-of-way. The pipeline right-of-way is what it is. It's the line. They're wanting to have access to that pipeline right-of-way. I think it's important that we remember that, for whatever reason, if somebody doesn't want someone on their land, that's their business. That's their right. I mean, we've got to be really careful here when we start talking about giving people the right to come on their property that these people don't want it. Now, if this was something that they said, if we don't have this, this can't happen, well, that might be different. The only thing we're going to do by turning this down is inconvenience some surveyors. But I believe it would be worth inconveniencing some surveyors to protect the rights of these citizens. It's their property. It's the most precious thing that most of these people own. Please, let's not let people just come onto that because they want to. Again, this isn't going to stop the pipeline. It's just going to make things a little inconvenient for the surveyors. And for the right of protecting people's property rights, I think it would be certainly worth that. I urge to reject this bill.
Further discussion, Senator from Nicholas.
Thank you, Mr. President. I recognize that this particular piece of legislation is very contentious because people feel like their rights are being taken. But what I think this bill is endeavoring to do, as much as anything, is to allow a surveyor to go on the piece of property to find out whether or not there's a legitimate right-of-way or a legitimate way to get across a piece of property. Many times when the surveyors with these particular individuals, and again, they haven't established the alignment of that route as it goes across any particular pieces of property. It's making an attempt to assess what is the route that needs to be taken. Many times that when you get to looking on properties, there's environmental concerns, and they can't go across those environmental concerns. Why? Because it runs into problems with the fish and wildlife folks. We get into wetland considerations, things of that nature when they're doing these surveys. You can't identify that unless you walk the route. You can find places where there's rock outcroppings. There may be sensitive things on the property as well as they're walking those routes that you can't see from aerial photography and things like that, like the graveyard on a piece of property that's been there for years and years and years, hundreds of years. And until they walk that route, they can't identify those particular concerns. What this allows the gas pipeline company to do is simply walk the property, walk the alignment, and find out what is the best route, and to begin talking with the property owners to find out where they feel like might be areas where they want to avoid so that the people on the property can actually accomplish the things on the longevity that they need to accomplish. This is just the initial phase. It's the beginning, trying to figure out what is the best route to get there. At this point, they don't want to establish eminent domain. If they do, they're taking a piece of property. But it may not be the property, and it may not be the route that they necessarily want in that particular routing. Now, all of a sudden, they've taken somebody's property that maybe it wasn't where they wanted it to be. This just simply allows the people to walk on the property, survey it, and allow them to understand what is the best route for all parties in concern. Thank you, Mr. President.
Further discussion. Recognize the Senator from Morgan to close.
Thank you, Mr. President. I'll be very brief. The discussion of this legislation today on the floor of the Senate, I think, has sort of honed in on all the issues around this. What I will say about the bill before us is it was an earnest attempt by the Judiciary Committee to balance the interests that we've heard discussed here. I have no doubt there may be ways that it could be improved and maybe will over time. It is, in my judgment, a matter upon which each member must make his or her own decision. But I'm happy to recommend it to the body as the product of hard work of the Judiciary Committee on the difficult questions involved.
Senator from Preston.
Thank you, Mr. President. I move that I be excused from voting under the rule number 43 of the rules of the Senate.
Chair had ruled that any impact on you would be as a member of a class, and the Chair would direct you to vote. The question for the Senate, shall the bill pass? All those in favor vote yea, those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine and ascertain the results. On this question, 11 yeas, 23 nays, 0 absent not voting. Less than a majority of those present and voting having voted in the affirmative, I declare the bill rejected. Clerk will communicate.
Engrossed Senate Bill 618, allowing Economic Development Authority to make loans to certain whitewater outfitters. Third reading of the bill.
Questions on passage of the bill, the junior senator from the 17th.
Thank you, Mr. President. Senate Bill 618, the purpose of this bill is to support the whitewater rafting industry in West Virginia by allowing Economic Development Authority to make loans to certain outfitters. The bill permits the Development Authority to make loans up to $550,000 per whitewater rafting license owned by a qualifying outfitter. That is defined as follows: a licensed commercial whitewater outfitter that has filed an application for a loan no later than July 1, 2016, an outfitter that operates on the New and Gauley Rivers, an outfitter that operates an adventure resort comprised of at least 75 acres and employing a minimum of 100 employees. The loan proceeds may be used only to refinance existing indebtedness to qualify outfitters up to the $550,000 and may not exceed that amount of outstanding indebtedness of the qualifying outfitter as of January 1, 2016. The bill provides that the loans have a term of about 15 years, amortized over 30 years at interest rates commensurate with other loans currently made by the Economic Development Authority. The loans are collateralized as determined by the authority. There was some concern on this bill regarding statute that's in place that deals with indebtedness. That's the purpose of this bill, so that there is a workaround. This will be left up to the commissioner as well as the governor, should we approve this, to make an exception in this situation, but will still be left up to the Development Authority. At the end of the day, I do urge adoption of the bill.
Questions on passage of the bill as a discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea, those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine and ascertain the results on this question. 34 yeas, 0 nays, 0 absent not voting. More than a majority of those present voting having voted in the affirmative, declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 626, requiring DHHR Secretary seek waiver within Supplemental Nutrition Assistance Program, limiting purchases under WIC program. Third reading of the bill.
Question on passage of the bill, Senator from Ohio.
Thank you, Mr. President. This bill would require the Secretary of the Department of Health and Human Resources seek a federal waiver within the Supplemental Nutrition Assistance Program, also known as SNAP, to only allow SNAP benefits to be used to purchase food with a similar nutritional value as the Women's, Infant, and Children Program, also known as WIC. The bill requires a report by 12/31 of 2017 to the Legislative Oversight Commission on Health and Human Resources Accountability on the progress of the waiver. I urge passage.
Questions on passage of the bill as a discussion. Senator Boone.
Thank you, Mr. President. This is something that a lot of us have worked on for some time, trying to get highly nutritious foods and less Mountain Dew, if you would. During and after the conversation at our Health Committee, the Secretary of DHHR clearly understands that the WIC-type foods are very limiting. And it's my understanding that there would be an attempt to encourage highly nutritious foods over the sugary sweetened drinks, for example, but that this would take into effect or take into account the many food deserts that we have in West Virginia, places where you cannot get highly nutritious foods. So, and I've been assured, in fact, that that will be the case. And I certainly know that the junior senator from the 17th has been highly involved in this as well. So I urge passage, but I just want to, in some way, let people know that the SNAP benefits will not just be used for rice, milk, the same products that's under WIC, that this will be better nutrition, more value units for the highly nutritious foods, less value units for the sugary sweetened drinks. I know there's some concern over that because we indeed do have, as you all have seen on your desk, some significant areas that you can not simply easily buy highly nutritious food. So I urge passage with some clarification.
Further discussion? If not, the question for the Senate, shall the bill pass? All those in favor will vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 29 yeas, 5 nays, 0 absent, not voting. More than the majority of those present voting. Having voted in the affirmative, declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 637, creating West Virginia Uniform Fiduciary Access to Digital Assets Act of 2016. Third reading of the bill.
Questions on passage of the bill. Senator from Morgan.
Thank you, Mr. President. The committee substitute for Senate Bill 637 enacts a new article, and it's the West Virginia Uniform Fiduciary Access to Digital Assets Act of 2016. Under the bill, the article would go in Chapter 44. It'd be Article 5B, Sections 1 through, I think we have 19 sections in the Act. The Act defines what are digital assets, online tools, and other terms, personal representative, service agreement, and it applies to a fiduciary acting either under a power of attorney or a personal representative of a decedent. It applies to a conservator appointed or a trustee acting on behalf of a trust. And it applies to a custodian if the user resides in this state or did so at the time of his or her death. And the Section 4 allows the user to use an online tool to direct the custodian regarding the disclosure of a user's assets. And it says if the tool allows the user to modify or delete a direction at all times, a direction regarding disclosure overrides a contrary direction in the user's will, trust, or power of attorney. If an online tool is not used or is unavailable, the user may now prohibit the user's disposable assets to be disclosed to a fiduciary. Either expression of direction, override a contrary provision at the time of the service agreement. Section 7 of the Act sets forth a process whereby a custodian may disclose the contents of electronic communications of the user to the personal representative of the estate of the user. Section 8 provides that unless the user prohibited disclosure or a court directs otherwise, that section limits the procedure by which the custodian may disclose a catalog of electronic communications sent by the user and digital assets to the personal representative of the estate of the deceased. Section 9 sets forth the requirements which allow a custodian to disclose the content of electronic communications to an agent under a power of attorney. Section 10 authorizes a custodian to give an agent with a specific power of authority over digital assets or general authority to act on behalf of a principal a catalog of electronic communications minus the content if certain prerequisites are met. In Section 11, the bill says that a custodian must disclose to a trustee that is an original user of an account any of the information in the account. Section 12 provides that the conditions under which a custodian may reveal the content of communication to a trustee who is not an original user or successor user of an account. Section 14 allows a court to grant a conservator access to the digital assets of a protected person. So that's not the estate of a deceased person. That's someone who's been adjudged to be incompetent or otherwise in need of protection. And it says the custodian may also be required to provide a catalog of electronic communications minus the content. And it says a conservator with authority to manage the assets of a protected person may request a custodian of the digital assets of the protected person to suspend or terminate an account of the protected person for good cause. Section 15 addresses legal duties of a fiduciary charged with managing tangible property, and a digital asset is subject to the applicable terms of service. The section 15 we're talking about still sets forth the actions which a fiduciary may take and information which he or she may receive, and it allows the fiduciary to terminate the user's account under certain circumstances. Section 16 requires a custodian to reply with a request under the Act within 60 days of receiving the information. That section makes clear that a custodian and its officers and employees are immune from liability for an act or omission done in good faith with compliance in the article. Section 17 is a uniformity section, and it requires that in the construction of the Act, consideration is to be given to the need to promote uniformity among the states that enact it. And Section 18 makes it severable. Section 17 provides that this act, if adopted by the West Virginia Legislature, would modify and supersede the Electronic Signatures in Global and National Commerce Act, but not modify or supersede Section 101C of that act or Section 7001C of that act. I'll be happy to try to answer questions, Mr. President. But let me say, this is one of the acts that has been recommended to us by our Uniform Commission on State Laws, and it addresses in general and specific ways that are beyond, some of which beyond my limited technology understanding, but legal issues that have sort of grown out of our digital age.
Questions on passage of the bill? Is there discussion? Senator from Marshall.
Thank you, Mr. President. Will the senator from Morgan
yield?
Yes.
You may have answered that, but this has been recommended by the Uniform State Law Committee folks, whatever. I can't remember their formal name.
Yeah, this comes to us from the Uniform Commission on State Laws.
Right. And I'm assuming it's had some input during the committee from those that do probate work, and I think there's a probate and Wills and Probate Committee, Administration of Estates through the West Virginia State Bar. Any insight or input from them, one way or the other?
I don't know the answer to that question. If Senator's question is, has the Probate Committee of the State Bar been through this?
Yeah.
Let's see. Do we know? I do not know the answer to that. I know we've had other bills on this floor this session that have been reviewed, and this may very well have, but I don't want to say it has because I'm not sure.
I'm just concerned, because I'm not concerned, but I guess it sounds like a pretty reasonable bill, but whether it works in real life application in West Virginia is I'm always interested in having the insight and input from practitioners locally to see if it needs to be changed, altered, or adapted somehow to meet our code.
I've just been told, I've been given updated information, which I'm happy to share. Apparently, the Probate Committee of the State Bar has reviewed this and also recommended it.
That's the answer I was looking for. Thank you, Mr. Senator.
Thank you.
Further discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than the majority of those present voting having voted in the affirmative declare the bill passed. Clerk will communicate the action Senate to the House.
Engrossed Senate Bill 700 authorizing Berkeley County Council own or operate a drug treatment or drug rehabilitation facility. Third reading of the bill.
Questions on passage of the bill. Senior Senator from the 15th.
Thank you, Mr. President. Senate Bill 700 is a local bill that authorizes the Berkeley County Council to own or operate a drug treatment facility within the city limits of the city of Martinsburg. Mr. President, I request the right to close.
Questions on passage of the bill? Is there discussion? Senator from Jefferson.
Thank you, Mr. President. This is a bill that was originated in committee at the Drug Treatment Center in the city of Martinsburg. We've talked about a couple bills here that set a very bad precedent, especially if interfering in court cases. We just 10 minutes ago talked about that, Mr. President. This is one of the same things. Berkeley County is suing the city of Martinsburg over their zoning ordinance that they had lost the right to use a building for a drug treatment center. Now, I wanted from the onset here, I certainly realize how epidemic the drug problem is statewide, and it's certainly epidemic in the Eastern Panhandle and the city of Martinsburg. And I'm sensitive to that, as many of you are. But this is not the right way to do this. We're stepping in with a lawsuit already been filed between the city and the county over a zoning issue. For the legislature to step in with this type of action, I think, is wrong. It sets a very bad precedent. And I ask each one of you, as you hear me speak, what's the name of your hometown? Each one of you think about that in your own mind. What if this bill had your hometown listed? And the senior senator from the 16th, that's his home. So if you replace in this bill your hometown name, you would be standing up making this same speech. And that's all that I ask you to keep in mind. This sets a very bad precedent for the West Virginia Legislature to step in to an extremely local issue. Although my personal opinion is I'd like to see this happen. I believe it will happen, but not through the action of this legislature, but through the action and interaction, even if it takes the court at the local, county, and city level. So I urge rejection of this bill, and just ask each one of you in closing, what if your hometown was the subject of this legislation? Thank you, Mr. President.
Further discussion? Senator from Marshall.
This isn't my hometown, Mr. President, but I am again troubled, as I was on the earlier bill we discussed today, about the legislature picking and choosing the winners of pending litigation. Again, I wasn't aware that this had a pending lawsuit between the city and the county trying to determine whose zoning ordinances are applicable or not applicable. But again, I understand by passing this legislation, we again, if it passes, would be picking the winners and losers. And I have heard so many times on the floor of this Senate, it's time for government to quit picking the winners and losers. Unless there's a court case going, then we're going to do it. When it's the market, well, maybe, maybe not. That's not our role, Mr. President. That's not our role. Lord knows we need drug treatment facilities in this state, and there are processes in place to do that, and I will support their expansion, growth, and more treatment facilities. But when you got a case pending between two entities that already have ordinances on the book that govern their location, prohibit their location, we shouldn't be interjecting ourselves in that. In fact, if I recall correctly, an earlier version of this bill was brought out on this floor and sent back to the Rules Committee, where it still remains parked. So I'd suggest this is an attempt to just end around the earlier action of not only this body, but to also, for the state of West Virginia, to tell our local communities who know best what works in their local communities, what we're going to legislate under this dome for them. For that, Mr. President, I urge the rejection of the bill.
Further discussion? The senior senator from the 16th.
Thank you, Mr. President. This is my hometown, and actually this is the senatorial district for the 16th. Senator from Jefferson, I represent the people that are in question right now. Actually, and don't hold the people of Martinsburg don't hold it against them in that sense. This is a very unusual bill. First of all, I've never seen it in the time I've ever spent here, this specific, particularly when it relates to a specific parcel of land in regards to the bill. I mean, so much so that it says it contains the parcel of 5.2819 acres, more or less. I mean, it goes into very specific of this piece of property. Let me tell you what's occurred. And I've stayed out of this whole discussion from the very beginning. And I only got involved with it when it actually came down into this chamber in regards to this situation. What's happened is the Berkeley County Council, and I think in good intentions, and I support their effort in trying to address the drug issue in Berkeley County and the Eastern Panhandle. We have an epidemic, and it's so bad that I know in West Virginia it's a problem, but in Berkeley County it rises to the level I think we lead the rest of the state in regards to heroin overdose and other things. Trust me, I see it every single day while I'm there, and I see it in the churches, I see it out in the community. Drugs are eating people alive, people are being impacted by it. So the Berkeley County Council has taken steps to try to address that issue, and I totally commend them and support them in there. What they did is they have several properties that they own, but they chose the one parcel of land that's actually in the city of Martinsburg, and I think they have others, but they chose the one that's in question in this bill regarding the location for this drug treatment center. The comprehensive plan of Martinsburg did not have it zoned that way. And so the Berkeley County Council went to the city of Martinsburg and asked if that zoning could be changed so they could use that particular facility for the drug treatment. Mr. President, I'll tell you right now, I'm not opposed or for that particular facility. I do know that some of the residents have been contacting me and saying that one of the reasons why they are opposed to it is it's right next to Oatsdale Little League ball field. Also, it's very close to residential areas, particularly where there's children, and so they had some safety concerns and there. Also, I know the fire department of that area and some emergency services folks are very concerned about that particular location because of some of the issues that I outlined. But Berkeley County Council in December went to the county council and asked that the zoning be changed, and they were denied. They were denied. It was already zoned a certain way. The council came there and says, can you rezone it so we can use that facility? And they were denied because it didn't fit in the comprehensive plan of Martinsburg. The residents, and most of the residents in Martinsburg, a lot of them, particularly around that area, felt that it was a safety issue. At that point, back in January, actually a court case was filed with the circuit court, and the case number is 16-AA-1. It's Berkeley County Council versus Martinsburg City Council, and it was filed on January 11th of 2016. And so this has been filed. Now, what's interesting about this particular case has gone through some interesting developments because the case was originally assigned to Judge John Yoder, who has been a member of this body as a judge, but he recused himself of this case and turned it back over, and now Judge Mike Lawrenson is actually presiding on this case. Talking to the senator from Morgan earlier on in the year when we had some bills floating around, we all agreed that we would send a letter to both the city of Martinsburg and the county council to ask them if there's anything that we could do to help facilitate conversation because of working this out locally. And we did that. We got a letter back actually February 24th, and it was emailed because I have the email dated February 24th to the 4 senators. All 4 senators were involved, Senator from Jefferson, Senator from Morgan, and the senior senator from the 15th, along with the senator from Morgan, where this letter was given saying that on behalf of the city of Martinsburg, I want to thank you for your offer to help facilitate a meeting between the leadership of the city and the county on the above referenced topic, and that's the discussion of the treatment facility. The city and county have met concerning this important matter and plan further meetings. The city would be willing to meet with you to discuss solutions concerning the proposed drug treatment facility. Pursuant to your letter, we welcome meeting with you in Martinsburg on a weekend. The 4 of you will be back in the Panhandle. So they're actually trying to work through this local issue, and therefore the letter was sent. But what was interesting is the letter was sent, emailed, and we received it February 24th, and then the next day, February 25th, it was originated. This bill was originated in government org the next day after receiving this letter saying that, yes, we want to talk, yes, we're working with the county, we're trying to work this out. So now we have the bill before us, Mr. President, and here's my concern about this. First of all, it's in a court case, and once again, it's a local bill. There's dispute going on between the entities, and they're not disputing if there should be a drug treatment facility. They're just disputing the specific location of what the council wants. The council has other locations throughout the county that could be considered, and even in the city of Martinsburg, actually the county council itself and the headquarter offices are actually in the city of Martinsburg. There's space available there because Blue Ridge Technical College used to be there. They moved out. There's actually space right there in their own headquarters if they wanted to set up a treatment center or some type of facility like that. But again, it's a local thing that they're trying to work out. Mr. President, I tell you what I really fear on this is that we're going to miss the real issue here, and that is to address the drug problem and provide treatment centers. We need more than just one treatment center. We need a whole lot of them in the Eastern Panhandle because of our situation. But what this has turned into is a battle between the city of Martinsburg and the county council over this one specific location. And I really feel that this war that's raging, the only casualties that's going to be taken are the people themselves. Because now it's a dispute over zoning, respecting zoning ordinance, comprehensive plans, and all like that. And we've lost sight of the fact that we do need a drug treatment center. Now, I'll tell you this. The people that were going to come in are one of them that's been proposed, and that's WVU Medical, was going to come in and try to run it. I've been told directly from the high-ups in West Virginia University Medical is that they will not come in as long as there's a dispute between the local city and the county. So if this bill passes and it rams that down the city of Martinsburg's throat and says, you know, we're going to disregard your zoning, your comprehensive plan, your people, your residents of this, and have it, I really think that this battle continues. This battle will continue over other issues other than the fact of the treatment. The other thing, Mr. President, that I say is, you know, this is my district, and those people vote for me or they vote against me. Same thing as Senator from Jefferson. I've never seen up here, with a courtesy of the person that represents those constituents, being disrespected. Because if I thought that this was in any way going to harm me as far as my reelection or election, I would be up there supporting this and versus against it. I mean, this is a total disrespect for those people. And the individuals that are forcing this or pushing this down here, those folks don't even get to vote for those individuals. I mean, it's outside their district. It's forcing it into another district. Mr. President, I ask that, and particularly you, in the sense that I appeal to you, that this is not the approach. This is really not the approach. Regardless of how you feel about me personally, regardless of all that, this is really going to cause a great resentment in a local level that in some small way be like the Palestinians and the Israelis coming in, battling each other over land and so forth. And this war is going to really overshadow what we really need to do, and that means all of us need to be all pulling in the same direction, working to try to locate treatment centers to help these people that need it. And this is only going to throw gasoline on a fire that's raging right now, and it loses the sight of those individuals that are lost in this that really need the help. So with that, Mr. President, I would ask that we reject this approach and we focus in on approaches that we have everybody at the table, everyone working in the same direction, because that's what we need to do in order to solve this major problem here in West Virginia. Thank you, Mr. President.
Further discussion? Senator from Morgan.
Thank you, Mr. President. I rise in support of the legislation. With all due respect and deference to my dear friend, the senior senator from Berkeley County, let me say this. What he has said on the floor of the House is true. It's sort of the history, and there are a couple parts of the history of this problem that he did not recount, and I hope to do that so we can have a complete picture of what has gone on in the Eastern Panhandle on this. I want to start, if I can, I guess it's a year ago, maybe more, almost a year ago now. Our United States Senator Shelley Moore Capito came to Martinsburg and conducted a drug summit, and with news that sadly Berkeley County was designated as a high-intensity drug traffic area under the federal guidelines. Senator Capito brought with her officials from the federal government and explained to local law enforcement and legislators and a number of people who were there some of the measures and resources that were going to be applied to try to combat this heroin problem that is tearing the Eastern Panhandle apart. And it's tearing Berkeley County apart. Berkeley County, of course, is the largest of the three counties in that far Eastern Panhandle. And we were all actually delighted that Senator Capito was bringing the federal attention that she brought and resources to it. And it was not long after that, it was also last year, I think it was last year, Governor Tomlin came to Martinsburg and held a drug summit there. Again, attended, very well attended by a whole host of people, state, local officials, law enforcement, educators. And so we have our leaders at the national level and our governor have made an effort to try to focus and allocate resources to this scourge of heroin. Everybody here knows, and there's the drug problem exists throughout this state, but what the members of this body need to understand is that Martinsburg is, 70 miles from Baltimore. 70 miles from Baltimore. And the whole Eastern Panhandle and the surrounding counties in Maryland and Virginia are being ravaged by heroin. So it was, and we had municipal officials at those meetings, the county commission, they call them county council in Berkeley County, there are 5, and a genuine spirited commitment all the way around to move forward, to work to try to address this problem. And I want to say here on the floor of the West Virginia Senate, the Berkeley County Commission, the county council stepped up to the plate. They did. They found a building that used to be a factory, a hosiery factory in the city of Martinsburg. It's a pretty big building. It's about 75,000 square feet, and acquired it for the purpose of developing drug treatment and recovery center there, which is desperately needed. We all know that. And we discuss all the time. We discussed last year, we have a fireworks bill that's coming next. And one of the things we talked about last year in that fireworks bill was perhaps using some money for a drug treatment center, because we need it desperately in this state to treat our citizens. So I thought very impressive, commendable action on the part of the Berkeley County Council to step up and try to address the problem. And they acquired the building, and this is where I think the trouble started. Mistakenly, incorrectly, believed that they needed to have it zoned differently than it was. The land the parcel there in Martinsburg is an industrial zone, and in the Martinsburg zoning ordinance, and I've read the entire thing, public buildings, public institutional buildings were permitted. The county didn't need to have the zoning changed to be able to do what they wanted to do on that parcel of land. Notwithstanding that, and I think they just didn't realize it, they made a request for a zoning change. And the city turned it down. That's true. It was unnecessary to begin with. A part of the story that has so far been omitted is that when the county realized, I think when the county realized that no zoning change was going to be necessary, they asked specifically to withdraw their request for a change, which the city of Martinsburg then denied. Denied them leave to withdraw their request for a zoning change. Now, in the interim, what has happened is the city of Martinsburg has amended or sought to amend its zoning ordinance to change the definition of a public building in such a way that I guess would render the site inappropriate for the what was clearly, in my reading of the zoning ordinance, a permitted zone use. Now, all that having been said, the senior senator from Berkeley County is absolutely right. There's litigation that's pending now. One of the reasons I support this bill is because I believe litigation on this to be a waste of time and resources and attorneys, when what we need is action that this body could deliver more quickly, that the legislature could deliver more quickly. It is not an exaggeration to say that people are dying. People are dying. And I think, under the circumstances, like everybody else in this body, I don't like being embroiled in a local conflict between a county commission and a municipality. Senior senator from Berkeley County is right. You know, we did offer to try to, the four of us, the four senators who represent the 16th and 15th districts, all signed a letter offering to try to facilitate some resolution or mediation. And that has not come to fruition. I had not seen the letter that the senior senator from Berkeley County read, but I don't doubt that it's there. And but our time has run, and people are dying. So I support the bill, and I think its passage is a reasoned, limited response to solving a problem that exists in our part of the state.
Is there further discussion? Senior Senator from the 16th.
Mr. President, would the senator from Morgan yield?
Senator Yield, please. Senator Yields.
Certainly. Yes, Senator. Actually, the doorkeeper is passing out the email by Mark Baldwin, dated, as well as the letter itself that was addressed to the four of us in regards to that letter. So you'll have a copy. But my question to you, in your comments, you talked about that the county commission or the county council the Berkeley County Council. And for those, I got to say that it's a county commission, but for Berkeley County, it's called a council because of the 5 members. Yeah, for people who've been here for a while, it makes it, we remember that. Those who are new here might get a little confused. So it's a commission that said that they didn't really need to go and get a zoning change. They found that they didn't need that. Is that what I heard you say? That, you know, when they approached the city and said we want to have a zoning change because they were a county entity, they found out that they didn't really need it. Is that what your comments?
That is my understanding. And I will, to my good friend and the senior senator from the 16th, it is consistent with my reading of the ordinance.
Okay. So if that's say that's true, and then now the lawsuit has been filed, I'm not sure why the lawsuit's filed by the county council against the city of Martinsburg. If that's true, if they can go ahead and do this facility without getting approval for the zoning change, I don't see the need for the lawsuit, because if they already have the authority, they should be able to do it. But then my question to you would be, what's the need for this piece of legislation then? If the county council can go ahead and use this parcel of land for the purposes of a drug treatment center, and under the law that you have said that's how you read it, why don't they go ahead and do it? And what's the necessity of this piece of legislation here? Tell me what the necessity would be.
Well, I believe the necessity of it, or at least the efficacy of it, is to make it all clear and to make this prospect of litigation go away. That would be the utility of it.
But the litigation, you mentioned the county council, well, they were the ones that actually prompt the litigation. But you're saying that they could go ahead and do it without it. I would think that if, under your interpretation of what your reading of the law, and they also feel the same way, why don't they go ahead and do it? And if they couldn't do it, then the city of Martinsburg would have to take them to court. Well, you see what I'm saying? Because they already are authorized to do it according.
I see what you're saying, and I assume that my good friend, senator from the 16th, senior senator from Berkeley County, is aware that Martinsburg is apparently, I don't know if they've completed it, but going through a process of amending their zoning ordinance to change the ground there in that fashion too.
Well, they may be in the process of doing that, and I don't know the details of all that, but that would be prospective. This is in the past. They've already done it. They're already starting. The county council's already bought the property. They've already made public announcement they're going to do what they're going to do. They can move forward on it. And so regardless of what the city council does or doesn't do at this point, everything would be prospective from that point on, wouldn't it?
Well, there are, and I'm not the world's foremost expert or even close to it on land use planning zoning questions, but zoning regulates uses. In this case, we're talking about a use that is not yet underway. It's certainly a contemplated use, but there is no drug treatment going on at that facility now. And so to the gentleman's point, I think probably until something happens, absent this bill, it may be possible for the city of Martinsburg to continue to prevent a drug treatment facility from being started there.
Do you know how long has the county council owned this piece of property?
I do not know the exact date they acquired it.
But we do know that they went before the the city council. The county council went before the city council and asked for a zoning change, and they were turned down. And in your opinion, they didn't really need to do that, and that was back in December.
Mayor Karas's letter, which I have, says that was December of last year, and I assume that's correct. I don't remember that for sure, my own personal knowledge, but I assume that that's correct.
But prior to that, they had to go to the planning commission before they got to the county, to the city council. And so this has been going on for some time. They could have moved forward with this treatment center under your interpretation of the law, instead of filing a court case in January? I mean, I don't understand why the county council filed a court case against the city of Martinsburg if they already can do what they're suing about. I mean, normally people don't sue on things that they know they can do. Normally you go ahead and do it, and if someone doesn't agree with you, then they sue you. But if the county council can go ahead and use this facility as a treatment center, then they should go ahead and do it. They don't need a lawsuit.
And to the senior senator from Berkeley, it's my understanding that that building is going to need a whole bunch of work and renovation before it's suitable for any such use. And so it would be some time down the road before it could be used. In the meantime, the city of Martinsburg is changing its ordinances to make it clear that it can't be used for that.
Now, my question on this, in your opinion, you know, trying to get everybody together, and you worked with us to draft that letter that wanted to bring the parties together to try to solve this problem, because we all agree that there's need for drug treatment centers, particularly in the Eastern Panhandle. And do you think that this piece of legislation is going to go toward trying to bring parties together, or do you think it's going to further divide?
It will resolve the question of whether or not the property can be used for the purpose intended by the county commission, county council. I can't speak to you know, what its effect will be on the attitudes of everyone. But it will. There would be opportunities for the parties to move forward together after that, after this question is behind them. And like you, I know most, I think, of the members of the Martinsburg Council and the mayor, the county council, county commissioners, and although they have an impasse on this, I think that, and I would be willing to participate in efforts to continue to try to bring them together and to help them get launched with the drug treatment that is so desperately needed in Berkeley County.
You did read the letter from the mayor on behalf of the city of Martinsburg that was left on your table, on your desk earlier today, regarding the opposition to Senate Bill 700. It's on each member's desk.
The letter from Mayor Karras dated February 26th.
Yes, sir.
No, it's from the mayor. Yes, I have it right here.
And so you are aware that both the mayor and the city of Martinsburg is opposed to this piece of legislation. You are aware of that, right?
It's quite evident from reading the letter.
Okay. Thank you. Thank you. Thank you very much.
Further discussion? Recognize the senior senator from the 15th to close.
Thank you, Mr. President. I'm going to go on for a few moments here. First of all, this bill was originated in the your committee of government organization. And what it actually did was, and why we originated it, is we were given, because we parked, I believe it was Senate Bill 253 onto the rule, and put it in the rules. And wanted to give enough time to both the city and the county to be able to come to some resolution on this issue. It was on February the 24th at 2 o'clock in the afternoon when it went on to the government organizations, the website, our agenda for February the 25th. The letter that everybody just received in this chamber look at it closely. It comes to you, or it supposedly came to us on February the 24th, and there's an email that when it came out, and the time that it came out was 3:21 p.m. Make no mistake, the Martinsburg City Council was quite aware that there was an originating bill that was going to be going on the government organizations committee to be taken up. Mr. President, that was the first time there was any correspondence that I personally have seen from the Martinsburg City Council on the letter that the senator from Morgan authored on his stationery and that I signed, and the senator from Jefferson and the senior senator from the 16th signed. Now, on that letter, which is right here, it was offering our ability to facilitate, to the best of our ability, some sort of resolution to what was going on. Make no mistake, my friends, and in this chamber, we don't particularly want to have this discussion here either. It's not necessary. It shouldn't be necessary, let's put it that way. This letter was dated January the 28th. Go back to the letter that was just dispensed out to all of us members. It was February the 24th. It was basically 1 month, just shy of a month. Not only that, on January the 30th, 2 days after the senator from Morgan authored this, in the Martinsburg Journal, the senior senator from the 16th, the headline reads this: Unger offers to hold meeting about recovery center. The only thing he did was sign the letter. That's what I feel about that. It brought more division, and when we were trying to solve a problem. The Berkeley County, no, forgive me. Let me pause. There's another falsehood that's been out here that is delicately danced around by wordsmithing in these documents. And that is the zoning commission for the Martinsburg City Council actually approved it. Approved it. But it had to go from the zoning commission to the city council, where they denied it 4-3. But it was approved. Now, our county council is made up of 5 Republicans. They bought a building for $250,000, $8 a square foot. It's 31,000 square foot that they were going to donate towards this cause. Make no mistake about it, at first, I wasn't too thrilled about what was going on with this. We had one council member whose son had passed away, basically because of drug-related issues, and another one that has it as well. Didn't pass away, though. That child's still alive. But I felt that they were interjecting their personal lives into what was taking place in our county. And I come to find out it wasn't about that. Sure, it had a partial bearing on it, but they seen the opportunity Keep in mind, Procter & Gamble's coming in. We need a drug-free workforce so that we can put people to work. They seen an opportunity to take a building that had been vacant for years and years, and they got it for $8 on the square foot. $8. This carpet here on this floor costs more than the $8 a square foot. Make no mistake about it, this carpet. The bad part about it is in zoned industrial. Anybody wants to see pictures of the building? I've got them. And it's right next to the water treatment plant. There's an empty building across from it. There's very little housing around it. And they were seeding it. The city or the county council wasn't, and let me back up, it's on the outskirts of the city as well. You can't get much further than being out of the city than what this was. It's still got about a mile to go, but it's in one of the least traveled areas. It's not in the downtown area. It's actually relatively close to the hospital. In fact, it's as close to the hospital as what it is to the center of the city of Martinsburg. Our county commission itself, county council, excuse me, commission, has taken many buildings in the city of Martinsburg and renovated them and made them so that they were usable buildings that were otherwise nothing less than an eyesore. This city council, by the way, is also the same city council that hasn't hesitated to take advantage of municipal home rule, add that 1% sales tax to it, and raise $3.6 million, while only reducing the B&O tax right around $300,000. I can give you other kinds of things that's going on here, but I'm digressing away from it. I don't want to do that. I want to stay on topic because the senator from Marshall was right about something. Winners and losers. I've used that over and over and over myself. There's no question about that, Senator. So I'm going to tell you who the winners are and who the losers are on this deal. If we don't pass this legislation out today, and there's no guarantee that the House is going to take it up, the 300 people out of the 17,000 people in the city of Martinsburg that signed the petition saying, I don't want this in my backyard, will be the winners. The lawyers who handle the case, the lawsuit that's out there for something that shouldn't even be in court, are going to be the winners. Now, who's going to be the losers? Well, there's 100,000 people, well, actually about 110,000 people that live in Berkeley County. They're going to be the losers because they want to get in a big contest with people's lives. Now, this information that's been brought out before us today, I'm trying to bring it up here. Since the first of this year, there's been 90 cardiac arrests due to drug overdose in Berkeley County. 90 of them. 24 of them resulted in deaths. The other 66, I believe, were resuscitated with Narcan. 42% of these cardiac arrests came from the city of Martinsburg, even though they only make up 15.5% of the population for Berkeley County. Now, it's been said that the city is in the 16th senatorial district, which is absolutely correct. And the 15th senatorial district horseshoes around that entire city. And the city of Martinsburg is the county seat for Berkeley County. Those of us that don't necessarily live in the city, we still have a vested interest of what goes on in our county as well. We're looking out for the taxpayers, but above all else, the people that are dying out here because, remember, this is the guy that wanted to do drug testing for welfare, and it was said to me over and over and over, including the senior senator from the 16th, that we don't have any treatment facilities in West Virginia. What are we going to do with them when we take them off? I'm here to tell you that we got a county council that didn't come to this chamber, this body, and asking for money to do this. They were developing the resources and the network to be able to do it themselves. And whenever it started falling apart, this is where the name dropping starts to take place. They had a whole group of people along with WVU that was going to act like the United Way, a clearinghouse, set the stage for the state of West Virginia on how to deal with this issue. We had an opportunity here. We still have an opportunity here, Mr. President. I don't like bringing a local issue into this chamber and into the legislature. But you know, sometimes you have to change your mindset just a little bit and follow your gut and know what you're doing is the right thing for the people, regardless of some of the baloney that gets put out on our desk that is nothing less than wordsmithing. And that's what a lot of that has been. Mr. President, when we passed this out of a committee, I made certain, and I think every member of my committee knew it, that I wasn't dictating. The only reason it got originated because I did not want another bill in the pipeline sending a message to the city and the county that they were threatening it. That was not the case. That's why it was originated. I didn't ask not one of my members on either side of the aisle to vote for or against it, and I'm not doing that here today. When I sit down, I will not be saying, Mr. President, I urge passage of this. But I will tell everybody in here right now, I may be the only person that votes for it, but I will be proud that I voted for it because I'm tired of government red tape and the bureaucracy and the infighting between everybody that's involved while people are dying. We need to get our act together in this state. And this is another step in that direction. And I apologize to everybody for taking so long. There was just a lot of the information that needed to come out, and I knew it was going to be a long debate, and thank you for indulging me on getting out the rest of the information on what was taking place with this. And thank you, Mr. President, for allowing me the time to do this as well.
Question for the Senate, shall the bill pass? All those in favor vote yea, those opposed will vote nay. The clerk will prepare the machine. Has every member voted? If so, the clerk close the machine, ascertain the results. On this question, 11 yeas, 23 nays, 0 absent and not voting. Less than a majority of those present and voting having voted the affirmative, I declare the bill rejected.
a recording from the Senate floor session earlier today after this vote on Senate Bill 700 rejecting authorizing Berkeley County Council own or operate a drug treatment or drug rehabilitation facility in Martinsburg. The Senate recessed for a little while. We are out of our allotted time for our legislative coverage today. We will be back tomorrow morning at 11 with more action from the floors of the State Senate and House of Delegates. There will be a lot of bills that will be up for debate and a vote tomorrow on both the Senate and the House floors. This program reminder, the Legislature Today, our nightly broadcast of legislative news and information, airs at 6:30 and 11:30 every weeknight on West Virginia PBS.
Senator from Jackson.
Thank you, Mr. President. I move.
And there they go into recess. The program can also be heard on public radio weeknights at 6:30, and the Legislature Today will be repeated weeknights at 10 and weekday mornings at 6:30 here on the West Virginia Channel. I'm Beth Voorhees for the West Virginia Channel, a service of West Virginia Public Broadcasting.